We are gonna discuss about relevancy of facts. So, let's have an introduction. Law may be broadly categorized under two heads, namely substantive law and procedural law or adjective law. So, procedural law is also called adjective law. The substantive law, whether statute law or common law, defines what facts go to constitute a right or liability. So, the substantive law defines what facts go to constitute a right or liability. Example, the Indian Penal Code of 1860, the Indian Contract Act, the Law of Tort, these are all substantive laws or majorly substantive. Now the adjective law. Adjective law, on the other hand, is one which substantive law is applied to particular cases. So adjective law is the one by which substantive law is applied to particular cases. It is known as the law of procedure. It is concerned with the enforcement of rights, duties, and liabilities determined in accordance with the rules of substantive law. Some example of this is the Code of Civil Procedure 1908, the Code of Criminal Procedure 1973, etc. The present subject, that is the law of evidence, is one of significant branches of procedural law. Now, in India, the law relating to the principles of evidence is governed by the Indian Evidence Act of 1872. It owes its origin from English law of evidence. It came into force from 1st September 1872. So, evidence law came into force in 1st September 1872. It extends to the whole of India except the Jammu and Kashmir and applies to all judicial proceedings in or before any court, including court-martial, other than court-martial convened under the Army Act, Naval Discipline Act, or the Indian Navy Act, such other acts. So, this exception of Jammu and Kashmir is taken away right now. Right now, Indian Evidence Act is also applicable for the state of Jammu and Kashmir. And some of the exclusion that was mentioned is here is the Army Act 44 and 44, 44 and 45, the Naval Discipline Act or Indian Navy Discipline Act, that is of 1934, then the Air Force Act. Now, but not to affidavits presented to any court or officers, nor to the proceedings before an arbitrator. Okay, so it said that Indian Evidence Act is applicable to court-martials too, other than court-martial convened under the Army Act or Naval Discipline Act or Indian Navy Discipline Act or the Air Force Act. For these, for the court-martial, Indian Evidence Act is not applicable. For all other court-martials, Indian Evidence Act is applicable, and it is also not applicable to the affidavits presented to any court or officer, nor to a proceedings before an arbitrator. So, in the proceedings before an arbitrator, we don't use Indian Evidence Act. Now, it shall come into force on the first day of September 1872. We discussed that already, that Indian Evidence Act came into force on first day of September 1872. Now, the fundamental rules or principles of law of evidence. Following are the main principles of evidence. Evidence should be confined to the matter or facts in issue. The second one is hearsay evidence should not be admitted. Hearsay evidence is not evidence. There are some exceptions to this which we will discuss later. That is with dying declaration and all. This is the general rule. That is the main principles of evidence. And the third one is the best evidence rule, or best evidence must be given in all cases. So the main principles of evidence, that is, evidence should be confined to the matters of facts in issue. The second one is hearsay evidence should not be admitted. Hearsay evidence is not evidence. And the third one is best evidence rule, or best evidence must be given in all cases. Now let's see more into evidence should be confined to the matter of facts in issue. According to this rule, evidence can be given only on those facts which might be asserted by one party and denied by the other party. So, evidence can be given only on those facts which might be asserted by one party and denied by the other party. Section 5 of the Indian Evidence Act 1872 provides that the evidence may be given in any suit or proceeding of the existence or non-existence of every fact in issue and of such other fact as hereinafter declared to be relevant and of no other. So what does section 5 say? All the evidence by section 5, evidence can be given in a suit or proceeding only regarding the fact of an existence or non-existence of a fact in issue, about the details or about something that proves or disproves the existence or non-existence of every fact in issue and of other facts which is discussed hereinafter. So that is said in section 5, which says that it should be with either fact in issue or the relevant fact. What are the relevant fact? It is discussed in further sections. For instance, A claims repayment of a debt on the basis of a promissory note executed by B. B denies it. A has a letter in which B admitted that he had written or executed a promissory note. The letter is not sufficient or relevant because the fact in issue is whether B had executed a promissory note but not that letter. Similarly, if X claims to be qualified, he has to show the testimonials relating to his qualification, that is degree certificate, and not the documents pertaining to his properties. Now the second principle is the hearsay evidence should not be admitted. Hearsay evidence signifies the evidence heard and said. It is also known as second hand or unoriginal evidence. So hearsay evidence is also known as second hand or unoriginal evidence. It is learnt by witnesses not through the medium of their senses but through the medium of some third person. It is commonly said that hearsay evidence is no evidence. Evidence given by a witness may be oral or documentary. According to section 60 of the Indian Evidence Act, by section 60 of the Indian Evidence Act 1872, oral evidence to be admissible, it must be direct. In other words, hearsay evidence is no evidence. Example, A is being tried of stealing B's cycle. C as witness says that C heard D saying that D saw A with B's cycle. Such evidence given by C is not admissible on the ground that the testimony of C is hearsay evidence. Hearsay evidence means whatever a person has heard is said. It includes 1. A statement made by a person not called as witness. 2. A statement contained or recorded in any book, document or record which is not admissible. So both of these is hearsay evidence. First one is a statement made by a person not called as witness. Then a statement contained or recorded in any book, document or record which is not admissible. The hearsay witness may not be able to say correctly or completely the truth of his statement. And there is an exception to this, that is the Indian Evidence Act provides for certain exception to this general rule. Hearsay, that is a general rule of hearsay evidence is no evidence. In other words, hearsay evidence is admissible in the following cases. So these are the some of the cases, situations or circumstances where hearsay evidence is admissible. And first one is res gestae, statements forming part of the same transaction. Res gestae is discussed in section 6. So in section 5 we discussed that the evidence should be given with respect to existence or non-existence of fact in issue or related to relevant fact. And in section 6 we discussed about res gestae. What is res gestae? That is statements forming part of the same transaction. So hearsay evidence is admissible in case of res gestae. Now admissions and confessions. Sections 17 to 23 and 24 to 30. Admissions are dealt in section 17 to 23 and confession in 24 to 30. Admissions and confessions, in this case also hearsay evidences are admissible. The third situation is statement by a person who cannot be called as a witness, that is dying declaration. Right now we are discussing about the circumstances where hearsay evidence has evidentiary value. The first one is res justice, discussed under section 6, that is statement forming the part of the same transaction. Then the second one we have admission and confession. Admission is discussed in section 17 to 23 and confession in 24 to 30. And then we have statements of people who cannot be called as a witness. There we are discussing about dying declaration, that is discussed in section 32 subclause 1. Then we have evidence given in the formal proceeding. In a formal proceeding, that is discussed in section 33. So evidence given in formal proceeding is given in section 33. And then we have statements in public documents, that is section 35. Statements in public documents under section 35. Now opinion of experts, that is dealt in sections 45 to 51, that is opinions of experts dealt in section 45 to 51. And entries in books of account, that is in section 34. Entries in book of accounts, that is section 34. So 7 circumstances are discussed where hearsay evidence has evidentiary value and is an exception to the general rule that hearsay evidence is no rule. Once again, first one res justice, section 6. Then we have admissions and confessions. Admissions from dealt in section 17 to 23 and confession section 24 to 30. Then we have statements of people who cannot be called as witness, that is dying declaration, section 32 subclause 1. Then we have evidence given in formal proceeding, that is evidence given in formal proceeding, section 33. Then entries in a book of accounts, that is in section 34. Entries in book of accounts. Then statements of public documents in section 35. Statements in public documents, section 35. Then opinion of experts, that is in section 45 to 51. Section 45 to 51. So the third one is the best evidence rule. It is well established that the best means of evidence must be given to in all cases. This rule is based on the principle that if anybody wants to know about a fact, the best proof is what he perceives through his own sense. This principle is used in connection with documentary evidence to prefer primary evidence to secondary evidence, and in connection with the oral evidence to exclude hearsay evidence. So, the main objective of the Evidence Act is to prevent laxity in the admissibility of evidence and to introduce a more correct and uniform rule of practice that was previously vague. So, the main object of the Evidence Act is twofold, that is to prevent laxity in the admissibility of evidence, and the second one is to introduce a more correct and uniform rule of the practice which was previously in a vague form. In other words, its main object is to help the courts to ascertain the truth and avoid confusion. So, in simple words, you can say the Evidence Act objective is to help the courts to ascertain the truth and to avoid confusion. The rules relating to the law of evidence in the administration of justice are of great importance. No substantive law can be enforced without the help of the rule of the law of evidence. Now, the law of evidence does not affect substantive rights of parties, but only lay down the law for facilitating the course of justice. So, the law of evidence does not affect the substantive rights of the parties. It only lays down the law for facilitating the course of justice. The Evidence Act lays down the rules of evidence for the purposes of guidance of the court. It is procedural law which provides inter alia how a fact is to be proved. So this was discussed in Ramjas versus Surendranath 1980. So in the case of Ramjas versus Surendranath 1980, the court said that the law of evidence does not affect the substantive rights of the parties but only laid down the law for facilitating the course of justice. The Evidence Act lays down rules of evidence for the purpose of guidance of the courts. It is procedural law which provides inter alia how a fact is to be proved. Now, into the history of law of evidence. Earlier, the principles relating to law of evidence were not clear, both under English and Indian legal system. In the early English law, in the early Indian law, we had Hindu law and Muslim law with respect to evidence. In the early English law, ordeals, compurgation, or wager of law and trial by battle were used as modes of proof. Under Hindu system of jurisprudence, sometimes divine tests were used. General principles of Hindu jurisprudence can discuss about this. The modern law of evidence owes its origin from the English common law. Certain areas or parts of the law of evidence may be traced back to the period of the Middle Ages. However, the real beginning for the main outstanding feature of the evidence was made in the 16th and 17th century when juries started deciding cases on the evidence of a witness. For the first time, a book of evidence was written by Chief Baron Gilbert, who died in 1796. So, for 1726. So, the first book of evidence was written by Chief Baron Gilbert, who died in 1726. The book was published posthumously in 1756. In India, principles of evidence were applied by the courts in presidency towns of Madras, Bombay, and Calcutta during the British period. But in the provinces, the courts did not follow the English law of evidence. Okay. In those days, at the time, okay. As the time passed, many reforms were introduced and series of acts were passed by the Indian legislature between 1835 and 1853. For the first time, the need for codification of law of evidence was felt by the reformers. The Third Law Commission, in its fifth report, submitted in 1868. So, the Third Law Commission, in its fifth report, submitted in 1868, placed or presented draft evidence bill. The draft was very short as it contained only 39 capsules. The draft bill was introduced in the Legislative Council and was referred to the Select Committee in 1868. Now, but the bill was not passed on the ground that it was incomplete, ill-arranged and unsuitable. So, what was the ground for which it was not passed? Because it was incomplete, ill-arranged and unsuitable to Indian conditions. Later, another draft prepared by Sir James Stephen was introduced in the council in 1871 and was passed in the year 1872, entitled the Indian Evidence Act 1872. So, the first draft bill was submitted by the Third Law Commission in its fifth report in 1868, but this was not passed on the ground that it was ill-arranged, incomplete and unsuitable to Indian condition. Later, Sir James Stephen prepared a draft and submitted to the council in 1871, and that was passed as the Indian Evidence Act of 1872. Now to the meaning and definition. So the expression evidence is derived from the Latin word evidentia. Evidentia means being clear or plain or apparent clear. The Latin term evidence, evidere, that is the Latin term evidence evidere means to show clearly. So we have evidentia and evidence evidere. Okay. According to Gisborne, evidence means the testimony, whether oral or documentary or a real, which may be legally received in order to prove or disprove some facts in dispute. So it is a testimony. It can be oral, documentary, or a real one, which may be legally received. It shall be legal. It is entitled to be legally received, or it is good enough to be legally received in order to prove or disprove. So it should be something with relating to proving or disproving some fact in the dispute. Fact and dispute is same as fact and issue. So according to Gisborne, evidence means the testimony, whether oral, documentary, or real, which may be legally received in order to prove or disprove some fact in dispute. Now towards the definition, the law of evidence may be defined as a system of rules for ascertaining controverted question of fact in judicial inquiries. So the law of evidence may be defined as a system of rules for ascertaining controverted questions of fact in judicial inquiries. The law of evidence has great importance since it enables the court to decide the existence or non-existence of facts. According to Taylor, evidence means and includes all facts except arguments, which tend to prove or disprove any matter which is under inquiry in judicial proceedings. Under Section 3 of the Indian Evidence Act, evidence is an instrument of proof regarding a fact in issue. It means and include 1. All statements which the court permits or required to be made before it by witness in relation to matter of fact under inquiry. The second one is all documents, including electronic document, produced for the inspection of the court. So, by under Section 3, evidence is an instrument of proof regarding a fact and issue. So, by Section 3, evidence is an instrument of proof regarding a fact and issue, and it means and includes all statements which the court permits or requires to be made before it by witnesses in relation to matter of fact under inquiry, and all the documents including electronic record produced for the inspection of the court. The word evidence as defined in Section 3 of the Evidence Act. The word evidence as defined in Section 3 of the Evidence Act signifies only the instruments by means of which relevant facts are brought before the court. So, the instrument adopted for this purpose is witnesses and documents. So, this was discussed in Govaraya versus Emperor, that the word evidence as defined in Section 3 of the Evidence Act signifies only instruments by means of which relevant facts are brought before the court. The instruments adopted for this purpose is witnesses and documents. Now, regarding the scheme of the Act is divided into three parts as follows. The part 1, that is dealing with our chapter 2, it contains section 5 to 55, which deals with relevancy of fact. So, relevancy of fact is dealt in chapter 2, that is from sections 5 to 55. So, it is to be noted that under this chapter we have admission, confession, then entries to the book, account or opinion of experts all come under this chapter, and this is dealt with respect to relevancy of fact. It indicates fact which may be provided before the court. Now, part 2, that is from chapter 3 to chapter 6. Here it contains sections 56 to 100, which deals with proof of acts. This part contains rules as to what type of evidence or facts mentioned in the first part may be given. So, this part contains rules as to what type of evidence of the facts mentioned in the first part may be given. This part lays down the provisions as to when oral evidence may be given and when the documents are required to be proved by the primary evidence and when they can be proved by secondary evidence. Sections 91 to 100 lay down the provisions relating to when oral evidence will be excluded by documentary evidence. So, the second part we discuss here is chapter 3 to chapter 6, and it is sections 56 to 100. Here we are will be discussing about the provisions to when and how the relevant facts discussed in chapter 2 is to be accepted, and how to choose which fact to be made admissible. And section 91 to 100 in this part 2 also discuss about when oral evidence will be excluded by documentary evidence. Now we have part 3, that is from chapter 7 to chapter 11. So, Indian Evidence Act have a total of 11 chapters, and these 11 chapters are divided into 3 parts. Part 1 is chapter 2 alone, which discuss about the relevancy of fact, that is from section 5 to sections 55. Then the part 2 is dealt in chapter 3 to chapter 6, that is from section 56 to section 100, and then the third part is chapter 7 to chapter 11, that is from section 101 to 167. So the total number of sections in Evidence Act is 167 and 11 chapters divided into 3 parts. So the part 3 deals with the production and effect of evidence. The first part dealt with the relevancy of facts. The second one dealt with how the evidence of how it may be made admissible, and what kind of rule is to be made effective for the facts that is provided under chapter 2. Now the chapter part 3 deals with the effect of these with the production and effect of these evidences. Now section 101 to 114a. Section 101 to 114a deals with the question who should adduce the evidence, that who has the burden of proof. That is from 101 to 114a. Then section 115 to 117 deals with the doctrine of estoppel. So section 115 to 117 deals with the doctrine of estoppel. Chapters 9 and 10, that is sections 118 to 166. Chapter 9 and 10, that is from section 118 to 166, deal with the question of how evidence is to be adduced. They contain rules regarding witness and their examination. And the last chapter contains only one section, that is section 167, which deals with the effect of mistake in admission or rejection of evidence. So part 3 is dealt by sections 101 to 167, whereas sections 101 to 114a deals with the burden of proof. Who should adduce the evidence? Who should adduce the proof? Burden of proof, that is 101 to 114a. Then 115 to 117 discuss about doctrine of estoppel. 115 to 117 discuss about doctrine of estoppel. Then 118 to 166, that is chapter 9 and 10. 118 to 166, it contains question of how evidence is to be adduced. That is the rules regarding the witnesses and their examination. So how evidence is to be adduced, that is rules regarding witnesses and their examination, that is dealt in 118 to 166. And the last chapter, which has only one section, that is 167, discuss about the effect of mistake in admission or rejection of evidence. Now the scheme, that is the scheme of the act. Now let's go to, law of evidence is lex fori. The phrase lex fori means the law of the place of the action. The law of evidence is the lex fori which governs the courts. So lex fori means the law of the place of action. The law of the place of the action, that is lex fori. Law of evidence is the lex fori which governs the courts. Explaining the place of evidence as early as 1850, the House of Lords in Bain versus White Raven and Furnace Junction observed, the law of evidence is the lex fori which governs the courts. Whether a witness is competent or not, whether a certain fact requires to be proved by writing or not, whether a certain evidence proves a fact or not, that is to be determined by the law of the country where the question arises, where the remedy is sought to be enforced, and where the court sits to enforce it. So, what did the House of Lords observe here? Whether a witness is competent or not, whether a certain fact is to be proved by writing or not, whether the evidence proves a fact or not, all this is to be determined by the law of the country where the question arises, or where the remedy is sought to be enforced, and where the court sits to enforce it. So, the law of evidence is lex fori. Now, the law of evidence is lex fori. Matters relating to method of providing an event, that is whether a witness is competent or not, whether a certain matter requires to be proved by writing or not, whether certain evidence prove a certain fact or not, are to be determined by the law of the country where the remedy is sought to be enforced and where the court sits to enforce it. In Niharendu Dutt Majumdar versus Emperor, that is in Niharendu Dutt Majumdar versus Emperor, it was held that where the question was one of the proper methods of proving an event occurred in England, the law applicable was the Indian and not the English law of evidence. So in Niharendu Dutt Majumdar versus Emperor, it was held that where the question was one of the proper methods of providing an event occurred in England, the law applicable was the Indian and not the English law of evidence. Now, application of the principles of evidence in between civil and criminal proceeding. The rules of evidence in general are the same in civil and criminal proceeding. However, there are certain exceptions. For instance, the doctrine of estoppel discussed in section 115 to 117, then the admission that is discussed admissions discussed in section 18 to 20 apply to civil cases only. So in law of evidence we have admissions from section 17 to section 23. Out of those we are discussing about section 18 to 20, that is we did not include section 17, section 21 and 22 and 23 with in case of the civil cases. So the doctrine of estoppel, that is in section 115 to 117, and in with respect to admissions, the sections 18 to 23 shall be applicable only to civil cases, whereas the provisions relating to confession, that is from section 24 to 30, are peculiar to criminal proceeding. So with respect to civil cases, we discussed admissions in section 18 to 20, but please note that in section 17, section 21, 22 and 23 also deals with admission, but that is not included in civil case. Now, exceptions or differences between civil and criminal proceeding. The application of the rules of evidence in civil and criminal proceedings is the same in general. However, the application may be different in certain cases as stated below. And here 4 cases, scenarios are discussed. The first one is, in civil cases, the rules of evidence may be relaxed with the consent of the parties and with the order of the court. In criminal law, the rules cannot be relaxed or changed. The second one, the provisions relating to confession, dying declaration, character and competence of witnesses are more peculiar to criminal law than to civil law. The third one is that in a civil suit, it is the duty of the parties to place their case before the court, but in criminal case, it is the duty of the court to bring all relevant evidence on the record to see the justice is done. And the fourth one, the doctrine of estoppel is applied only to civil proceeding but not to criminal proceeding. Now, need and function of the law of evidence. When a dispute comes before a court of law, it has a fact story behind it. The judge or magistrate will not be in position to give sound or appropriate decision or judgment without the knowledge of true facts involved in a dispute. Generally, allegations made by one party are denied by the other party. The court must be informed of the facts of the case, the process of evidence by examining the witness from both the parties. Then the magistrate or judge has to weigh the evidence available in support of their contradiction to those contentions. The Evidence Act applies to all judicial proceedings and does not apply to proceedings which are not judicial. Now the question is, what constitutes judicial proceeding? The Act does not define the term judicial proceeding. Section 4 subclause M of the Code of Criminal Procedure (CRPC) defines it as a proceeding in the course of which evidence is or may be legally taken on an oath. So section 4 subclause M of CRPC defines judicial proceeding as a proceeding in the course of which evidence is or may be legally taken on oath. However, it does not include the proceedings under the Income Tax Act and proceedings before an arbitrator. The object of every judicial proceeding is the enforcement of some right or liability. So the object of every judicial proceeding is the enforcement of some right or liability. Now, underlying principles of evidence or rules respecting judicial evidence. Underlying principles of evidence or rules respecting judicial evidence. Following are the 2 maxims respecting judicial evidence. One is quid probendum. It means thing to be proved. Quid probendum. Quid, quid probendum, probandum, quid probandum, which means things to be proved. And the second one is modus probendi, modus, modus probendi, probandi, modus probendi, it means mode of proving. So things to be proved and mode of proving, these are the two maxims respecting judicial evidence, quid probandum and modus probendi. Now, classifications or kinds of evidence. Indian Evidence Act 1872 divides evidence into the following kinds, namely direct and indirect or circumstantial evidence. So, indirect evidence is also known as circumstantial evidence. So, direct or indirect evidence is also known as circumstantial evidence, and then real and personal evidence, then original and hearsay evidence, then primary and secondary evidence, then oral and documentary evidence, and judicial and non-judicial evidence. So there is a broadly classified into six categories. The first category is the direct and indirect, second category real and personal, then the third category original and hearsay, fourth category primary and secondary, fifth category oral and documentary, and the sixth one judicial and non-judicial. So let's see what is direct evidence. It is also known as positive evidence. So direct evidence is also known as positive evidence. Evidence given by direct witness or eyewitness is called direct witness. Evidence given by a direct witness or eyewitness is called direct witness. Direct evidence is a testimony of a witness to the existence or non-existence of a fact or fact in issue. Example, A is tried for setting fire to the house. B deposes that he saw A setting fire. B is eyewitness. A sues B for breach of contract. Now the second one is A sues B for breach of contract. C deposes that he was present at the time of agreement entered into between A and B. So here in this example, C is a direct witness. Now indirect or circumstantial evidence. So direct evidence is also known as positive evidence. And now we have the indirect or circumstantial evidence. In case where direct evidence is not available, then circumstantial evidence can be resorted to. So only in case where direct evidence is not available, then circumstantial evidence can be resorted to. Circumstantial evidence is a testimony by witness as to the circumstances from which an inference is to be drawn as to the fact in issue. So here, based on the circumstances, the evidence, the witnesses give only a statement about the circumstances, and from these circumstances an inference is made with respect to the fact in issue. So as those the testimony by the witness is as to the circumstances and not to the offense or the fact in dispute. So in circumstantial evidence, the testimony by the witness is as to the circumstances from which an inference is to be drawn as to the fact in issue. So some relevant cases here is A.C. Lagu, that is Arun Chand Lagu versus Anand Chand Lagu versus State of Bombay. So the first relevant case law here is Anand Chand Lagu versus State of Bombay, that is AIR 1960, Supreme Court 500. Here the accused in the instant case was a family doctor. He was tried for the murder of his patient, a rich woman, and sentenced to death on the basis of the circumstantial evidence. So here the family doctor was alleged to alleged that he murdered his patient, who is a rich lady, and this family doctor was convicted on the basis of circumstantial evidence. Now, Kalua versus State of Uttar Pradesh. Kalua versus State of Uttar Pradesh. That is AIR 1958, Supreme Court 180. Here Kalua was charged with the murder of the deceased by shooting him with a pistol. The circumstantial evidences proved were A. Few days before the killing of the deceased, the accused held out a threat against him. B. A cartridge was found near the cot of the deceased. C. A pistol was recovered from the accused house. D. The firearm expert gave his opinion that the cartridge found near the coat of the dead body was fired from the pistol produced by the accused. It was held that there could be no room for thinking in the circumstances established in this case that anyone else other than the accused might have shot the deceased. He was convicted. So what happened here? Here circumstantial evidences were considered again, and what were the circumstances? So what happened is, like, a person was shot dead and Kalia was alleged to be the murderer. So what are the circumstances? One was that there was a few days back Kalia made a threat against him, and the second one, there was a cartridge found near the cot of the deceased, and then it was a pistol was recovered from the accused house. And now the last one was the firearm expert gave his opinion that the the cartridge that was found near the deceased cot seemed to have been fired from the pistol that was recovered from the accused house. So based on these four circumstances, the court held that there is no doubt or confusion in convicting Kalia, and Kalia was convicted. Based on the circumstantial evidence, there was no direct witness in this case. And the third one is Hardayal versus State of UP. Hardayal versus State of UP. Here, common object not inferred from the mere facts of moving in a body of persons with arms guilty. Okay, there was no eyewitness to the fact of the murder, but the telltale circumstances had made the chain so complete that there was no escape from the conclusion that within all human probability the child was kidnapped, murdered, and thrown into the well by none other than the accused. He used to beat his wife, and therefore she had gone back to her parents. He tried his best and even played false tricks with his father and brother-in-law, but his wife refused to rejoin him. He went back uttering a threat that he would teach them a lesson of their life. He was seen taking away the 10-year-old child of his wife's brother while the child was alone at home. The child remained missing, and when the accused was traced in his village and surrounded by the father of the child and some others, he confessed to have taken away the child and promised to return him, but instead managed to escape. On the village's report, the body of the child was recovered from a well and duly identified socially as well as medically. The Supreme Court sustained that the conviction and death sentence. Where a murder was committed in the evening hours, the Supreme Court observed that when there was light enough to enable the assailants to identify their victims and kill them, it could hardly be said that the light was not enough for the witness to identify the assailant. Now, it relates to a series of other facts than facts in issue. When footprints are found on sand, it is inferred that some animate being has gone that way. Example: a few days before the murder, the accused threatened to the deceased that he would kill him. Now, the second category we have is the real evidence and personal evidence. So, what is real evidence and personal evidence? So, real evidence, it is that which is addressed to the sense of the tribunal for inspection of the court, that is weapons, blood-stained clothes, etc. So, these are produced before the court for the inspection of the court. This is real evidence, that which is addressed to the sense of the tribunal. Now, personal evidence, it reaches the court through human agency. Oral testimony of witness is a good example. So, personal evidence reaches the court through human agency. In real evidence, it is addressed to the sense of the tribunal. For example, weapons, blood-stained clothes, etc. Now, the third category is original evidence and unoriginal or hearsay evidence. So, original evidence. By original evidence is meant the production of the thing proved in its original form. It is that which a witness reports himself to have seen or heard through the media of his own sense. Through the medium of his own senses. That is original evidence. For example, C says that he heard the cry of B as save me, I am being killed by A. So this is what is heard by C, and this is a original evidence. Now another one, X bases his claim on a sale deed. The sale deed is the original evidence. Now unoriginal or hearsay evidence. It is which the witness reports that he himself did not see or hear. He reports what he has learnt respecting the fact through the medium of a third person. Hearsay evidence is no evidence and is not admissible. But there are some exceptions to this, which we discussed earlier, such as the dying declaration 32 sub clause 1, then res gestae, then we have the admission and confession, and then we had the entries of the book, then we had the opinion of the experts, etc., which were exceptions to hearsay evidence. Now, example of unoriginal or hearsay evidence. A is being tried for stealing the cycle of B. C, as a witness, says that he heard D saying that D saw A with B's cycle on road. So, A was trying to steal the cycle of B. So, B is original owner of the cycle and A is trying to steal it. C is a third person who said that, who heard D saying that D saw A with B's cycle on road. In this example, the testimony of C is a hearsay evidence because C did not see A with B cycle, but instead C heard that D said D saw A with B cycle. So the testimony of C is a hearsay evidence. Meanwhile, if D had given the testimony, then that would have been a direct evidence or witness. D would have been a direct witness, but C is a hearsay evidence. Now, the fourth category is primary evidence and secondary evidence. So, primary evidence, it means the document itself is produced for the inspection of the court. So, the document itself is produced in front of the court, that is primary evidence, and this is discussed in section 62. For example, A sold his house to B for rupees 50,000 and executes a registered sale deed. In a dispute as to the title, if B produces before the court the sale deed, it is primary evidence. Primary evidence is considered as the best evidence since it provides proof with certainty. That is why law insists or requires first the primary evidence. The document may be in counterparts, then each counterpart is regarded as primary evidence. If the document is made by uniform process like printing or lithography, each one constitutes the primary evidence. Now, secondary evidence. It is known as inferior or substituted evidence. So, secondary evidence is also known as inferior or substituted evidence. It indicates the existence of more original source of information. Secondary evidence may be given in the absence of a better or primary evidence if proper explanation is given for such absence. Section 65 of the Indian Evidence Act provides for the circumstances in which secondary evidence is admissible. So, primary evidence is discussed in section 62, and section 65 of the Evidence Act provides for the circumstances in which secondary evidence is admissible. According to section 63, copies made and compared with the original or photostat copies may be treated as secondary evidence. That is said in section 63. Following are the circumstances in which secondary evidence is admissible. That is given in section 65. 1. The person in possession of the original is not within the reach of the court. Second, if the original is in the possession of the opposite party. 3. If the original is lost. 4. When the original deed had already been admitted to the court. 5. If the original is a public document. 6. When the original is not easily movable. And 7th, the original consists of many accounts. So, that is with primary and secondary evidence. And then the fifth category is the oral or documentary evidence. Oral evidence and documentary evidence. The oral evidence is also known as payroll evidence. So oral evidence is also known as payroll evidence. It is a fact brought to the knowledge of the court by verbal statement of a witness qualified to speak on the point. All facts contents except the contents of documents or electronic records may be proved by oral evidence. Oral evidence is discussed in section 59. So in section 62 we discuss about primary evidence and secondary evidence admissibility in section 65, and in section 63 we discuss that even some of the photocopies of original document or primary evidence is secondary evidence. And now in oral evidence, that is discussed in section 59, and it is also called payroll evidence. And it also says that all facts except the contents of the document or electronic record may be proved by oral evidence. Now, documentary evidence. The term document under section 3. So, we have the definition of document under section 3 of Evidence Act means any matter expressed or described upon any substance by means of letters, figures or marks, or by more than one of these means intended to be used for the purpose of recording that matter. The expression documentary evidence as it defined in section 3 means all documents produced for the inspection of the court. All documents produced for the inspection of the court, such documents are called documentary evidence. The expression document is defined in section 3 as follows. Document means any matter expressed or described upon any substance by means of letters, figures or marks, or by more than one of these means intended to be used for the purpose of recording that matter. Now we have some illustration, that is a writing is a document. Words printed, lithographed or photographed are document. A map or plan is a document. A caricature is a document, etc. Now the sixth category is judicial evidence and non-judicial evidence. So judicial evidence, it is an evidence received by the court of justice. It is an evidence received by the court of justice in proof or disproof of facts. So it is received by the court of justice in proof or disproof of facts, the existence of which comes in question before them. So judicial evidence, it is an evidence received by the courts of justice in proof or disproof of facts, the existence of which comes in question before them. Non-judicial evidence, evidence given in the proceedings before magistrate or officer, not in a judicial capacity but administrative, is known as non-judicial evidence. So evidence given in the proceedings before magistrate or officer, not in judicial capacity but administrative, is a non-judicial evidence. Example, evidence in proceeding under section 164 of CRPC, that is confession made to a police officer, that is inadmissible and that is a non-judicial evidence. Now, changes brought about by IT Act of 2000. So, new communication systems and digital technology have brought certain revolutionary changes. Business houses and consumers are nowadays using computers to create, transfer and store information in electronic form instead of traditional paper documents. The law of evidence was traditionally based on paper-based records, and oral testimony and records were required to bear signature. Since electronic commerce eliminates need for paper-based transactions and signatures, it became necessary to make changes in law. International trade through the media of e-commerce is growing rapidly, and many countries have switched over to the new system. The United Nations Commissions on International Trade Law, that is UNICITRAL, adopted the model law on electronic commerce in 1996, and the General Assembly in 1997 recommended that in revising and amending their laws, all countries should consider the model law on electronic commerce. In view of the above, to facilitate electronic commerce, the use and acceptance of electronic records and digital signatures was essential, and it required changes in various existing laws. The Information Technology Act sees to attend IPC, Indian Evidence Act, Pangus Book Evidence Act 1891, and RBI Act 1934 with respect to this. So that is with respect to the first section, or the with that we are moving on to the lecture 2, which is about definitions. So here we cover the interpretation clause under section 3. Then we see into court, fact, relevant fact, fact and issue, document, evidence, proved, disproved, not proved, and India. So these are the definitions that we are going to look into. And then what is presumption? So starting with interpretation clause. Interpretation clause, that is in section 3. In this act, the following words and expressions are used in the following senses unless a contrary intention appears from the context. The words and expressions which are used in the sense in which they are defined in the Evidence Act have to be understood only in the sense unless a contrary intention appears from the context. For example, the expression court has to be understood only in the sense in which it is defined in section 3. But the expression court may also mean a tennis court, a badminton court if used in a different context. So the first definition we are going to look into is court. According to section 3 of the Indian Evidence Act 1872, court includes all judges and magistrates and all persons except arbitrator legally authorized to take evidence. So court includes all the persons legally authorized to take evidence, including all judges and magistrates and all other persons who has legally authorization to take the evidence except the arbitrator. So that is what court is, how is court is defined in Evidence Act. Now, etymologically, the word court means king's darbar. It is also understood in the sense of the place where justice is administered, or the person or persons who administer justice. The expression court is defined in the Evidence Act in the latter sense, that is, the person or persons who administer justice. According to the definition given in section 3 of the Act, the court does not mean four walls of the premises where justice is administered, but it means and includes all judges, magistrates, and such other persons who are legally authorized to take evidence. The above definition under section 3 is not exhaustive. The expression court is not confined only to the regular courts. It also includes any person who administers justice and is authorized to take evidence. Example, commissioners appointed under the Code of Civil Procedure 1908 and the Code of CRPC 1973, Code of Criminal Procedure 1973. The next definition is fact. The term fact means an existing thing. But under the Evidence Act, the meaning of the word is not limited to only what is tangible and visible or is in any way the object of sense. So, the meaning of the word is not limited to only what is tangible and visible or is in any way the object of senses. According to section 3 of the Act, fact means and includes anything, state of things or relation of things capable of being perceived by the sense. So it can be anything, state of things or relation of things capable of being perceived by the senses. That is how fact is defined in section 3. We have an illustration, that is that a person heard or saw something. So that is a fact. Now that a person said certain words, that is a fact. Now the second one is any mental condition of which any person is conscious. For example, a person has an intention to commit murder. Now that is a fact. That a man has certain reputation, that is also a fact. So not only a thing, a state of thing or a relation of thing, it also includes any mental condition of which any person is conscious. Now, rights and liabilities in a judicial proceeding emerge or arise out of facts. So section 3 categorizes facts into physical fact and psychological fact. Physical facts, it means and includes anything, state of things or relation of things capable of being perceived by senses. In other words, all facts which are subject to perception by bodily senses are physical facts. They are also known as external facts. So physical facts are also known as external facts, and they are subject which is perception by bodily senses. Then we have psychological facts. They are known as the internal facts. Those facts which cannot be perceived by senses are psychological facts. For example, intention, mens rea, knowledge, good faith, fraud, etc. The next definition we are going to look into is relevant fact. The word relevant has two meanings. In one sense, it means connected, and in another sense, admissible. One fact is said to be relevant to another when the one is connected with the other in any of the ways referred to in the previous in the provisions of the Evidence Act relating to the relevancy of fact, and relevancy of fact is discussed from section 5 to section 55. In other words or simple words, a fact is said to be relevant to another if it is connected therewith under the provisions of Evidence Act. The expression relevancy means connection between one fact and another. According to Stephen, relevancy means connection of events so as to cause and effect. So according to Stephen, relevancy means connection of events as to cause and effect. What is really meant by relevant fact is a fact that has certain degree of probative force. A fact that has a certain degree of probative force. Now, kinds of relevancy. There is logical relevancy and legal relevancy. So logical relevancy. A fact is said to be logically relevant to another when by application of a logic it appears that one fact has a bearing on the other fact. Facts which are logically relevant are not provable. For instance, confession statements made to wife by her husband. Husband said to his wife that he had committed a crime, that is murder, rape or theft. If the wife gives evidence as to the commission of crime by her husband, it is not admitted in evidence under section 122 of Evidence Act. The act does not deal with logical relevancy. The act means Evidence Act, therefore it is said that all facts logically relevant are not provable. However, legally relevant facts are provable. Now, legal relevancy. A fact is said to be legally relevant when it is expressed as relevant under section 5 to 55 of the Evidence Act, which deals with relevancy of facts. Example, A tried for administering poison to B with a motive of inheriting property. Here the motive is relevant under section 8. Similarly, the fact revealed by the postmortem expert that the death is caused by the poison is relevant under section 45 of the Act and deals with legal relevancy. According to section 6 to 55 of the Act, following are relevant facts. So, 1. Facts connected with facts in issue or relevant facts. Now, the second one is 2. Facts to the issue as admission, that is dealt in section 17 to 23, and confession, section 24 to 30. The third one is statement under special circumstances, that is discussed in section 34 to 38. Now, judgments, that is dealt in section 40 and 41. Now, opinions of third person, that is dealt in sections 45 to 51. And finally, the character of parties, that is dealt in section 52 to 55. So, what are the facts that are relevant is discussed from section 6 to section 55. Section 5 defines relevant facts. Now, the kind of facts discussed here is facts connected with facts in issue or relevant fact, then facts to the issue as admissions and confessions, and then statements under special circumstances, then judgments, then opinions of third persons, and the character of parties. Now, facts in issue, that is also defined in section 3, that is an interpretation clause. The expression facts in issue means and include any fact from which either by itself or in connection with other facts the existence, non-existence, nature or extent of any right, liability or disability asserted or denied in any suit or proceeding necessarily follows. So, any fact from which either by itself or in connection with other facts, what does it it has to show the existence or non-existence or nature or extent of any right or liability or disability or asserted or denied, all these which is asserted or denied in a suit or proceeding that necessarily follows. So anything related with these is a fact in issue. Now explanation. Whenever under the provisions of the law for the time being in force relating to civil procedure, any court records an issue of fact, the fact to be asserted or denied in the answer to such issue is a fact in issue. So with respect to civil procedure, if the court requires to answer to an issue of a fact, then that fact is fact in issue. It can be asserted or denied, so that is fact in issue. Illustration. A is accused of murder of B. At his trial, the following fact may be in issue: that A caused B's death, that A intended to cause B's death, that A had received grave and sudden provocation from B, that A at the time of doing the act which caused B's death was by reason of unsoundness of mind incapable of knowing its nature. So such facts are facts in issue. So these facts result in the answer and the judgment of the suit or proceeding. Now, facts in issue in the plain sense means facts which are in issue and form the subject matter of the court's decision. So in simple words, facts which are in issue and form the subject matter of court's decision is fact in issue. Now, the question relating to a fact enabling the court to give decisions are fact in issues. Now, fact in issue are those facts which are alleged by one party and denied by the other party in the pleading in a civil case, or alleged by the prosecution and denied by the accused in a criminal case. Example, A is accused of murdering B. At trial, the following facts may be in issue: that A caused B's death. So this refers to the question whether A has caused the death of B. If the answer is no, A is discharged or acquitted. If the answer is yes, the following questions will arise. That if the answer is yes, then we have to look into that did A intend to cause B's death? If A caused B's death, the next question arises is whether A had intention to cause B's death or not. If the intention, that is mens rea or mental element, is present, it is murder or culpable homicide, and A is awarded serious punishment, that is death or life imprisonment. Otherwise, if the intention of mens rea is absent, it amounts to accident, which is a defense under Section 80 of IPC. If the accident is by negligence, the punishment is up to 2 years of imprisonment or fine or both. That A had received grave and sudden provocation from B. It refers to the question whether B is an instrumental or responsible for such a grave and sudden provocation by A, actuating the cause of death of B. Now, that at the time of committing the act, okay, and further, these are the type of relevant facts with respect to case. Now, in a criminal proceeding, charge contains fact in issue. Fact in issue are alleged by the prosecution and denied by the defense counsel or defendant. According to Section 3 of the Act, facts in issue are asserted by the plaintiff and denied by the defendant. According to Section 3, facts in issue arise out of a legal right or liability or disability of a party to the case. Now, the definition of fact in issue, that is, fact in issue means and includes any fact from which either by itself or in connection with other facts give rise to the existence, non-existence, nature or extent of any right, liability asserted or denied in any suit or proceeding. Recording facts in issue by civil court is also a fact in issue. Answers to the fact in issue are also fact in issue. Now, example, A sues B for default against the promissory note. B denies the execution of promissory note. The questions and also the answers in this example constitute fact issue. The questions will be such as whether B executed promissory note in favor of A, what is the relief that A is entitled to, and the answers may be B executed promissory note in favor of A and B is liable to pay the amount due to A. Now, distinction between fact in issue and relevant fact. So, fact in issue, it is necessary ingredient of a right or liability, whereas relevant fact, it is not a necessary ingredient of a right or liability. Now, fact in issue is called the principal fact or factum probendium. So, fact in issue is called the principal fact or factum probendium. It is called now relevant fact is called evidentiary fact or factum probendi. So fact in issue is principal fact or factum probendium, and relevant fact is evidentiary fact or factum probendi. Now facts in issue are affirmed by one party and denied by the other party, whereas relevant facts are the foundation of inference regarding them. Now, the next definition is about document. The word document in the general parlance is understood to mean any matter written upon a paper in some language such as English, Hindi, Urdu, and so on. Under the Evidence Act, it means any matter expressed and described upon any substance, paper, stone, or anything by means of letters or marks. According to Section 3 of Indian Evidence Act 1872, document means any matter expressed or described on any substance by means of letters, figures, or marks, or by more than one of those means intended to be used or which may be used for the purpose of recording that matter. We have an illustration here. A writing is a document. Words printed, lithographed, or photographed are documents. A map or plan is a document, and an inscription on a metal plate or stone is a document. Now, the word document literally means written papers. According to Section 3, it means and includes matters expressed or described on all material substance by means of letters, figures, or marks. Okay. For example, even a writing on the wall is a document. A number given on fixed tables or trees are a document. So, document means all material substance on which human thoughts are recorded. Thus, we can say that documents means all material substance on which human thoughts are recorded. Documents are maintained proofs while witnesses are animated proofs. So, documents are inanimated proofs while the witnesses are animated proofs. So, the next definition we are going to look into is evidence. Evidence means and include all statements which the court permits or requires to be made before it by witnesses in relation to matter of fact under inquiry. Such statements are called oral evidence. And the second one is that all documents, including electronic records, produced for the inspection of the court, such documents are called documentary evidence. So, oral evidence and documentary evidence. Now, we also discussed different categories of evidence earlier, that is primary and secondary, then oral, documentary. We discussed about 6 categories, real and original and unoriginal. So, those was already discussed in lecture 1. Now, the next definition we are going to look into is proved. So, a fact is said to be proved when, after considering the matters before it, the court either believes it to exist or considers its existence so probable that a prudent man ought, under the circumstance of a particular case, to act upon the supposition that it exists. The word proof means anything which serves the purpose of convincing either immediately or immediately the mind as to the truth or falsehood of a fact or profession. That is called the proof. The expression proof under Section 3 of the Evidence Act means such evidence as would induce a reasonable man to come to a conclusion. Now, disproved. A fact is said to be disproved when, after considering the matters before it, the court either believes that it does not exist or considers it non-existent so probable that a prudent man ought, under the circumstances of the particular case, to act upon the supposition that it does not exist. So, it is after consideration of the matter, the court either believes that it does not exist or consider its non-existence as the most probable as per what a prudent man would understand or suppose. Now, the definition of the expression disproved is converse of the definition of the expression proved. Now, we have not proved. That is, a fact is said to be not proved when it is neither proved nor disproved. So, disproved is when the court is of assumption that such a matter is non-existent, and proved is that when the court comes to a conclusion that such a matter exists. So, When it is neither of it, we have not proved. That is, it is neither proved nor disproved. A fact is said to be not proved when neither its existence nor its non-existence is proved. It also indicates a state of mind in between the two. That is, one cannot say whether a fact is proved or disproved. It negatives both proof and disproof. So let's see the distinction between proved, disproved, and not proved. So proved is a positive term. Now disproved is a negative term. The term not proved is a mean between the terms proved and disproved. There's no positive or negative here. It's a neutral word. Now, when a fact is proved, the court decides or gives judgment in favor of the person who has proved it. When something is disproved, no further question arises as to its proof. And when something is not proved, when a fact is not proved, it implies further evidence either to prove or disprove the fact is necessary. Now, we will discuss about India. India means territory of India, excluding the state of Jammu and Kashmir. Now, this exclusion of state of Jammu and Kashmir has been taken away. So, the expression certifying authority, digital signature, electronic form, etc. are also included with the evidence and is assigned the same meaning as assigned to them as it is defined in the Information Technology Act of 2000. That is certifying authority, digital signature certificate, electronic form, electronic records, information, secure electronic record, secure digital signature, and subscriber. All these shall have the same meaning as the meanings assigned to them as in Information Technology Act of 2000. Now we have presumptions, that is discussed in section 4. Presumptions: may presume, shall presume, and conclusive proof. So what is the difference between these? Now, section 4 of the Indian Evidence Act 1872 provides for 3 types of presumptions, namely may presume, shall presume, and conclusive proof. It runs as follows. May presume: whether it is provided by this act that the court may presume a fact, it may either regard such a fact as proved unless and until it is disproved, or may call for proof of it. So, the court may either regard such a fact as proved unless and until it is disproved, or it may call for proof for it. Now we have shall presume. Whenever it is directed by this act that the court shall presume a fact, it shall regard such fact as proved unless and until it is disproved. So in may presume, we discussed that this fact shall be considered as proved unless and until it is disproved, and the court may call for proof of it in may presume. But the difference in shall presume is that the court shall presume a fact as proved unless until it is disproved, and there is no option such as may call for proof of it in shall presume. Now, conclusive proof. When one fact is declared by this act to be the conclusive proof of another, the court shall, on proof of one fact, regard the other as proved. So, if one fact is proved, the court shall presume that the other fact is also proved, and shall not allow evidence to be given for the purpose of disproving it. So, in conclusive proof, the court shall, on proof of the one fact, regard the other as proved, and shall not allow evidence to be given for the purpose of disproving it. Evidence is a means to arrive at proof. Proof is a process by which truth or falsehood as to a fact is convinced. Proof enables a reasonable man to come to a conclusion. Before analyzing the expression may presume, shall presume, and conclusive proof, it is necessary to explain presumption, from which the above expressions are emerged as follows. So let's consider the expression presumption. So, in the absence of absolute certainty, we resort to presumptions. So, only in the absence of absolute certainty, we resort to presumptions. The word presume means supposed to be. The word presumption means an inference from non-facts. So, presumption means an inference from non-facts. For instance, A find B's scooter in front of a restaurant. Then A may presume that B is in the restaurant. When A entered into the restaurant, he found B. then his presumption is correct or true. Instead of B, if C, who is B's brother, is found, his presumption is incorrect or wrong. Thus, presumption may be true or untrue. In other words, they may be rebuttable, may be challenged, or irrebuttable, cannot be challenged. So, they can be either rebuttable or irrebuttable. So, presumption is an inference which takes place in the absence of absolute certainty as to the truth or falsehood of a fact. In other words, presumption is an inference drawn by the court as to the truth of a particular fact from other known or proved fact. The definition. The term presumption, in its largest and most comprehensive signification, may be defined to be an inference, affirmative or disaffirmative, of the truth or falsehood of a doubtful fact or proposition, drawn by a process of probable reasoning from something proved or taken for granted. So let us split the definition. So we are discussing presumption in the largest and the most comprehensive signification. So how is it defined? It is an inference. What kind of inference? It can be affirmative or deformative of what? Of truth or falsehood of a doubtful fact or proposition. And how is it drawn? It is drawn by a process of probable reasoning from something proved or taken for granted. So, when we split the definition of the presumption, we have the key points such as that it is an inference, then it can be affirmative or deformative, and it is to the existence, to the truth or falsehood of a doubtful fact or a proposition, and it is drawn by a process of probable reasoning, and this reasoning is based on something that is proved or taken for granted. So this is how we can split the definition of presumption. Now, classification of presumption. Presumptions may be classified as follows. That is, presumption of fact or natural presumption or may presume. So first one is presumption of fact or natural presumption or may presume. So this is discussed in sections 86 to 88, then section 90, section 113a and section 114. So once again, section 86 to 88, 90, section 90, section 113a and section 114. The second type is presumption of law or artificial presumption, and that is that can be rebuttable presumption or irrebuttable presumption. So the rebuttal presumption of law, or which is shall presume, that is discussed in section 79, section 85, section 189, section 105, section 111A, section 111B and 114A. So in presumption of law or artificial presumption, we have two kinds, that is rebuttable presumption and irrebuttable presumption. Rebuttable presumption is where we use shall presume, and that is discussed in section 79, 85, 189, 105, 111A, 111B and 114A. And then we have irrebuttable presumption of law or conclusive proof. Irrebuttable presumption of law or conclusive proof, that is discussed with respect to section 41, section 112 and section 113. So irrebuttable presumption of law or conclusive proof is discussed with respect to section 41, section 112 and section 113. So classification of presumption mainly into two, that is presumption of fact, which is also known as natural presumption or may presume. Then we have presumption of law or artificial presumption. Under presumption of law or artificial presumption, we have rebuttable presumption and irrebuttable presumption. With that, now let's look more into may presume or presumption of fact or natural presumption, that is discussed in section 86 to 88, section 90, section 113a and section 114. So section 86 to 88, section 90, section 113a and section 114 lay down the provisions relating to presumption of fact or natural presumption or may presume as stated below. Section 86 deals with the presumption as to the certified copies of foreign judicial records. Section 87 deals with the presumption as to the books, maps and charts. Section 88 deals with the presumption as to telegraphic message. Section 90 deals with the presumption as to documents 30 years old. Section 113 deals with presumption as to abetment of suicide by a married woman. Now, Section 114 deals with court may presume existence of certain facts. Now, the expression may presume refers to discretion of the court as to the existence or non-existence of a fact in issue. For instance, when a person is found in possession of a stolen property, the court may presume him as thief or has received such goods with the knowledge that they are stolen. This is discussed with respect to Section 114, which deals with court may presume existence of certain facts. Now, we will be discussing about shall presume or rebuttable presumption of law. That is discussed in section 79 to 85, section 89, section 105, section 111a, section 113b and section 114a. So, section 79 to 85, section 89, section 105, section 111a, section 113b and section 114a laid down the provisions relating to rebuttable presumption or shall presume, and these are section 79 deals with the presumption as to genuineness of certified copies. Section 80 deals with presumption as to documents produced as record of evidence. Section 81 with presumption as to the gazette, newspaper, private acts of the parliament and other documents. Section 82 deals with presumption as to documents admissible in England without proof of seal or signature. Section 83 deals with presumption as to maps or plans made by authority of the government. Section 84 deals with the presumption as to the collection of law and reports and decisions. Now, Section 85 deals with presumption as to the power of attorney. Section 89 deals with the presumption as to due execution, etc. of the documents not produced. Section 105 deals with burden of proving that the case of the accused comes within exceptions. Section 111a deals with presumption as to certain offences. Section 113b deals with presumption as to dowry death. Now, Section 114a deals with the presumption as to absence of consent in certain prosecutions for rape. And now, according to Section 4 of the Evidence Act, the court has no option or discretionary power in drawing a presumption as to the existence or non-existence of a fact in issue. The court is bound to regard a fact as proved unless an evidence is produced or to disprove it. However, rebuttal presumption of law, which is shall presume, is not conclusive but only rebuttable. Section 79 directs that when a certified copy of a public document is produced, the court shall presume that the certifying officer held the official character when the copy was certified. The court cannot call for evidence to disprove this fact, but the opposite party still has the privilege to disprove that he held the official character. Now, we have a conclusive proof or irrebuttable presumption of law that is discussed in section 41, 112 and 113. So, this is the last portion with respect to presumptions. Now, section 41 deals with relevancy of certain judgment in probate, etc. and the jurisdiction. Now, section 112 deals with the birth during marriage, conclusive proof of legitimacy. As a conclusive proof of legitimacy. Now, section 113 deals with the proof of cessation of territory. According to section 4 of the Evidence Act, when one fact is declared by Evidence Act to be conclusive proof of another, the court on proof of the fact must regard the other having been proved, and the court shall not permit any kind of evidence for the purpose of rebutting or disproving that fact. In other words, when a fact is proved to be conclusive under the Evidence Act, the court must confirm it as conclusive and shall not permit or entertain any evidence for the purpose of disproving that fact. In such words, neither the court has discretion to call for evidence nor the party has the privilege to disprove it. Even if the party seeks to prove it, the court has a duty not to allow the evidence for that purpose. So, that is regarding lecture 2. We discussed about the definitions and presumptions, not the definitions, the interpretation clause and the presumptions. Lecture 3, the relevancy of facts. So, relevancy of facts is discussed from section 5 to section 55. Here we are going to discuss about sections 5 to 16. Now, evidence of only facts in issue and relevant facts. Section 5 of the Indian Evidence Act 1872 says that evidence may be given of facts in issue and relevant facts. It runs as follows. Evidence may be given in any suit or proceeding of the existence or non-existence of every fact in issue and of such other fact as hereinafter declared to be relevant and of no others. Now we have illustrations that A is tried for murder of B by beating him with a club with the intention of causing his death. So at A's trial, the following facts are facts in issue. That is, A is beating B with club, A is causing B's death by such beating, A's intention to cause B's death. Now, a suitor does not bring with him and have in readiness for production at the first hearing of the case of cause of the case a bond on which he relies. So, a suitor who has filed a suit based on a bond he has not brought with him and does not have in readiness for production at the first hearing of the cause of the case the bond on which he relies. This section does not enable him to produce the bond or prove its contents at a subsequent stage of the proceeding otherwise than in accordance with the conditions prescribed in CPC. So we have an explanation to section 5, that is, this section shall not enable any person to give evidence of a fact which he is disentitled to prove by any provisions of the law for the time being in force relating to civil procedure. Now we have doctrine of res gestae, that is discussed under section 6. So the section title is relevancy of facts forming part of same transaction. Relevancy of facts forming part of same transaction, section 6, doctrine of res gestae. Facts which, though not in issue, are so connected with a fact in issue as to form part of the same transaction are relevant whether they occurred at the same time and place or at a different time and place. So the illustrations here A is accused of the murder of B by beating him. Whatever was said or done by A or B or the bystanders at the beating or shortly before or after it is as to form part of the same transaction is a relevant fact. Now another one is A is accused of waging war against government of India by taking part in an armed insurrection in which property is destroyed, troops are attacked and goals are broken open. Now the occurrence of these facts is relevant as forming part of the general transaction, though A may not have been present in all of them. Now A sues B for libel contained in a letter forming part of a correspondence. Letters between the parties relating to the subject out of which the libel arose and forming part of the correspondence in which it is contained are relevant facts, though they do not contain the libel itself. Now the question is whether certain goods ordered from B were delivered to A. The goods were delivered to several intermediate persons successively. Each delivery is a relevant fact. So these are the illustrations under section 6 and we are discussing of doctrine of res gestae. The term same transaction under section 6 has been defined in the Evidence Act. The principle underlying section 6 is the following is a statement of res gestae. Now res gestae, the meaning. The doctrine of res gestae is borrowed from English law and incorporated in section 6 of the Indian Evidence Act 1872. The term res is a Latin word which means thing and the expression res gestae literally means the thing done, a subject matter, a transaction or essential circumstance surrounding the subject. The law of evidence, in the law of evidence, it means things done including words spoken forming part of the same transaction. There is a fact story behind every case before the court of law. The fact story contains certain facts, omission of statements which are not an issue but are capable of throwing some light upon the nature of the transaction, revealing its true quality and character. Such acts, omissions or statements which forms the part of the same transaction in issue are allowed to be proved. Now definition. The doctrine of res gestae may be defined as those circumstances which are automatic and undersigned incidents, that is, which are automatic and undersigned incidents of a particular litigated act and which are admissible when illustrative of such act. Now Halsbury defines res gestae as facts which form part of the res gestae and are consequently provable as facts relevant to the issue, include acts, declarations, and incidents which themselves constitute or accompany and explain the facts or transaction in issue. Now, Section 6 of the Indian Evidence Act deals with the doctrine of res gestae. According to Section 6, facts, though not in issue, are so connected with a fact in issue as to form part of the same transaction are relevant, whether they occurred at the same time and place or at a different time and place. Sometimes fact itself is not a fact in issue, but is connected with fact in issue. Still, it is relevant since it forms a part of the same transaction. It may occur at the same time and place or at different time and place. In simple words, only relevant facts are admissible in evidence. However, there are certain circumstances in which certain facts, though not relevant, are admissible since they form part of the same transaction. Example, A is accused of murdering B by beating. Whatever is said or done by A or B or bystanders at the beating or so shortly before or after the beating forms part of the same transaction and is relevant. In simple words, relevancy of facts which form part of the same transaction denotes res gestae. Now, what is transaction? So, according to Stephen, which is the most accepted definition by courts, according to Stephen, a transaction is a group of facts so connected together as to be referred to by a single legal name, such as crime, contract, wrong, any other subject of inquiry which may be in issue. In the above example, certain words like I will kill you, I will not spare you, oh please do not beat me, he would die, uttered by A, B, or the bystanders are not the facts in issue, but they form part of the same transaction. And here the transaction is the crime of beating and become provable under Section 6 of the Act. While applying the principles of res gestae, the courts are very rigid and cautious since it is very difficult to understand what facts do form and what facts do not form part of the same transaction. And one case law is R versus Foster, 1941. R versus Foster, 1941. The accused in the incident case was charged with manslaughter for killing a person by driving over him. A witness saw the vehicle at a high speed but did not see the accident. On hearing cries of the victim, he reached the spot. The victim died after making statement as to the cause of death. The statement was held admissible. Now the conditions. A statement to be admissible under Section 6. The following conditions are to be satisfied. 4 conditions are laid out. The first one, the statement must be a statement of fact and not of opinion. So a statement must be a statement of fact. Now, the statement must have been made by a participant or witness of the transaction. So the statement must be made by the participant or the witness of that transaction. The third one is the statement made by bystander is admissible if he was present at the scene of the offense. And the fourth one, the statement must explain, elucidate, or characterize the incident in the same manner. So these are the 4 conditions for admissibility of a statement under Section 6. One is that the statement must be of a fact. Then the participant or the witness must have made the statement. And if a bystander is making a statement, that bystander should have been present at the incident. And whatever the statement is made, that statement should explain or elucidate or characterize the incident in the same manner. So these are the 4 conditions to accept a statement, to make a statement admissible under Section 6. That is in doctrine of res gestae. That is, facts though not relevant are closely connected, thus to make it relevant. Now in Hadu Samanta versus State of Orissa, the accused Hadu Samanta was charged of murdering one Bhim Pandey. The deceased gave accused some gold and money for teaching, by which golden treasures from underneath the land can be taken out. As the purpose could not be served, the deceased demanded return of the gold and money. When the deceased went to the accused's residence for collecting gold and money, the accused administered poison to him. The dead body was found lying near a village tank. The body was identified that of Bhim Pandey by his wife. The accused was prosecuted for murdering basing on circumstantial evidences, though there was no direct evidence in the case. So in this particular case, there was no direct evidence, there was only circumstantial evidence. And this circumstantial evidence was given by the prosecution witness number 6, PW6. So PW6 was a person who used to sell fruits from in a fruit cart in various villages. So in this particular day, while he was returning to his village after selling the fruits, he was coming back with his cart. So he got while he came in front of the accused house, there was a cart with unlocked cart there, which was loaded, and there was the bulls were unlocked. So the road was blocked by this cart. So the fruit cart, the PW6 requested the person standing nearby to move the cart so that he can pass by. In this instance, the person who was standing next to the cart in front of accused house said that there was a dead body loaded in the cart and the movement was not so easy. So based on this dialogue, that the person standing next to the cart said to the fruit cart owner that there was a dead body loaded in the cart, and the place where the cart was found and the circumstance were all taken as a circumstantial evidence, and the court could make an inference that the accused was killed at the accused house, and later the body was transported using using this cart to the place where the body was found or somewhere nearby. So based on this circumstantial, they came to the conclusion on the guilt of the accused. So according to section 6, what is admissible is a fact which is connected with the fact in issue as a part of the transaction. So in this example, what the person next to the cart said to the fruit cart owner was not a fact in issue or a relevant fact, but it was so closely connected to the fact in issue that it became admissible and it became a relevant fact. There was no indication in the case that the person who made the statement had actually witnessed murder, or that no substantial time had elapsed between the occurrence and the statement, but still it was made admissible. Now the next case we have here is Rabindranath Murthy Naidu versus State of Bengal, 1996. Rabindranath Murthy Naidu versus State of Bengal, 1996. In this case, the accused Rabindranath Murthy Naidu was tried of stabbing of one Paresh Pramanik. Shortly after stabbing, he escaped. The victim narrated about the incident to the people gathered around him while the knife was still stuck on his back. It was held that the incident itself comes within the scope of being part of res geste and admissible as independent evidence. Now, in another case, Vasu Chandrasekhar Rao versus Ponna Satyanarayana, 2000. Vasu Chandrasekhar Rao versus Ponna Satyanarayana, 2000. In this case, the accused Ponna Satyanarayana was charged with murder of his wife and daughter. The statement of the father of the deceased that the father of the accused told him on telephone that his son had killed the deceased was held not relevant as part of the transaction, as it was not proved whether the statement was made at the time of the incident or immediately after it. However, the accused was convicted on the basis of other evidence. Now, Bedruddin versus State of Maharashtra, 1981. Bedruddin versus State of Maharashtra, 1981. The accused in the instant case quarrelled with the deceased. The accused dragged the deceased from his house to Chowk area and began to beat the deceased. One villager who witnessed the incident of beating rushed to the police patel and reported the court that they received information from villagers as to the incidents of beating the deceased. The statement of police patel was held relevant and admissible. Now, res geste and hearsay evidence. One of the fundamental principles of law of evidence is hearsay evidence must not be admitted. It is said that hearsay evidence is no evidence. However, if the hearsay evidence can be admitted in evidence provided it forms part of the same accident or transaction. In other words, the doctrine of res geste is an exemption to the rule of hearsay evidence is no evidence. Now, next we have motive, preparation and previous or subsequent conduct, that is discussed in section 8. Motive, preparation and previous or subsequent conduct, section 8. Section 8 of the Indian Evidence Act 1872 lays down provisions relating to the relevancy of three principal facts which are very important in connection with every kind of civil and criminal cases. That is one, motive; second, preparation; and conduct. Third one is conduct. Section 8 runs as follows. Any fact is relevant which shows or constitutes a motive or preparation for any fact in issue or relevant fact. Further, the conduct of any party or of any agent to any party to any suit or proceeding in reference to such suit or proceeding or in reference to any fact and issue therein or relevant thereto, and the conduct of any person and offense against whom is the subject of any proceeding is relevant if such conduct influences or is influenced by any fact and issue or relevant fact, and whether it was previous or subsequent thereto. Now, explanation 1. The word conduct in this section does not include statements unless those statements accompany and explain acts other than statements. But this explanation is not to affect the relevancy of statements under any other section of this act. Now, explanation 2. When the conduct of any person is relevant, any statement made to him or in his presence and hearing which affects such conduct is relevant. Now we have few illustrations here. 1. A is tried for the murder of B. The fact that A murdered C, that B knew that A had murdered C, and that B had tried to extort money from A by threatening him to make his knowledge public are relevant. Another one. A sues B upon a bond for payment of money. B denies the making of the bond. The fact that at the time when the bond was alleged to be made, B required money for a particular purpose is relevant. Now C, that is A tried for murder of B by poison. The fact that before the death of B, A procured poison similar to that which was administered to B is relevant. Another illustration. The question is whether a certain document is the will of A. The facts that not long before the date of the alleged will, A made inquiry into matters to which the provision of the alleged will relate, that he consulted vakils in reference to making the will, and that he caused drafts of other wills to be prepared of which he did not approve are relevant. Another illustration. A is accused of a crime. The facts that either before or at the time of or after the alleged crime, A provided evidence which would tend to give to the fact of the case an appearance favorable to himself, or that he destroyed or concealed evidence, or prevented the presence or procured the absence of persons who might have been witnesses, or suborned persons to give false evidence respecting it are relevant. Another one. The question is whether A robbed B. The fact that after B was robbed, C said in A's presence. Whether A robbed B is the question. The fact that after B was robbed, C said in A's presence, the police are coming to look for the man who robbed B, and that immediately afterwards A ran away are relevant. Now another illustration. The question is whether A owes B rupees 10,000. The fact that A asked C to lend him money and that D said to C in A's presence and hearing, I advise you not to trust A, for he owes B 10,000 rupees, and that A went away without making any answer are relevant fact. Okay. And the next illustration is the question is whether A committed a crime. The fact that A absconded after receiving a letter warning him that inquiry was being made for the criminal and the contents of the letter are relevant. Now another illustration. A is accused of a crime. The facts that after the commission of the alleged crime he absconded or was in possession of property or the proceeds of property acquired by the crimes, or attempted to conceal things which were or might have been used in the committing of the crime are relevant. The question is whether, now another illustration, the question is whether A was ravished. The facts that shortly after the alleged rape, she made a complaint relating to the crime, the circumstances under which and the terms in which the complaint was made are relevant. The fact that without making a complaint, said that she had been ravished is not relevant as a conduct under this section, though it may be relevant as a dying declaration under section 32 subclause 1 or a corroborative evidence under section 157. Now another illustration. Uh, the question is whether A was robbed. The fact that soon after the alleged robbery, he made a complaint relating to the offense, the circumstance under which and the terms in which the complaint was made are relevant. The fact that he said he had been robbed without making any complaint is not relevant as conduct under this section, though it may be relevant as a dying declaration under section 32 subclause 1 or as a corroborative evidence under section 157. Now, motive. The word motive means the reason behind the act or conduct or an act to be achieved in doing an act. Now, Salmon describes motive as the ulterior intent. It may be good or bad. Motive is the moving power which impels one to do an act. In other words, motive is that which moves a man to do a particular act. It is an emotion or state of mind which leads a man to do an act. Motive by itself is no crime, however heinous it may be. But once a crime has been committed, the evidence of motive becomes important. Therefore, evidence of the existence of a motive for the crime charged is admissible. Motive differs from intention. Intention refers to the immediate consequence, whereas motive refers to the ultimate purpose with which an act is done. An act may be done with bad intention but good motive. Example, a thief steals money and helps the poor. To establish liability, whether civil or criminal, motive is generally irrelevant, but an inquiry into motive is often great importance, particularly in case of circumstantial evidence. It helps in estimating probabilities and thus fixing the crime upon the proper person in some cases. It is strongly instrumental in determining the degree of offense. It may also be an important factor in evidencing the state of mind which is material for establishing a particular offense. Proof of motive. Motive cannot always be shown directly. It has to be inferred from the facts and circumstances in evidence. Example, A is tried of murder of B. The fact that B was present at the scene of the offense while A was murdering C, B tried to extort money from A, then by threatening him to reveal in the public that A murdered C are all relevant. Similarly, A sues B upon a bond for repayment of money. B denies the execution of the bond. The fact that at the time when the bond is alleged to have been made, B required money for a particular purpose is relevant to show his motive. Now, importance of evidence of motive. Motive is a relevant factor in all criminal cases, whether based on the testimony of eyewitnesses or circumstantial evidence. Motive alone is not sufficient evidence to establish that the crime in question has been committed by a particular person. Where a crime is to be proved beyond reasonable doubt, it is not necessary to consider the evidence of motive. Inadequacy of motive does not affect the cogent evidence but is important whether evidence is doubtful. Now, this was said in Matadin versus Emperor 1931. Matadin versus Emperor. Now in Sukhram versus State of MP 1992. Sukhram versus State of MP 1992. It was laid down in this case that the absence of motive may not be relevant where there is a overwhelming evidence against the accused, but it is a plus point where the evidence against him is only circumstantial. It is therefore not proper to consider the evidence of motive before examining the evidence as to the commission of crime. Now, preparation. Section 8, Para 1 of the Indian Evidence Act says, any fact is relevant which shows or constitutes a motive or preparation for any fact in issue or relevant fact. Preparation consists in arranging the means necessary for the commission of a crime. Every crime is necessarily preceded by preparation. For the commission of any crime, preparation must be there. Now, A tried for an example, A tried for the murder of B by poison. The fact that before the death of B, A procured poison similar to that which was administered to B is relevant. The fact that a day prior to the murder of B, A went to the druggist shop and obtained a particular poison is relevant to show that he made necessary preparation for committing the crime. Now, there are four stages in commission of a crime or an offense, that is intention, preparation, attempt and accomplishment or completed act. The first one, intention, is not punishable. The second stage in commission of a crime is preparation, which is punishable in certain cases. The third stage, attempt, is exempted from criminal liability in rare cases only in respect of minor offences. Preparation consists of in devising or arranging means necessary for commission of an offence. In Mohanlal versus Emperor 1937, that is Mohanlal versus Emperor 1937. In this case, the accused was charged with cheating for importing goods without paying proper customs duty by deceiving customs authorities. The evidence of his previous visit to the port trying to make certain arrangements whereby he could import goods without paying duty was held admissible under this section. The preparation on the part of the accused may be to accomplish the crime, to prevent discovery of crime, or it may be to aid the escape of the criminal and avert suspicion. All this comes under preparation. So that is for the accomplishment of the crime, or to prevent discovery of the crime, or to aid the escape of the criminal and to avoid the suspicion. All this comes under preparation. Now the third one is conduct. In the second paragraph of section 8 deals with the relevancy of conduct. It says, the conduct of any party or of any agent of any party to any suit or proceeding, in reference to such suit or proceeding, or in reference to any fact in issue therein or relevant fact thereto, and the conduct of any person, an offence against whom is subject of any proceeding is relevant if such conduct influences or is influenced by any fact in issue or relevant fact, and whether it was previous or subsequent thereto. So, conduct is different from character. Conduct is what a person is in the estimation of others. Now, paragraph 2 of section 8 deals with the relevancy of conduct in the following persons, that is, parties to the suit and their agents. Now, persons, an offence against whom is the subject to the proceeding. So this is the two kind of parties that is discussed in with respect to conduct under section 8, that is paragraph 2 of section 8. Now, against whom admissible? The conduct of any person, if relevant under section 8, is admissible only against himself and not against any other person. The conduct of an accused is not therefore admissible against a co-accused. Now, conditions for admissibility. The conduct is admissible only if the following conditions are satisfied. The first one is, it must be in reference to the suit or proceeding, or in reference to any fact in issue therein or relevant thereto. And the second one is, it must directly influence or be influenced by any fact in issue or relevant fact. The conduct remains inadmissible if any one of the above two conditions is not satisfied. Now, statement accompanying or explaining conduct. Evidence can be given of a statement which either accompanies some conduct or explains acts other than statements. So, we have Queen Empress versus Abdullah 1885. Queen Empress versus Abdullah 1885. In this case, the accused Abdullah was charged with the murder of one Dulari, a prostitute, by cutting her throat with a razor. She was taken to the police station and thereafter dispensary. She was questioned by her mother, Kotwal, deputy magistrate and surgeon, etc. about the incident. She was unable to speak and therefore she answered by way of signs and gestures. Example, when the deputy magistrate asked her who wounded her, she closed her lips. Then he mentioned great many names until the name of Abdullah was mentioned, when she nodded her head. He asked how she had seen the razor. She pointed to her throat and showed the wound on the fingers of her hand. He then asked whether a lamp was burning. She made a sign with her hand that there was no lamp. He asked how she could see if there had been no light. She pointed out and looked at the sky to indicate that it was morning. The evidence of these signs was sought to be admitted under section 8 as conduct and section 32 as dying declaration. As to the admissibility under this section, the court held that they were not directly or immediately influenced by the fact in issue, that is cutting off a throat by razor, or any relevant fact as the result only from one intermediate cause, that is questions, nor they influence the fact in issue or relevant fact. They were therefore held inadmissible under section 8. If the above two conditions are satisfied, the conduct will be relevant whether it was previous or subsequent. Now, previous conduct, the fact that 2 months before his death, the deceased had lodged complaint with the police expressing apprehension of death or injury, would be relevant as previous conduct of the deceased, such conduct being influenced by his fear of injury. Now, Habib Mohammed versus State of Hyderabad, 1954. Habib Mohammed versus State of Hyderabad. The allegation against the appellant was that he was acting in pursuance of a policy of Ittihad ul Musalman and that he wanted to exterminate Hindus. It was held by the Supreme Court that he was entitled to lead evidence to show that his behavior towards Hindu throughout his official career has been very good and could not possibly think of exterminating them. Now, subsequent conduct. The conduct of an accused soon after an incident plays an important role in determining the guilt of the accused and in ascertaining his state of mind. When a person is accused of a crime, the fact that after the alleged crime he destroyed or concealed evidence or prevented the presence of presence of the witnesses, procured the absence of persons who might have been witnesses, or suborned persons to give false evidence is relevant. Where murder and robbery have been shown to be the parts of the same transaction, recent and unexplained possession of stolen property would be presumptive evidence against a person on the charge of robbery as well as murder. Disappearance of the accused after the occurrence is a conduct which in the absence of any plausible explanation might be taken into account against him. To be an absconder under section 8, it is not necessary that he should run away from his house. It is sufficient even if he hides himself in his own house to evade the process of law. Now, Bal Mukund Ram versus Ghanshyam Ram, 1895. Bal Mukund Ram versus Ghanshyam Ram, 1895. In this case, the landlord of a house was found in the midnight in a room of his tenant in which the tenant and his wife were sleeping. Upon being detected, and accused was subjected to severe treatment but did not utter a word of protection of innocence nor made any show of remorse. In his trial under section 45 of IPC, it was held that judging from the time, place and conduct of the accused, it was possible to suppose that the trespass was not with innocent intention. Now, identification parade, that is discussed in section 9, that is facts necessary to explain or introduce relevant fact. Facts necessary to explain or introduce relevant facts, that is also known as identification parade, section 9. Section 9 of the Evidence Act 1872 provides for facts necessary to explain or introduce relevant fact. It runs as follows. Facts necessary to explain or introduce a fact in issue or relevant fact, or which support or rebut an inference suggested by a fact in issue or relevant fact, or which establish the identity of any thing or person whose identity is relevant, or fix the time and place at which any fact in issue or relevant fact happened, or which show the relation of parties by whom any such fact was transacted, are relevant insofar as they are necessary for that purpose. So, it can be a fact to explain or introduce a fact in issue or relevant fact. And the other one is, it can be something that is used to support or rebut an inference from a fact in issue or relevant fact. Then another one is, it may be to establish the identity of a thing or a person which is related to a fact in issue or relevant fact. Now, another criteria is, it may be for to fix the time or place at which the fact in issue or relevant fact happened. Now, last one we discuss here is, which shows the relation of parties by whom any such fact was transacted. So, if a fact is related to either of this, shows either of this, then that is brought under section 9 as facts necessary to explain or introduce relevant fact and thus relevant itself, also known as the identification. Identification period comes under this. Now we have few illustration here. A. The question is whether a given document is the will of A. The state of A's property and of his family and the date of the alleged will may be relevant facts. The another one, A sues B for libel imputing disgraceful conduct to A. B affirms that the matter alleged to be libelous is true. The position and relation of the parties at the time when the libel was published may be relevant facts as introductory to the fact in issue. The particulars of a dispute between A and B about a matter unconnected with the alleged libel are irrelevant, though the fact that there was a dispute may be relevant if it affected the relation between A and B. Now another illustration, A is accused of a crime. The fact that soon after the commission of the crime, A absconded from his house is relevant under section 8 as context subsequent and to the affected by fact in issue. The fact that at the time when he left home, he had sudden and urgent business at the place to which he went is relevant as tending to explain the fact that he left home suddenly. So that is admissible under section 9. The details of the business on which he left are not relevant except in so far as they are necessary to show that the business was sudden and urgent. And another illustration, A sues B for inducing C to break a contract of service made by him with C. So A sues B for inducing C to break a contract made by A with made between A and C. Now C, on leaving A's service, says to A, I am leaving you because B has made me a better offer. This statement is relevant fact as explanatory to C's conduct, which is relevant as fact in issue. Now another illustration, A is accused of theft, is seen to give the stolen property to B, who is seen to give it to A's wife. Now B says that he delivers it. A says, you are to hide this. B's statement is relevant as explanatory of fact which is part of the transaction. Now another illustration, A is tried for a riot and is proved to have marched at the head of a mob. The cries of the mob are relevant as explanatory of nature and transaction. Now section 9 provides for the identification period of persons. The purpose of identification test is to test the memory and veracity of a witness who claims to identify an accused person who is said to have participated in a crime. Section 7 and 8 of the Evidence Act deals with the facts which have some causal relation with the facts in issue or relevant facts. So section 7 and 8 of the Evidence Act deals with facts which have some causal relationship with the facts in issue or relevant fact, whereas section 9 of the Act deals with the facts which are not so connected but are necessary to introduce or explain the facts in issue or relevant facts. Identification is an important process in the administration of justice. When the court has to know the identity of any thing or any person, any fact which establishes such identity is relevant. The identity of a person can be established by the evidence of persons who know him. Identification parade are held for the purpose of identifying the properties which are subject matter of an offence or persons concerned in an offence. During the course of investigation, test identification parades are arranged by police either in jail or at some other place. Certain persons are brought to such a place and the accused person is mixed with them. In case of property, the property record is mixed with some other articles or properties of similar description. Then the magistrate or the punch witnesses will ask the witness to identify the accused person or the property in question. The evidence given by such witness is relevant under section 9. Then we have conspiracy under section 10. So, things said or done by conspirator in reference to common design is discussed as conspiracy under section 10. Section 10 of the Evidence Act 1872 says that things said or done by conspirator in reference to common design. It runs as follows. where there is a reasonable ground to believe that two or more persons have conspired together to commit an offense or an actionable wrong. Anything said, done, or written by any one of such persons in reference to their common intention after the time when such intention was first entertained by any one of them is relevant fact as against each of the persons believed to be so conspiring, as well for the purpose of proving the existence of the conspiracy as for the purpose of showing that any such person was a party to it. So we have an illustration. Here, reasonable ground exists for believing that A has joined in a conspiracy to wage war against the government of India. The fact that B procured arms in Europe for the purpose of the conspiracy, C collected money in Calcutta for a like object, D persuaded persons to join the conspiracy in Bombay, E published writings and advocating the objects in view at Agra, and F transmitted from Delhi to G at Kabul the money which C had collected at Calcutta and the contents of a letter written by H giving an account of the conspiracy or each relevant both to prove the existence of the conspiracy and to prove A's complicity in it, although he may have been ignorant of all of them, and all the persons by whom they were done were strangers to him, and although they may have taken place before he joined the conspiracy or after he left it. So, conspiracy meaning and definition. Etymologically, the word conspiracy means breathing together. When two or more persons agree to commit a crime, they are said to have conspired. In other words, conspiracy is an agreement of two or more persons to do an illegal act or legal act by illegal means. Such persons are said to be conspirators. Section 120A of the Indian Penal Code 1860 defines criminal conspiracy, and Section 120B prescribes punishment for the same. Section 120A defines criminal conspiracy as follows: when two or more persons agree to do or cause to be done an illegal act or an act which is not illegal by illegal means, such an agreement is designated as criminal conspiracy, provided that no agreement except an agreement to commit an offense shall amount to a criminal conspiracy unless some act besides the agreement is done by one or more parties to such agreement in pursuance thereof. Explanation: it is immaterial whether the illegal act is ultimate object of such agreement or is merely incidental to the object. So, ingredients or essentials of conspiracy. To constitute criminal conspiracy, the following ingredients are to be satisfied. 1. There must be an agreement between the parties who are alleged to conspire. 2. The agreement should be for doing an illegal act or for doing a legal act by illegal means. Now, in simple words, to constitute criminal conspiracy, there should be an agreement between two or more persons. The agreement must be for doing an illegal act or a lawful act by illegal means, and there must exist an act over it. Now, conditions for application of Section 10. For the purpose of Section 10 of the Evidence Act, the following conditions are to be satisfied. First one, reasonable grounds to believe the existence of conspiracy. Second one, act or statement of the conspirator. Then third one is a common intention, and the fourth one, the act or statement must be in reference to common intention. The first one, there should be reasonable grounds to believe that there is a conspiracy, and second one, there should be an act or statement, and third one, there must be a common intention, and the fourth one, the act or statement thus made must be in reference to the common intention. So these are the four conditions to make Section 10 applicable. Now, reasonable grounds to believe the existence of conspiracy. Before the application of Section 10, it must establish by independent evidence that there is a reasonable ground to believe that two or more persons conspire to commit an offense or an actionable wrong. In other words, there must be a prima facie evidence in support of the existence of conspiracy between two or more persons. The second one is act or statement of conspirator. This section allows evidence to be given of anything said, done, or written by any one of the conspirators. The third one is common intention. Intention means the desire of doing an act. If two or more persons desires of doing an act by prior meeting or pre-arranged plan, it is called common intention. For the application of section 10, there must be common intention before the act or statement by the conspirator. Now the fourth one is act or statement must be in reference to common intention. The expression in reference to common intention or in furtherance of common intention means action of helping forward. The offense is committed in accordance with the common intention, in other words, putting the common intention in operation. However, the expression in reference to their common intention used in section 10 of the Evidence Act is very comprehensive. Now, Bhagwan Swarup versus State of Maharashtra 1965. Bhagwan Swarup versus State of Maharashtra 1965. In this case, the Supreme Court pointed out that the expression in reference to common intention has a wider scope than the expression in furtherance of common intention. So, section 10 uses in reference to common intention, whereas in English law we have in furtherance of common intention. So, as in section 10 we use in reference of to common intention, this has a wider scope. So this was said that in reference to common intention has a wider scope than the expression in furtherance of common intention used in English law. This was discussed in Bhagwan Swarup versus State of Maharashtra 1965. Now, restriction as to the use of evidence. The evidence of anything said, done, or written by one conspirator against the other conspirator may be used subject to the following restrictions. So, we have few restrictions too. The first one, the evidence is capable of being used only for two purposes, namely to prove the existence of conspiracy and to prove that a particular person was a party to conspiracy. So, such statement can be used only to prove the existence of the conspiracy and that a particular person was party to the conspiracy. And the second restriction is that the death of the conspirator does not affect the act or statement. So the second one is the death of the conspirator does not affect the act or statement. The third one is the evidence of anything said, done, or written by one conspirator cannot be rendered inadmissible merely because of the fact that the person who made the statement had done the act is dead. So, evidence of anything said, done, or written by one conspirator cannot be rendered inadmissible merely because of the fact that the person who made the statement or had done the act is dead. Now, the fourth restriction is that acts and statements of one conspirator cannot be utilized in favor of another conspirator. The fourth restriction is the acts and statements of one conspirator cannot be utilized in favor of the another conspirator. So, that is with section 10, conspiracy. Next we have alibi. Alibi comes under the head facts otherwise relevant becomes relevant. That is in section 11. So facts otherwise relevant becomes relevant as explained in section 11. Facts otherwise not relevant becomes relevant. Section 11, alibi. So meaning, alibi is a Latin word which means elsewhere. The accused very often takes the plea that he was not present at the place where the offense was committed. In other words, alibi is a defense under which a person accused for an offense alleges that he was so far away from the place of the commission of the offense that he could not be guilty. Example: A is accused of B's murder on a particular day at Bombay. On that day, A was at Delhi. Is relevant to prove alibi. That is, A has to prove that it would be impossible for him to commit murder at Bombay as he was in Delhi on the occurrence of the offense. The plea of alibi must be proved with absolute certainty so as to exclude presence of the accused from the scene of the offense. In Bhuboni Sahu versus the King, 1949, Bhuboni Sahu versus the King, the Privy Council held that alibi evidence, though disinterested and impartial witnesses, has a greater evidentiary value. But in certain cases, the accused may not be able to produce such evidence. For instances, if the accused was sleeping at home at the time of crime, he can't produce alibi evidence through his family members. In such cases, it is not possible for him to prove the alibi through disinterested and impartial witnesses. Now, in the second one, we have absence or non-access. Absence or non-access. Where legitimacy of a child is in question, the absence or non-access of the husband is a relevant fact because legitimacy of the offspring implies a begetting by the husband. So this we will be discussing also with respect to section 112. Now another one is survival of alleged deceased. Whether A is alleged to have killed B on a particular date, the fact that after the date B was seen alive is relevant fact as being inconsistent with this being killed on that day. So this is also discussed in section 107 and 108 of Evidence Act. The next one we have is commission of an offence by a third person. Where A is charged with a crime committed by himself alone, any evidence which includes that B might have committed the crime may be received. Threats by a third person or motive of such third person are generally offered to prove that he and not the accused have committed the alleged crime. And then we have self-infliction of harm alleged. Where A is charged with murder of B, if it is proved that B has committed suicide, A cannot be convicted for murder of B. Where a lover was charged with murder of a woman whose body was found in a river, the fact that during the week before her death she had actually attempted to drown herself and had been prevented from doing so was held to be relevant to show that she might have made a second attempt. So under alibi, we saw that it is necessary to prove beyond with absolute certainty. The plea of alibi must be proved with absolute certainty. And then we discussed about absence or non-access of husband in Bhubani Sahu versus the King. We saw that if a person is sleeping at home, his family members cannot give evidence of alibi, being disinterested as an impartial witness. The family members cannot do that. Then we discuss about survival of alleged deceased, commission of an offence by a third person, and self-incrimination or harm alleged. That is with alibi or facts otherwise not relevant becomes relevant. That is discussed in section 11. Now right or custom. So facts relevant when right or custom is in question. That is discussed in section 13. Facts relevant when right or custom is in question. Section 13 of the Indian Evidence Act 1872 speaks about facts relevant when right or custom is in question. It runs as follows. Where the question is as to the existence of any right or custom, the following facts are relevant. A. Any transaction by which the right or custom in question was created, claimed, modified, recognized, asserted or denied, or which was inconsistent with its existence. So any transaction by which the right or custom in question was created, claimed, modified, recognized, asserted or denied, or which was inconsistent with its existence. The second one is particular instances in which the right or custom was claimed, recognized or exercised, or which it or in which its exercise was disputed, asserted or departed from. So these are the two facts considered relevant under this section. Now we have an illustration. The question is whether A has the right to fishery. A deed conferring the fishery on A's ancestor, a mortgage of the fishery by A's father, a subsequent grant of fishery by A's father, reconcilable with the mortgage, then particular instances in which A's father exercised the right or in which the exercise of the right was stopped by A's neighbor are relevant facts. Now right. The word right literally means an interest recognized and protected. So The word right literally means an interest recognized and protected. If it is protected by the administration of justice, it is called legal right. Section 13 is concerned with legal rights only. So, a right is an interest recognized and protected. And if this right is protected by the administration of justice, it is a legal right. And section 13 is concerned only with legal right. The word right as used under section 13 of the Evidence Act means only public and incorporeal rights such as right to ferries, right to roads, right to fisheries, etc. The right of private ownership of a house or chattel is not covered under section 13. However, the High Court of Bombay, Madras and Allahabad took a different view on this point. Custom, meaning and definition. The term custom means acharya or usage or traditionally followed long practice by the members of a society. Manu recognized custom to be a transcendent law. Custom is a good source to interpret law in the administration of justice. A custom is a particular rule which has existed from time immemorial and has obtained the force of law in a particular locality. The custom is nothing but a long-standing usage. Section 3, subclause D of the Hindu Succession Act 1956 defines custom as follows. The expression custom and usage signify any rule which, having been continuously and uniformly observed for a long time, have obtained the force of law among Hindus in any local area, tribe, community or group of families. So this is the definition given for custom in Hindu Succession Act 1956, section 3, subclause D. Provided that rule is certain and not unreasonable and opposed to public policy. So the restriction here is that the rule has to be certain, not ambiguous, and not unreasonable, and is not opposed to public policy. And provided further that in the case of a rule applicable only to a family, it has not been discontinued by the family. So these are the restrictions put on custom as in Hindu Succession Act 1956. Now, requisites or essentials of a valid custom. So how can a custom be a valid custom? So we have 6 requisites here. The first one, custom must be ancient, that is antiquity. 2, it must be continuous. Third, it must be reasonable. The fourth one, it must be moral, equitable and in accordance with the public policy. The fifth one, it must not be contrary to justice, equity and public policy. It must not be contrary to justice, equity and public policy. The sixth one, it must not be contrary to statutory law. So these are the 6 requisites mentioned under a valid custom, that it must be ancient or antiquity, it must be continuous, it must be reasonable, it must be moral, equitable and in accordance with public policy, it must not be contrary to justice, equity and public policy, and it must not be contrary to statutory law. So custom must be ancient. It is necessary that it should be ancient. It must be from time immemorial. Custom must be continuous. A custom to be valid must be continuous without any break or interruption for a long time. Custom must be reasonable. A custom must be good and reasonable. Unreasonable customs are void. Now, custom must not be immoral. Custom must be moral. If it is immoral, it is not treated as law. Now, it must not be contrary to justice, equity and public policy. A custom to be valid must not be contrary to justice, equity and public policy. Custom must not be contrary to statutory law. The last ingredient of the custom is that it should not be contrary to justice, equity and public policy along with any statutory law. Now, proof of custom. Section 13 makes the instance and transactions relevant to prove and disprove custom. It has nothing to do with the mode of proof. A custom is mixed question of law. A custom is a mixed question of law and fact. First, certain facts are to be proved, and from those facts an inference of the existence of a valid custom is drawn. Where a custom is pleaded by one party and denied by the other, the onus is on the party pleading it to show its existence. So the burden of proof is to the person who claims the existence of such a custom. The custom may be proved or disproved in any of the following ways. The first one, by opinion of persons likely to know of its existence, of having special means of knowledge thereof. The second, by statement of persons who are dead or whose attendants cannot be proved without unreasonable delay or expense, provided they were made before any controversy as to such custom arose, and were made by persons who would have been or likely to have been aware of the existence of such custom if it existed. The third one, by any transaction by which the custom in question was claimed, modified, recognized, asserted, or denied, or which was inconsistent with its existence. The fourth one, by particular instances by which the custom was claimed, recognized, or exercised, or knowledge of its existence was disputed, asserted, or departed from. Now, judgments, orders, or decrees are relevant to prove a custom, but they are not conclusive proof thereof. But when a custom has been repeatedly brought to the notice of the court and judicially recognized, it becomes a part of the law of the locality where it prevails, and it is not necessary to prove its attributes in each individual case. So that is with custom. And then we have state of mind or bodily feeling, discussed in section 14, that is facts showing the existence of state of mind or bodily feeling, section 14. Section 14 of the Indian Evidence Act 1872 deals with the proof of the facts showing the existence of any state of mind or of body or bodily feeling. It runs as follows: facts showing the existence of any state of mind, such as intention, knowledge, good faith, negligence, rashness, ill will, or goodwill towards any particular person, or showing the existence of any state of body feeling, or are relevant when the existence of any such state of mind or body or bodily feeling is an issue or relevant. Now, explanation 1. The fact relevant as showing the existence of a relevant state of mind must show that the state of mind exists not generally but in reference to a particular matter in question. Explanation 2. But where upon the trial of a person accused of an offence, the previous commission by the accused of an offence is relevant within the meaning of this section, the previous conviction of such person shall also be a relevant fact. Now, illustrations. The first illustration: A is accused of receiving stolen goods, knowing them to be stolen. It is proved that he was in possession of a particular stolen article. The fact that at the same time he was in possession of many other stolen articles is relevant, as tending to show that he knew each and all of the articles of which he was in possession to be stolen. Another illustration: A is accused of fraudulently delivering to another person a counterfeit coin, which at the time when he delivered it, he knew it to be counterfeit. The fact that at the time of its delivery, A was possessed of a number of pieces of counterfeit coins, knowing them to be counterfeit, is relevant. Now, another illustration: A used B for damage done by a dog of B, which B knew to be ferocious. The fact that the dog had previously bitten X, Y, and Z, and they had made complaints to B, are relevant. Now, another illustration: the question is whether A, the acceptor of a bill of exchange, knew that the name of the payee was fictitious. The fact that A had accepted the other bill drawn in the same manner before they could have been transmitted to him by the payee, if the payee had a real person, is relevant, as shown that A knew that the payee was a fictitious person. Now, another illustration: A is accused of defaming B by publishing an imputation intended to harm the reputation of B. The fact of the previous publication by A respecting B showing ill will on the part of A towards B is relevant, as proving A's intention to harm B's reputation by particular publication in question. The fact there was no previous quarrel between A and B, and that A repeated the matter complained of as he heard it, are relevant, showing that A did not intend to harm the reputation of B. And furthermore, we have another illustration: A is sued by B for fraudulently representing to B and C to B that C was solvent, where B, being introduced to trust C, who was insolvent, suffered loss. The fact at the time when A represented C to be solvent, C was supposed to be solvent by his neighbor and by persons dealing with him, is relevant, as showing that A made the representation in good faith. Another illustration: A is sued by B for the piece of work done by B upon a house of which A is the owner by the order of C, a contractor. A's defense is that B's contract was with C. The fact that A paid C for the work in question is relevant, as proving that A did in good faith make over to C the management of the work in question, so that C was in position to contract with B on C's own account and not the agent for A. And such we have plenty more illustrations in this section. We have many illustrations. So the next we have section 14 of the Evidence Act deals with the proof of similar fact showing the existence of any state of mind such as intention, knowledge, good faith, negligence, rashness, ill will or goodwill towards any particular person, and also facts showing the existence of any state of body or bodily feeling provable when the existence of any such state of mind or body or bodily feeling is an issue or relevant. In simple words, the following facts are made relevant under section 14 of the Evidence Act, that is the state of mind and state of body or bodily feeling. So, state of mind. Facts showing the state of mind constitute intention, knowledge, good faith, negligence, rashness, ill will or goodwill. For the purpose of showing the existence of the state of mind, it is not possible to provide direct evidence. So, Brian C.J. observed, it is common knowledge that thought of a man cannot be tried, for devil knoweth not what passeth in one's mind. But it is now well established that the state of one's mind is as much as fact as the state of his digestion. It need not be directly proved by confession by the accused or by the evidence of a person who had admission from the accused about his intention. Now, second one is state of body or bodily feeling. The condition of one's body or his bodily feeling may help a lot in finding the truth. Thus, where it is alleged that A was murdered by administering poison to him, his statements regarding his condition and bodily feeling may help in finding whether poison was given to him and which type of poison was administered. Now, the next section is section 15, that is facts bearing on question whether act was accidental or intentional. So, section 15 deals with facts bearing on the question whether the act was accidental or intentional. Section 14 and section 15 of the Evidence Act are overlapping. So, in section 14, we discuss about the state of mind, which can also be considered as whether it was intentional act or accidental act. So, section 14, we have the state of mind, body or bodily feeling, and in section 5, we are particularly discussing about facts which gives an answer to whether an act was accidental or intentional. So, these two, for section 14 and section 15, are overlapping. Section 15 is an application of the general rule laid down in section 14. Section 15 of the Evidence Act deals with facts bearing on question whether act was accidental or incidental. It reads as follows: where there is a question whether an act was accidental or intentional or done with a particular knowledge or intention, the fact that such act formed as a part of a series of similar occurrences in each of which the person was doing the act was concerned is relevant. So, illustration: A is accused of burning down his house in order to obtain money from for which it is insured. The fact that A lived in several houses successively, each of which he insured, in each of which a fire occurred, and after each of which A received payment from a different insurance office, are relevant as tending to show that the fire was not accidental. Now, another illustration: A is employed to receive money from debtors of B. It is A's duty to make entries in the book showing the amounts received by him. He makes an entry showing that on a particular occasion he received less than he really did receive. The question is whether this false entry was accidental or intentional. The fact that other entries made by A in the same book are false, and that the false entry is in each case in favor of A, are relevant. Now, another illustration is that A is accused of fraudulently delivering to B a counterfeit rupee. The question is whether the delivery of the rupee was accidental. The fact that soon before or soon after the delivery to B, A delivered counterfeit rupees to C, D and E are relevant as showing that the delivery to B was not accidental. So, that is with facts bearing on question whether act was accidental or intentional in section 15. Lecture 4, Admissions. So admissions is discussed from section 17 to 31, which also includes admissions as well as confessions. So first, admissions, that is sections 17 to 23, and confession is discussed from section 24 to 30. Now overall admissions, section 17 to 31, including admissions and confessions. Exclusive to admission is section 17 to 23, and confession section 24 to section 30. Now meaning. The expression admission means voluntary acknowledgement of the existence or truth of a particular fact. So it means voluntary acknowledgement of existence of a truth of a particular fact. But in the Evidence Act, the term admission has not been used in this wider sense. It deals with admission by statements only oral or written or contained in an electronic form. So oral, written or contained in an electronic form. Admission plays a very important role in judicial proceedings. If one party to the suit or any other proceeding proves that the other party has admitted his case, the work of the court becomes easier. An admission must be clear, precise, not vague or ambiguous. Section 17 defines admission. Section 18 to 20 enumerate various categories of persons competent to make admission. So section 18 to 20 discuss about the categories of persons competent to make admission. Now section 21 deals with proof of admission against persons making them and by or on their behalf. Section 22 deals with the relevancy of oral admission of a contents of a document. Section 22A provides for when oral admission as to contents of electronic documents are relevant, and section 23 deals with admission in civil cases when relevant. So once again, section 17 defines admission. Section 18 to 20 discuss about the persons competent to make admissions. Section 21 deals with proof of admission against persons making them and by or on their behalf. Section 22 deals with the relevancy of oral admission to the contents of a document. Section 22A discuss about the oral admission as to contents of an electronic record, and 23 deals with the admissions in civil cases when relevant. So definition or admission defined in section 17. According to section 17 of the Evidence Act, an admission is a statement, oral or documentary, or contained in an electronic form which suggests any inference as to any fact in issue or relevant fact, and which is made by any of the persons and under circumstances hereinafter mentioned. Characteristics. To constitute admission, the following characteristics are to be present as per definition of given in section 17. The first one, it may be oral or documentary. Second, it is a statement to suggest any inference as to any fact in issue or relevant fact. Now the third one, it may be made by any person prescribed under the Act, that is discussed in section 18 to 21. Section 18 to 20, that is section 18, 19 and 20. Discuss persons competent to make the admission. Now the fourth one is it must be made under the circumstance prescribed under the Act. Example, A undertakes to collect rents from B. A was asked to collect rent from C, but A did not collect, saying that no rent was due from C to B. B sues A for not collecting the rent. If C makes a statement that C owes B rent, it is an admission. Admission is the best substantive evidence that an opposite party can rely upon. So admission is the best substantive evidence that an opposite party can rely upon. Nature of admission. The statements made by parties during judicial proceeding are self-regarding statements. The self-regarding statements may be classified under two heads: self-serving statement and self-harming statement. So discussing the nature of admission, the statements made by parties during judicial proceeding are self-regarding statements, and these self-regarding statements can be either self-serving or self-harming. So self-serving statements are those which serve, promote or advance the interest of the person making it. Hence they are not allowed to be proved, they enable to create evidence for themselves. Now, self-harming statement. Self-harming statements are those which harm or prejudice or injure the interest of the person making it. These self-harming statements are technically known as admissions and are allowed to be proved. Admissions by silence. Where a statement substantially affecting a person's material interest is made in his presence and the circumstances are such that he would have certainly objected had it been incorrect, the silence on the part of such person can be deemed as an admission of the statement. In such a case, silence can be deemed as admission provided the person has an obligation to speak and he holds his tongue in breach of that obligation. So, Besella versus Stern, 1877. Besella versus Stern. In this case, a suit was filed for breach of promise of marriage. It was proved that the plaintiff said to the defendant, "You always promised to marry me and you do not keep your word." The defendant at that time did not deny the promise alleged by the plaintiff in her statement. The Court of Appeal held that from the silence and other conduct of the defendant, the jury might draw an inference of admission on the part of the plaintiff and of the alleged promise. Value of evidence of admission. An admission is the best evidence against the party making the same unless it is untrue and made under the circumstances which does not make it binding on him. Admission by a party is substantive evidence of the facts admitted by him. Admissions duly proved are admissible evidence irrespective of whether the party making the admission appeared in the witness box or not. In fact, admission is the best substantive evidence that an opposite party can rely upon it. The evidentiary value of admission by the government is merely relevant and not conclusive unless the party to whom they are made has acted upon and thus altered his detriment. So, the evidentiary value of the admission by the government is merely relevant and not conclusive unless the party to whom they are made has acted upon and thus altered his detriment. Now, persons competent or qualified to make admissions. This is discussed from section 18 to 20. Sections 18 to 20 of the Act lays down the provisions relating to the persons competent to make admissions. According to section 18, the following persons can make admission. The first one, parties to the suit or process, may it be civil or criminal. Parties to the suit or process. The second one, authorized agents of the parties expressly or impliedly assigned hereto. For example, statements in a representative character, a statement made by the Vice Chancellor of a university that mass copying took place in the examination conducted by the university. This statement is deemed to be an admission. Now, third one is persons having proprietary or pecuniary interest in the subject matter of the suit or proceeding. Persons having proprietary or pecuniary interest in the subject matter of the suit or proceeding. Example, statement of admission made by one partner is an admission and shall be binding upon other partners of the firm. The fourth category is persons from whom the party to the suit has derived his interest. Persons from whom the party to the interest has derived his interest. So these are the four categories of persons who can make admission discussed under section 18. Now section 19 and 20 deals with the statements by strangers. The general rule is admission made by strangers are not admissible. That is the general rule. However, section 19 and section 20 provides exception to this rule. According to section 19, a third person or a stranger can make an admission against him affecting his position or liability. According to section 20, statements made by persons to whom a party to the suit has expressly referred for information is admissible. So by section 19, a third person or a stranger can make an admission against him affecting his position or liability, and according to section 20, statements made by persons to whom a party to the suit has expressly referred for information is admissible. So example, as A sold horse to B. B asked A whether the horse is sound and A says B, go and ask C. Now C knows all about it. Here the statement made by C is an admission. Self-serving statements when admissible, that is discussed under section 21, that when self-serving statements can be made admissible. General rule is self-serving statements are not accepted as admissions. Section 21 of the Evidence Act provides for proof of admission against persons making them and by or on their behalf. Section 21 provides three exceptions to the general rule, that is self-serving statements are admissible, that is self-serving statements can be made admissible in the following three scenarios. The first one, when the self-serving statement is of such a nature that the person making it were dead, it would be relevant as between third persons, that is dying declaration. Now the second one, when it relates to any state of mind or body and is accompanied by conduct rendering its falsehood improbable. So when it relates to any state of mind and body and is accompanied by conduct rendering its falsehood improbable. And the third scenario is if it is relevant otherwise than as an admission. If this is it is relevant otherwise than as an admission. So these are three scenarios when a self-serving statement is admissible under section 21. Section 21 runs as follows. Admissions are relevant and may be proved as against the person who makes them or his representative in interest, but they cannot be proved by or on behalf of the person who makes them or by his representative in interest except in the following cases. The first one, an admission may be proved by or on behalf of the person making it when it is of a nature that if the person making it were dead, it would be relevant as between third persons under section 32, that is dying declaration. Now the second one, an admission may be proved by or on behalf of the person making it when it consists of a statement of the existence of any state of mind or body relevant or in issue made at or about the time when such state of mind or body existed and is accompanied by the conduct rendering its falsehood improbable. And the third one, an admission may be proved by or on behalf of the person making it if it is relevant otherwise than as admission. So there we have some illustrations here. The first one, the questions between A and B is whether a certain deed is or is not forged. A affirms that it is genuine and B that it is forged. A may prove a statement by B that the deed is genuine and B may prove a statement by A that the deed is forged. But A cannot prove a statement by himself that the deed is genuine, nor can B prove a statement by himself that the deed is forged. Now, A, the captain of a ship, is tried for casting her away. A, the captain of a ship, is tried for casting her away. Evidence is given to the ship that the ship was taken out of her proper course. A produces book kept by him in the ordinary course of his business, showing observations alleged to have been taken by him from day to day and in indicating that the ship was not taken out of her proper course. A may prove these statements because they would be admissible between the third parties if he were dead under section 32 subclause 2. Now, another illustration is A is accused of a crime committed by him at Calcutta. He produces a letter written by him and dated at Lahore on that day and bearing the Lahore postmark of that day. The statement in the date of the letter is admissible because if A were dead, it would be admissible under section 32 subclause 2. Now, another illustration, A is accused of receiving stolen goods knowing to be stolen. He offers to prove that he refused to sell them below their value. A may prove these statements though they are admissions because they are explanatory of conduct influenced by the fact and issue. Now another illustration is A is accused of fraudulently having in possession of counterfeit coin which he knew to be counterfeit. He offers to prove that he asked a skillful person to examine the coin as he doubted whether it is counterfeit or not, and that person did examine it and told him it was genuine. A may prove these facts for the reasons stated in the last preceding illustration. Now, relevancy of oral admission as to the contents of a document, that is discussed in Section 22, relevancy of oral admission as to the contents of a document. Section 22 of the Act lays down that oral admission as to the contents of a document are irrelevant. Oral admissions as to the contents of a document are irrelevant. However, they can be proved to be relevant by a party who is entitled to give the secondary evidence of its contents under Section 65. Now, in Section 22A, we discuss about oral admission as to contents of electronic records which are relevant. According to Section 22A, this was inserted by Clause 3 of second schedule of the IT Act 2000. 22A, Section 22A of the Evidence Act says that oral admission as to the contents of electronic records are not relevant unless the genuineness of the electronic record produced is in the question. So, only if the genuineness of the electronic record produced is in question, the oral admission as to the contents of the electronic record are relevant. Else, the oral admission as to the contents of the electronic records are not relevant. This section prescribes that oral admission as to the contents of an electronic record will not be relevant unless the genuineness of the electronic record produced is in question, that is disputed. In Section 22, oral admissions as to the contents of a document are also relevant when party proposing to give evidence of oral admission proves that he is entitled to give secondary evidence under Section 65. Now, admissions in civil cases when relevant is discussed in Section 23. Admission in civil cases when relevant is discussed in Section 23. In civil cases, no admission is relevant if it is made 1. Either upon an express condition that evidence of it is not to be given. Second, or under the circumstance from which court can infer that the parties agreed together that evidence of it should not be given. So, in civil cases, no admission is relevant if it is made either upon an express condition that evidence of it is not to be given, or under the circumstance from which court can infer that the parties agreed together that evidence of it should not be given. Now, Section 23 lays down certain rules of relevancy of admission in civil cases. It does not apply to criminal cases. According to Section 23 of the Act, an admission in civil case is not relevant under the following circumstances. An admission in civil cases is not relevant under the following circumstances. 1. When it is made upon an express condition that evidence of it is not to be given. For instance, in a life insurance contract, the insured policyholder furnishes his family history in the proposal form or the application form on the condition that it shall not be used as evidence in the court. And the second is where, though the admission has not been made on such express condition, but the court can infer that the parties agreed together that the evidence of it should not be given. For example, where a person writes to another a letter without prejudice, he cannot use the reply in evidence against the writer even if his reply is not marked with prejudice. Similarly, where a letter is one of a series of letters written without prejudice, it is also privileged even if the words without prejudice are not written in it. Now, with that, we are gonna done with admission, and we are going to discuss about confession. Confessions is discussed from sections 24 to 30. So, let's see into the meaning and definition. The expression confession means a statement made by an accused admitting his guilt. It is an admission or acknowledgement as to the commission of an offence. If a person accused of an offence makes a statement against himself, it is called confession or confessional statement. So, a statement made by an accused admitting his guilt. That is the meaning of confession. Now, example, A is charged with the murder of B. If A said that he had killed B, it is a confession or confessional statement by A. Confessions are special form of admissions. So, confessions are also a form of admissions. The sections exclusive for admissions is 17 to 23, but admissions as a whole is discussed from sections 17 to 31 actually, 17 to 31. All confessions are admissions, but all admissions are not confessions. So, the term confession has not been defined anywhere. It appears for the first time in section 24 of the Evidence Act. It is not defined anywhere. According to Sir James Stephen, a confession made at any time by a person charged with a crime stating or suggesting the inference that he committed the crime is called a confession. Now, section 24 to 30 deals with confession. Confession should be voluntary. Section 24 says that confessional statement made by an accused by inducement, threat, or promise is irrelevant and inadmissible. Similarly, section 25 and 26 exclude evidence of confessional statement to police officer. So, section 25 and 26 exclude the confessional statements given to police officer. Section 27 deals with how much of information received from the accused may be proved. And section 28 and 29 discuss about the nature of exception to section 24, and section 30 deals with the admissibility of confession of a co-accused jointly tried with the accused. So, confession is dealt in section 24 to 30. Section 24 explains what is a confessional statement, and it says that the confession shall be a voluntary confession and not by threat, inducement, or a promise. Now, 25 and 26 exclude the confessional statements given to police officer. Now, 27 discuss about how much of the information from the confessional statement can be made admissible or can be proved. That is discussed in 27. And 28 and 29 discuss about the nature of exception to section 24. And section 30 deals with the admissibility of confession of a co-accused. Now, it is a rule of universal law that a person may be convicted on the basis of his confession made in a judicial proceeding. The underlying principle is enshrined in two Latin maxims as stated below. That is, confession judicio omni probation major est. Confession judicio omni probation major est, which means confession in judicial proceeding is greater than any other proof. The second maxim is confessio facta in judicio est plena probatio. Confessio facta in judicio est plena probatio. It means confession is a absolute proof. So, we have two maxims: confessio in judicio omni probation major est, and confessio facta in judicio est plena probatio. So, confessio in judicio omni probation major est, which means confession in judicial proceeding is greater than any other proof. And the second one, confessio facta in judicio est plena probatio, which means confession is the absolute proof. Now, judicial and extrajudicial confession. Confessions are of two kinds, namely judicial and extrajudicial. Confessions made during the course of judicial proceedings are called judicial confession. Confession made outside the course of judicial proceeding are called extrajudicial confession. Now, evidentiary value of confession. Confession, whether it is judicial or extrajudicial, must be clear and unequivocal. No reliance can be placed on confessions which are in general or vague terms. The judicial confession of an accused is good evidence and he can be convicted on the strength of it. Law does not require that a confession must be corroborated before it can be acted upon. It is the duty of the court to decide whether it believes a confession or not. Thus, the court must apply double test. The first one, whether the confession was perfectly voluntary, and the second one, if so, whether it is true and trustworthy. So, it is a discretion of the court to believe a confession or not, and the double test, the first test is whether the confession was perfectly voluntary, and the second one, if it is voluntary, whether it is true or trustworthy. Now, satisfaction of the first test is a sine qua non for its admissibility in evidence. Whether the confession was perfectly voluntary, that test is of sine qua non for its admissibility, means that a mandatory one for the admissibility in evidence. If the first test is satisfied, the court should carefully examine the confession and compare it with the rest of the evidence. In the light of the surrounding circumstance and probabilities of the case, if no such examination and comparison, the If on such examination and comparison the confession appears to be probable catalogue of events and naturality fits with the test of evidence and the surrounding circumstance, it may be taken to have satisfied the second test. Section 24 to 30 of the Evidence Act lays down the provisions relating to confession as follows. Now, confession caused by inducement, threat, or promise. Section 24. By Section 24, a confession to be admissible in evidence, it must be free and voluntary. If it proceeds from a remorse and a desire to make reparation for the crime, it is admissible. A confession made by an accused in a criminal proceeding is irrelevant if it is caused by inducement, threat, or promise. Example, if the magistrate says the accused, explain how you committed the offense so that I will help you, it is inadmissible. Ingredients. To attract the prohibition enacted in Section 24, the following acts must be established. The first one, that the statement in question is a confession. Second, that such confession has been made by the accused. The third, that it has been made to a person in authority. Fourth one, that the confession has been obtained by reason of any, that the confession has not been obtained by reason of any inducement, threat, or promise proceeding from a person in authority. And the fifth one, such inducement, threat, or promise shall not have reference to the charge against the accused, or it shall not have any threat. Now, the sixth one, the inducement, threat, or promise must, in the opinion of the court, be sufficient to give the accused ground which would appear to him reasonable for supporting that by making it he would gain any advantage or avoid any evil of a temporal nature in reference to the proceedings against him. Now, it is very difficult to lay down any hard and fast rule as to what constitutes inducement. It is for the judge to decide every case. An inducement may be express or implied. It need not be to the accused directly from the person in authority. In Pyarelal Bhargava versus State of Rajasthan, 1963, Pyarelal Bhargava versus State of Rajasthan, 1963. The accused in the instant case was charged and tried for the theft of certain official files. He was taken to the chief secretary where he made confession. Later, he retracted the confession on the ground that he was threatened with dismissal. The Supreme Court held that the threat by chief secretary was not sufficient to cause reasonable belief in the mind of the accused, and the confession was held to be admissible. Now, confession to the police officer, that is discussed in Section 25. According to Section 25, confession made to the police officer is inadmissible. Confession under Section 25 may be a statement directly made to a police officer orally or in writing, or indirectly made to a police officer. The reason is the police officers in India resort to third-rate methods to extort confession. Confession to police officer are excluded even if arrest and custody are illegal. This was discussed in Emperor versus Magistrate of Jagya. Now, Sitaram versus State, 1996. Sitaram versus State, 1996. The accused, after committing murder, left a confessional letter on the dead body. The letter was addressed to police officer. The court treated the letter not addressed to police since the police officer was not nearby. The confession was admitted and the accused was convicted. Confession by the accused while in custody of the police not to be proved against him. This is discussed in Section 26. Confession of the accused while in custody of police not to be proved against him. No confession made by any person whilst he is in the custody of a police officer, unless it be made in the immediate presence of a magistrate, shall be proved as against such person. Explanation. In this section, magistrate does not include the head of a village discharging magisterial function in the presidency of Fort St. George or elsewhere, unless such headman is a magistrate exercising the power of a magistrate under the CRPC 1882. According to Section 26, confession made by an accused in police custody shall not be proved against him. Confession caused by inducement, threat, or promise have been made inadmissible by Section 24. confession made to a police officer have been declared irrelevant by Section 25 without proof of inducement, threat, or promise. How much of information received from the accused in police custody may be proved is discussed in Section 27. How much of the information received from accused in police custody may be proved is discussed in Section 27. Section 27 is an exemption to the preceding three sections, that is Section 24, 25 and 26. According to Section 27, when an information given by the accused in police custody leads to the discovery of an incriminating material or material object like jewelry, weapons, etc., that portion of the information can be proved. The reason is such discovery guarantees truth of the information. Example, A is tried for the murder of B. If A in police custody says, I have killed B and buried the dead body in my garden. Accordingly, if the body is found, A's statement becomes provable under Section 27. Section 27 runs as follows. How much of the information received from the accused may be proved, provided that when any fact is deposed to as discovered in consequence of information received from a person accused of any offence in the custody of a police officer, so much of such information, whether it amounts to a confession or not, as relates distinctively to the fact thereby discovered, may be proved. Conditions for application Section 27 to the following conditions. Conditions for the application of Section 27. The first one, the accused in police custody has given some information in his confessional statement. The second one, such information must relate to the discovery of certain fact relating to the commission of some offence. The third one, in pursuance of such information, the police discovered certain facts. The fourth one, the facts discovered must be connected with the offence or relevant to the offence. So, four conditions are laid down for to make Section 27 applicable. The first one is the confessional statement is given in police custody, and the second one, it must relate to discovery of certain facts. This confessional statement shall lead to discovery of certain facts relating to the commission of the offence. And the third one is, in pursuance of such information, the police discovered certain facts. And the fourth one is, the facts discovered must be connected with the offence, connected with or relevant to the offence. When the above conditions are satisfied, only that portion of the information which directly relates to the fact discovered shall be relevant. Now, in a case law, Pullukuri Kottai versus Emperor. Pullukuri Kottai versus Emperor 1947. Now, Kottai's case is leading and relevant on this point. So, Kottai's case is leading and relevant on this point. In this case, the accused was charged with the offence of rioting with murder. The accused made a confession to the police as, about 14 days ago, I, Kottaya, and people of my party lay in wait of Shivaya and others at about sunset time at the corner of the Pullipadu tank. We all bet Bodupatti, Chinna Shivaya and Subaya to death. The remaining persons, Pullaya, Kottaya and Narain, ran away. Dondapatti Ramaya, who was in our party, received blows on his head. He had a spear in his hand. He gave it to me and I hid it and my stick in the rick of the Venkatarasu in the village. In the rick of the Venkatarasu in the village. I will show you if you come. We did all this the instigation of Pullukuri Kottaya. In pursuance of this statement, the police recovered or discovered the spear. It was held that the second part of the confession leading to the discovery of the dead body becomes provable or admissible under Section 27. The word discovery under Section 27 can be understood in two senses. First, discovery means purely a mental act, learning something which was not known earlier. Secondly, it may be a physical fact, that is, finding upon search of some fact the existence or exact locality of which was not known earlier. Section 27 applies to the latter. In other words, Section 27 has no application to the discovery of the psychological facts. In another case, that is Timma versus State of Mysore 1971. Timma versus State of Mysore 1971. In this case, the accused was charged with the murder of his mistress and the dead body of the lady was found in a gunny bag left in a railway compartment. The accused was arrested. He pointed out the shop where he had purchased the gunny bag and he also pointed out the coolie whom he had engaged for carrying the gunny bag. This information was held to be inadmissible because it leads only to the discovery of a psychological fact and not to the discovery of some physical fact. The word discovery in section 27 has been used in the sense of discovery of some material object. As held by Privy Council in Pullukuri Kottaya case, the Supreme Court in Udaybhan versus State of UP. Supreme Court in Udaybhan versus State of UP 1962 laid down a discovery of fact includes three components: the object found, place from which it is produced, and the knowledge of the accused as to its existence. So, Supreme Court laid down the following facts with respect to discovery, that is, the object found, place from which it is produced, and the knowledge of the accused as to its existence. Now, constitutional validity of section 27. The validity of section 27 Indian Evidence Act 1872 was challenged on the ground that it violates article 20 subclause 3, that is the self-incrimination, the doctrine of self-incrimination. It violates article 20 subclause 3 of the Indian Constitution. According to article 20 subclause 3 of Indian Constitution, no person accused of an offence shall be compelled to be a witness against himself. It is responsibility of the prosecution to prove the guilt of the accused. The constitutional validity of section 27 Indian Evidence Act was challenged on the ground that using information given by the accused for discovery of a fact against him makes the accused a witness against himself. Before the Constitution came into force, the information leading to discovery was provable and admissible, whether it was given by the accused voluntarily or against compulsion. After the Constitution came into force, such information obtained by compulsion is not admissible on the ground that it violates Article 20, subclause 3 of the Constitution. This view was followed by AP High Court in Re Madugula Jermaiya, Allahabad High Court in Amin versus State, and Bombay High Court in Amrut versus State. But Mysore High Court in Re Govinda Reddy was of the view that section 27 of the Evidence Act is not controlled by Article 20 subclause 3. So, the AP High Court, Allahabad High Court and Bombay High Court in various cases was of the view that it violates Article 20 subclause 3 of the Constitution, whereas the Mysore High Court in Re Govinda Reddy was of the view that section 27 of the Evidence Act is not controlled by Article 20 subclause 3 of the Constitution. The above conflict was resolved by the Supreme Court in State of Bombay versus Kattikallu Oghad. The Supreme Court put an end to this conflict in State of Bombay versus Kattikallu Oghad, that such information obtained does not give rise to a presumption that the information was given under compulsion. It is the prosecution to find out whether the accused gave the information voluntarily or by compulsion. Section 28 and 29 provides for the exceptions of section 24. That is to say that confession made after removal of impression caused by inducement, threat or promise are relevant. That is said in section 28, and confession under the promise of secrecy, section 29. Now, consideration of proved confession affecting person making it and other jointly under the trial for the same offence, section 30, that is confession of a co-accused, is discussed in section 30. So, section 28 discuss about the confession after the removal of impression of inducement, threat or promise are relevant, and section 29 discuss about the confession under the promise of secrecy. And now under section 30 we are going to discuss about confession of the co-accused. When more persons than one are being tried jointly for the same offence and a confession made by one of such persons affecting himself and some other of such persons is proved, the court may take into consideration such confession as against such other persons as well as against a person who makes such confession. So, explanation: offence as used in this section includes the abetment of or attempt to commit the offence. Illustration: A and B are jointly tried for the murder of C. It is proved that A said, B and I murdered C. B and I murdered C. The court may consider the effect of this confession as against B also. Now, another illustration. A is on his trial for the murder of C. There is evidence to show that C was murdered by A and B, and that B said, A and I murdered C. This statement may not be taken into consideration by the court against A, as B is not being jointly tried. So B is not a co-accused here, so this statement may not be considered. So admissions not conclusive proof but may stop. That is discussed in section 31. That is admissions not conclusive proof but may stop. Admissions are not conclusive proof of the matters admitted, but they may operate as estoppels under the provisions hereinafter contained. So admissions can act as a estoppel. So that is discussed, but not as a conclusive proof. That is discussed in section 31. So now distinction between admission and confession. Admission means voluntary acknowledgement as to the truth of a fact, whereas confession means a statement made by an accused admitting his guilt. Now, admission is defined under section 17 of Evidence Act, and confession is not defined in the Act. Admission is not a conclusive proof. Confession, judicial confession, is a conclusive proof. Now, all admissions are not confessions, but all confessions are admissions. Now, admission is made in a civil cases, but confession is made in criminal cases. Admission can be made on behalf of another or by a stranger. Confession must be made by the accused himself. So that is a distinction between admission and confession, where it is also important to note that all confessions are also admissions. So our exclusive sections for admission is 17 to 23, and for confession is 24 to 30, and for admission it's about 17 to 31, and section 31 is admission not conclusive proof but may act as an estoppel. So that is with admission, lecture 4, sections 17 to 31. The next one is lecture 5, dying declaration or statements of persons who cannot be called as witness. So sections 32 and 33 of the Act lay down provisions relating to statements by persons who cannot be called as witnesses. Section 32 says that cases in which statement of relevant fact by person who is dead or cannot be found, etc., is relevant, and that is dying declaration. In section 33 deals with relevancy of certain evidence for proving in subsequent proceeding the truth of certain facts therein stated. So section 32 makes relevant statement made by a person who is dead, who cannot be found, who has become incapable of giving evidence, or whose attendance cannot be procured without unreasonable delay or expense. So section 32 considers relevancy of statement by 4 kind of people. The first one is who is dead, the second one is who cannot be found, the third one who has become incapable of giving evidence, or the fourth one whose attendance cannot be procured without unreasonable delay or expenses. So dying declaration. So section 32 subclause 1 of the Indian Evidence Act 1872 lays down the provision relating to dying declaration. It is a provable evidence. So we discussed 4 kind of persons whose statements are relevant under section 32, and the first one is who is dead. So that is relating to dying declaration. The second one was who cannot be found, and the third one who has become incapable of giving evidence, and the fourth one whose attendance cannot be procured without unreasonable delay or expense. And now we are going to look into 32 subclause 1, statement given by a person who is dead, dying declaration. Now this dying declaration is a provable in evidence. Meaning and definition. A dying declaration is a declaration, written or verbal, made by a person as to the cause of his death or to any of the circumstances of the transaction which resulted in his death. So the declaration shall be with respect to his cause of death or anything that led to his death. Example, A has been attacked by B. If A shortly before death makes a declaration holding B responsible for his injuries, it is called dying declaration. Section 32 subclause 1 of the Act defines dying declaration as statements, written or verbal, of relevant facts made by a person who is dead or who cannot be found or who has become incapable of giving evidence or whose attendance cannot be procured without an amount of delay or expense, which under the circumstances of the case appear to the court unreasonable or themselves relevant facts in the following cases. The first one, when it relates to the cause of death. The second one, when it is made in the course of business. Third one, against the interest of the maker. Fourth one, gives opinion as to the public right or custom or matters of general interest. Now the fifth one relates to the existence of a relationship. The sixth one, when it is made in will or deed relating to the family affairs. The seventh one, in a document relating to transaction mentioned in section 13 subclause A. Now the eighth one, when it is made by several persons and expresses feelings relevant to a matter in question. According to section 32 subclause 1, dying declaration is a statement oral or verbal written made by a person who is dead or cannot be found or incapable of giving evidence or whose attendance involves delay or expense under the circumstance stated above, which the court considers reasonable. Dying declaration is of the utmost importance and the evidence as to it should be as exact and full as possible. The general rule is hearsay evidence is no evidence and is not admissible in evidence. Section 32 and 33 of the Evidence Act are among the exceptions. As such, dying declaration is an exception to this general rule. Reasons for the admissibility of dying declaration. Dying declaration is admissible for the following two reasons. The first one, as the victim is the sole eyewitness, exclusion of his evidence defeats the ends of justice. And the second one, declaration made by a person under the expectation of death are presumed to be true. Now, underlying principle or maxim. The admissibility of dying declaration is based on the maxim nemo moritur presumpter mentiri, which means that a man will not meet his maker with a lie in his mouth. A man will not meet his maker with a lie in his mouth. Nemo moritur presumpter mentiri. Nemo moritur presumpter mentiri. So, a man will not meet his maker with a lie in his mouth. In other words, a person who is about to die would not lie. Truth sits on the lips of a person who is about to die. Such persons would not lie because he has to face his maker, the Almighty, in the other world. This is the reason why dying declaration is made admissible under section 32 subclause 1. Though the dying declaration are not statements made on oath and no cross-examination is possible, yet because of the solemnity of the occasion, which ensures truth more than a positive oath, they are received in evidence. Absolute guarantee of truth cannot be expected even in case of statements made on oath in a court. The second reason for admissibility of dying declaration is necessity. Where it is the only evidence available under the circumstances, rejection of it may result in injustice. The person being no more in the world cannot be called in the court to testify and other evidence is not available to help determining the truth. Now the conditions. For admissibility of dying declaration, the following conditions are to be satisfied. The first one, the person making the statement must have died. Second, injuries must have caused the death. Third, statement must have been made as to cause of his death or as to circumstances of his transaction resulting in his death. The fourth one, the cause of his death must be in question. Fifth one, the person making the statement must be in a fit condition to make the statement. Sixth, the statement must be complete. Seventh, declaration must be competent. So these are the conditions for admissibility of dying declaration. Now, the first one, the declarant must have died. Dying declaration to be admissible, the declarant must be dead. If the declarant survives, it is not admissible under section 32 subclause 1, although it is admissible under section 157 as corroborative evidence. So, if the declarant survives, it becomes a corroborative evidence under section 157, and only if the declarant dies, it is an evidence under dying declaration, that is section 32 subclause 1. Now, Maksoodan versus State of UP. Maksoodan versus State of UP, 1983. In this case, survival of the declarant was held to be admissible under Section 157 for corroborating his testimony in the court. Now, Ram Prasad versus State of Maharashtra, 1999. Ram Prasad versus State of Maharashtra, 1999. In this case, dying declaration was recorded by the judicial magistrate, but the declarant survived. It was held that the statement or declaration could not be used under Section 32, but it could be used as corroborative evidence under Section 157 of the Evidence Act. The term death under Section 32 includes both suicidal and homicidal death. That was discussed in Kansraj versus State of Punjab, 2000. So it was discussed in Kansraj versus State of Punjab, 2000, and Sudhagar versus State of Maharashtra, 2000. So Sudhagar versus State of Maharashtra as well as Kansraj versus State of Punjab, both 2000 cases, both cases of AIR 2000. In both these cases, the term death under Section 32 includes both suicidal and homicidal death. So once again, Sudhagar versus State of Maharashtra and Kansraj versus State of Punjab. Now the second condition to be met for the admissibility under dying declaration is injuries must have caused the death. The person, that is a declarant, must have been dead as a consequence of the injuries inflicted, but not as a consequence of some other reason or ailment. So in Moti Singh versus State of UP, 1964, Moti Singh versus State of UP, 1964, it was held in this case that if the person survives, his statement cannot be said to be the statement as to cause of his death. Now the third condition for the admissibility under dying declaration, that is statement as to the cause of death or circumstances leading to death. The statement must relate to the cause of his death or circumstances of the case resulting in his death. Statements which relate to the cause or circumstances not responsible for his death are not admissible as dying declaration under 32 subclause 1. Now the fourth condition for admissibility is cause of death must be in question. The statement as to cause of death of the deceased person will be relevant only if the cause of his death is in question. Now the fifth condition for admissibility in dying declaration is the declarant must be fit condition to make the declaration. Dying declaration is to be admissible under Section 32 subclause 1 if the person making the statement must be in a fit condition to make the statement. The sixth condition for admissibility of dying declaration is the statement must be complete. To be admissible in evidence, dying declaration must be complete. This is a matter of common sense because the deceased might have added something in contradiction to things already stated. It is therefore necessary that the incomplete declaration should not be received in evidence. And the seventh condition for the admissibility of a statement under dying declaration is competence of declarant. The admissibility of the statement under Section 32 is based upon the assumption that the maker of the statement was competent to take oath as a witness. Evidentiary value of dying declaration. So we discussed about the 7 conditions for a statement to be admissible under dying declaration. Now evidentiary value of dying declaration. The evidentiary value of the dying declaration will vary according to the circumstances of a particular case in which it is made. While considering the value of dying declaration, the court take into account the whole but not a part of it. It cannot be allowed as sole basis for confession for the following reasons. So we are going to look into the reason why it cannot be considered as a sole reason for conviction. The first one, the declarant is not subject to cross-examination. The second one, the declarant may be in a state of confusion. Third, the declarant may take last opportunity to take revenge against his enemies. So dying declaration alone cannot be the sole reason for conviction. The declaration must be as to the cause of death or as to any of the circumstances that resulted in death. Now the relevant case laws here is, one is Pakkala Narayana Swamy versus King Emperor. Pakkala Narayana Swamy versus King Emperor. That is 1939 case. Pakkala Narayana Swamy, the accused in the instant case, was a resident of Behrampur. He was married to one of the daughters of Diwan of the Pitapuram estate. So Pakala Narayana Swami was a resident of Behrampur, and he is accused here. He was married to one of the daughters of the Diwan of Pitapuram estate. Nukharaju, the deceased in this case, was a peon in the Pitapuram estate. In 1936, the accused along with his wife visited Pitapuram. During his stay at Pitapuram, the accused borrowed 3,000 rupees from the deceased Nukharaju. Later, the accused went back to Berambur. On 20th March 1937, the deceased Nukhraju received a letter from the accused's wife asking him to come and collect the money at Berambur. The deceased showed that the letter to his wife and left for Berambur on 21st March 1937. But on 22nd March 1937, the deceased's body, cut into 7 pieces, was found in a trunk box in a railway compartment in Puri railway station. In investigation, it was ascertained from the trader of the trunk box that the accused purchased it from him. The accused was arrested and tried for murder. At the trial, the statement made by the deceased to his wife by showing the letter that he was proceeding to Berhampur was held to be admissible as dying declaration under section 32 subclause 1. The court, that is the Privy Council, made it clear that the evidence of any such circumstance must be proximately related to the actual occurrence. The accused's wife, the daughter of the Diwan Pitapuram estate, was in secret love with the deceased Nukhraju, and a number of love letters exchanged between them. If the letters are not proximate, that is not connected with the occurrence, they are not admissible under section 32 subclause 1 as in now. Now we are going to discuss about that case where the letters are not proximate, that is not connected with the occurrence, then they are not admissible. So in Pakala Narayana Swami versus King Emperor, we saw where the letter sent by the accused was shown to the deceased wife, and that was taken as a dying declaration. Now in Gokul Chandra versus State 1950, Gokul Chandra versus State 1950. In this case, the deceased Swarnalada, who was married to son of Gokul Chandra, was being maltreated by her mother-in-law and her husband's brother. She was even driven out of the house and was denied access to her son. She wrote several times to Gokul Chandra and mother-in-law to send her son to her mother's house where she was living, but all in vain. Ultimately, she went to Gokul's house with her 2 uncles. She was again ill-treated and was not allowed to stay in the house with her young son and was compelled to return back with her uncles to her mother's house. When they reached Ram Sagar station, which was their destination, one of their uncles went in search of a bullock cart. Meanwhile, a train arrived at the platform. She stood before the engine and was knocked down and was killed instantaneously. Gokul Chandra and certain other members of his family were then tried for abetting the commission of suicide. At the trial, letters written by her 5 to 8 months before her death were produced as dying declarations. The court held that the letters were not admissible as dying declaration as under section 32 subclause 1. So in another case, Ghasi versus State, that is 1966, Ghasi versus State. Here also, statement made by the deceased 10 years before his death were held inadmissible. So the statement was made by the deceased 10 years before his death and was held inadmissible. Distinction between English law and Indian law. In English law, a dying declaration is provable only in criminal cases, homicide cases, while in Indian law, it is provable both in civil and criminal cases. And the second one, under English law, the declarant must die without a hope of survival, without any hope of survival. But according to para 2 of section 32 subclause 1, statements made not under the expectation of death are relevant but admissible, and admissible. And third one, according to English law, the declarant must be competent. A statement or declaration by an infant or child is not admissible. But in Indian law, every person, whether major or not, is competent to make a declaration. So this is the distinction between English law and Indian law with respect to the liability in English law it is only for criminal cases. In Indian law it can be for criminal case as well as civil cases. And the second one is that in the first one, the declarant must die without any hope of survival. But in Indian law, the statement not under the expectation of death is also relevant and admissible. And in the third criteria is that in English law, declarant must be competent, but by Indian law, any person, whether major or not, is competent to make a declaration. Now, Section 33. Section 33 of the Evidence Act deals with relevancy of certain evidence for proving in subsequent proceedings the truth of certain facts therein stated. It runs as follows. Evidence given by a witness in a judicial proceeding or before any person authorized by law to take it. It is relevant for the purpose of proving in a subsequent judicial proceeding or in a later stage of the judicial proceeding the truth of the facts which it states when the witness is dead or cannot be found or is incapable of giving evidence or is kept out of the way by adverse party, or if his presence cannot be obtained without an amount of delay or expense which under the circumstance of the case the court consider reasonable, provided that the proceeding was between the same parties or their representatives in interest, that the adverse party in the first proceeding had the right and opportunity to cross-examine, that the question in issue was substantially the same in the first and in the second proceeding. Now, the explanation to this: a criminal trial or inquiry shall be deemed to be a proceeding between the prosecutor and the accused within the meaning of this section. Now, Section 33 recognizes the relevancy of evidence given by a witness in a judicial proceeding to have a particular fact when such witness is dead or cannot be found or is incapable of giving evidence or is kept out of the way by the adverse party or whose presence cannot be obtained without an amount of delay or expense. It is provided that the truthness of a fact can be proved by using the evidence given by a witness relating to the fact. However, such evidence can be used to prove the said fact either in the same case or in another case on the circumstances laid on by the said section. Now, the conditions for the application of Section 33 is as follows. Here 5 conditions are mentioned. The first one, the maker of the statement is dead. The second one, he cannot be found. The third one, has become incapable of giving evidence. The fourth one, his evidence cannot be procured without reasonable delay or expense. And the fifth one is kept out of the way by the adverse party. The first 4 conditions are common to Section 32 and 33, but the fifth condition, that is kept out of the way by the adverse party, is peculiar to Section 33. That is with lecture 4, time declaration, and we discuss Section 32 and 33 here. So the next is lecture 6, judgments. Judgments of Court of Justice when relevant. Section 40 to 44 of the Indian Evidence Act 1872 lay down the provisions relating to judgments of Court of Justice when relevant. Section 40 to 44. Section 40 deals with a previous judgment relevant to bar a suit or trial. Section 41 deals with the relevancy of a certain judgment in probate, etc. jurisdiction. Section 42 deals with relevancy and effect of judgments, orders or decrees other than those mentioned in Section 41. Now, Section 43 relates to judgments, etc. other than those mentioned in Section 40 and 42. And Section 44 speaks about fraud or collusion in obtaining judgment or competence of the court. So, Sections 40 to 44 discuss about judgments of Court of Justice when relevant. 40 discuss about previous judgments relevant to bar a suit or a trial. That is Section 40. Section 41 about the relevance of certain judgments in probate, etc. Then Section 42 discuss about the effect of judgment, orders and decrees than those mentioned in Section 41. So Section 41 discuss about certain judgments in probate and etc. All those relevancy of those judgments other than these as mentioned in Section 41 is discussed in Section 42, and Section 43 relates to all those judgments that is not mentioned in Section 40 as well as 42, and Section 44 speaks about fraud or collusion in obtaining judgment or incompetence of the court, which may be proved. Now, kinds of judgment. Judgments are categorized or classified into two kinds, namely judgment in rem and judgment in personam. Judgment in rem. Judgments in rem are judgments affecting the legal status of some subject matters, persons, or things are called judgments in rem. Example: divorce, court judgment, grant of probate or administration, etc. Such judgments are conclusive evidence against all the persons, whether parties to it or not. So, such judgments are conclusive evidence against all the persons, whether parties to it or not. That is judgments in rem, or judgment for the remaining everyone. Now, judgments in personam. Judgments in personam are all the ordinary judgments not affecting the status of any subject matter, any person, or anything. If such judgments, the rights of the parties to the suit or the proceedings are determined. So, judgments in rem, here the it affects the legal status of some subject matter or persons. So, it is applicable to all the persons, even though even if they are not parties to this particular suit or proceeding. Now, judgments in personam doesn't affect the legal status of a particular person or a class of people. The rights or the judgments affect the rights of rights of only those parties who are persons who are parties to the suit or proceedings. Now, under section 40 and 40 to 44, a judgment is not relevant to prove that the plaintiff has filed a false case. So that was discussed in Hassan Abdullah versus State of Gujarat. Hassan Abdullah versus State of Gujarat, 1962. Under sections 40 to 44, a judgment is not relevant to prove that the plaintiff has filed a false case. Now, distinction between judgment in rem and judgment in personam. Judgment in rem is adjudication pronounced upon the status of persons or a thing by a competent court to the world generally, that is to the world generally. Judgment in personam are all the ordinary judgments not affecting the status of any subject matter, any person or anything. It is applicable only to the parties of the proceeding. Now, judgment in rem is judgment of a court in exercise of a probate, matrimonial or insolvency jurisdiction, confirming or taking away legal character or judgments in rem. Now, judgment in personam, the judgments of a civil court are the judgments in personam. Now, judgments in rem, it is binding on all persons whether they are parties to those proceedings or not. Judgment in personam is binding on the parties to the suit only. Section 40 provides for previous judgments relevant to bar a second suit or trial. It runs as follows: the existence of any judgment, order, or decree which by law prevents any court from taking cognizance of a suit or holding a trial is relevant fact when the question is whether such court ought to take consequence of such suit or to hold such trial. Section 40 permits evidence of the previous judgment, order, or decree which by law prevents any court from taking cognizance of a suit or holding a trial when the question arises whether such court ought to take cognizance of such suit or hold such trial. The object of section 40 is to avoid multiplicity of suits and to save precious time of the court. This provision is incorporated in under section 11 of CPC, that is doctrine of res judicata. So, doctrine of res judicata is discussed in section 40 of the Indian Evidence Act. Now, relevancy of certain judgments in probate, etc. jurisdiction. Section 41. Section 41 deals with the judgments in rem which bind not only the parties and their representatives but the whole world. A judgment in rem under section 41 shall be conclusive in civil as well as criminal proceeding. Section 41 runs as follows: a final judgment, order, or decree of a competent court in the exercise of a probate, matrimonial, admiralty, or insolvency jurisdiction, which confers upon or take away from any person any legal character, or which declares any person to be entitled to any legal character or be entitled to specific thing, not as against any specified person but absolutely, is relevant when the existence of any such legal character or the title of any such person to any such thing is relevant. Such judgments, orders, or decrees is conclusive proof. So judgments in rem that is discussed in section 41, it is a conclusive proof that any legal character which it confers accrued at the time when such judgment, order, decree came into operation. That conclusive proof for the following, that is, one is any legal character which it confers accrued at the time when such judgment, order, or decree came into operation. Then any legal character to which it declares any such persons to be entitled accrued to that person at the time of such judgment, order, or decree declares it to have accrued to that person. Then that any legal character to which it takes away from any such person ceased at the time from which the such judgment, order, or decree declared that if that it had ceased or should cease, and that anything to which it declares any person to be so entitled was the property of the person at the time from which such judgment, order, or decree declares that it has been or should be his property. So, to summarize, we can say that such judgments, judgments in rem, such judgments means judgments in rem, that is judgment or order or decree. It is a conclusive proof for the following 4 instances. The first one is when a legal character is conferred to a person or entity, then a legal character to which it so any legal character to which it declares any such person to be entitled. So one, assigning a legal character to character, and the second one we discuss is that legal character is entitled to some person, and the third one we discuss is that some a legal character is taken away by such from such a person, and the last one we discussed is anything which declares to any person so entitled was the property of the person at the time from we are assigning a legal entity to a declaration to a person. So these are the 4 instances that is discussed under section 41. Section 40 discusses about doctrine of res judicata, and section 41 here we discuss about judgments in rem with respect to the assigning of legal character through a judgment or order, decree. Then such legal character is declared to be entitled to some person, then such legal character is taken away from such person or ceases to be entitled to such person. And the 4th category is that anything which declares any person to be so entitled was the property of that person at the time from which such judgment, order, decree declares it has been or should have been his property. Now section 41 deals with what is known as judgments in rem. Under this section, a final judgment, order, or decree of a competent court in the exercise of probate, matrimonial, admiralty, or insolvency jurisdiction, which confers upon or takes away from any person any legal character, or which declares any person to be entitled to any such character or to be entitled to any specific thing absolutely, is relevant when existence of any such legal character or title to any such thing is relevant. A judgment in rem under this section shall be conclusive in civil as well as criminal proceeding. Conditions. For the application of section 41, the following conditions are to be satisfied, and 4 conditions are laid down. The first one, the judgment should be a final judgment and not a interlocutory one. The second one, the court must be competent. The third one, the judgment must be in excess of any of these following 4 types of jurisdiction mentioned in the section wise: probate, admiralty, matrimonial, or insolvency. So the jurisdiction mentioned is probate, admiralty, matrimonial, and insolvency. And the 4th condition, such judgment must confer upon or take away from any person any legal character, or declare that any person is entitled to such character, or declare that any person is entitled to any specific thing. So such judgment shall be to confer or to take away, and any legal character confer or take away any legal character, or it can be of a declaration that a person is entitled to such character or a specific thing absolutely. So these are the 4 conditions to be met for the application of section 41. Now, relevancy and effect of judgments, orders, and decrees other than those mentioned in section 41. So in section 41 we discussed jurisdiction, that is probate, admiralty, matrimonial and insolvency. For other judgments which does not come under these jurisdiction, we go to section 42. According to section 42, judgments, orders and decrees other than those mentioned in section 41 are relevant if they relate to matters of public nature relevant to the inquiry. So if they matters to public relevant and does not come under section 41, then it comes under section 42. But such judgment, order or decrees are not conclusive proof of that which they state. So section 41, we discussed for jurisdiction, and such a judgment is conclusive one. If the judgments which does not fall under the full jurisdiction of section 41 and is of public nature or relevant to public interest, falls under section 42, but this judgment is not a conclusive proof. Now illustration. A sues B for trespass on his land. B alleges the existence of a public right of way over the land, which A denies. The existence of a decree in favor of the defendant in a suit by A against C for trespass on the same land, in which C alleged that the existence of same right of way is relevant, but it is not conclusive proof that the right of way exists. Now, judgments, etc., other than those mentioned in section 40 and 42 will be relevant in section 43. So, we discussed about section 40 and 41, the exception. Those of public interest which does not fall under 41 was discussed in section 42, and now we still have few jurisdiction that may be left out from section 41 as well as 42, and those come under section 43. Section 43 provides that judgments, orders or decrees which are not mentioned in section 40 and 41 are not relevant unless the existence of such judgment, order or decree is a fact in issue or relevant fact under the other sections of the Evidence Act. So, the previous judgments are relevant only if they are relevant with the fact in issue in the present instant case. Judgments, orders or decrees other than those mentioned in section 40, 41 and 42 are irrelevant. So, judgments, orders or decrees other than those mentioned, so which is not included in section 40, 41 and 42 are irrelevant unless the existence of such judgment, order or decree is a fact in issue or is relevant under the some other provisions of this act. So, illustration. A and B separately sue C for libel, which reflects upon each of them. C in each case says that the matter alleged to be libelous is true, and the circumstances are such that it is probably true in each case or in neither. A obtains a decree against C for damage on the ground that C failed to make out his justification. The fact is irrelevant as between B and C. So, we have a few illustrations here. Let's summarize section 40, 41, 42 and 43. So, section 40 we discussed about the doctrine of res judicata in Indian Evidence Act. In section 41 we discussed about 4 jurisdiction, that is the admiralty, probate, admiralty, matrimonial and we have and insolvency. Probate, admiralty and matrimonial insolvency was discussed in section 41, and the judgments under these jurisdiction will be a conclusive proof. Then we discussed about section 43, where matters which is of public interest and does not come under these 4 jurisdiction mentioned in section 42 is discussed in section 43, but here they are relevant and admissible but not conclusive proof. Now in section 44 what we discuss is that those judgments we 42. So next in 43 what we discuss is that those judgments that is not coming under section 40, 41 and 42 are irrelevant. That is, if the judgments doesn't fall under 40, 41 or 42, they are irrelevant unless there is one exception. It may be relevant if the existence of such a judgment is relevant or is a fact in issue in the instant case. Only then they are relevant, else they are irrelevant. And then finally we are going to section 44, which discuss about fraud or collusion in obtaining judgment or incompetence of the court. So the general rule is that judgment of a competent court shall be binding on the parties operating as res judicata in subsequent proceedings between the same parties. Section 44 contains exceptions to this general rule. According to Section 44, a judgment is liable to be annulled or impeached on the ground of want of jurisdiction, fraud, and collusion. It runs as follows. Any party to a suit or other proceeding may show that any judgment, order, or decree which is relevant under Section 40, 41, or 42 and which has been proved by the adverse party was delivered by a court not competent to deliver it or was obtained by fraud or collusion. So here also we are discussing about section 40, 41 and 42. So if even if it is proved by the adverse party, the party it can be annulled or impeached if it is on the grounds of want for jurisdiction, fraud, or collusion. That is discussed in section 44. So with respect to judgments, we have section 40 to 44. In section 40 we discuss about doctrine of res judicata. Then in section 41 we discuss about judgments in rem, and which is also in conclusive proof, and this is discussed in 4 jurisdictions, that is probate, matrimonial, insolvency, and admiralty. And then we have section 42 which discuss about judgments which does not fall under section 41 here, and is of public nature, public interest. Then here the judgment is not a conclusive proof but admissible and relevant. Then we discuss about section 43 which discuss about that all the judgments which does not fall under section 40, 41 and 42 are irrelevant unless the existence of such a judgment is relevant to the instant case or a fact in issue in the instant case. The only if it is a relevant to the instant case or fact in issue in the instant case, they are relevant. Else, if they do not fall in section 40, 41 and 42, they are irrelevant, with only one exception that is mentioned in section 43. And section 44 is an exception to the general rule of the conclusiveness of the judgment, that the judgments under section 40, 41 and 42 can be challenged on the three grounds, that is want of jurisdiction, that is the competency of the court, and then fraud, and then collusion. That is with judgments section 40 to 44. Lesson 7. Opinions of experts. Opinions of third persons when relevant. The general rule is that opinion of a witness on a question, whether of fact or law, is irrelevant. However, there are certain exceptions to this general rule as provided under section 45 to section 51 of the Indian Evidence Act 1872. So that is from section 45 to section 51. Section 45 to section 51 lay down the provisions relating to opinion of experts or third persons when relevant. Section 45 deals with the opinion of experts. Section 46 deals with the facts bearing upon opinions of experts. Section 47 deals with the opinions as to handwriting when relevant. Section 47A, inserted by Information Technology Act 2000, provides for the opinion as to the digital signature when relevant. Section 48 speaks about opinion as to the existence of right or custom when relevant. Section 49 deals with the opinion as to the usage, tenants, etc. when relevant. Now, Section 50 deals with opinion on relationship when relevant. Finally, Section 51 provides for the grounds of opinion when relevant. Opinions of experts. Section 45. Section 45 of the Indian Evidence Act makes relevant the opinions of experts. An expert is a skillful professional in a particular field, vice, art or trade or science, foreign law, identity of handwriting and finger impression, etc. In other words, an expert is a skillful professional in a particular field capable of possessing specialized knowledge concerning the matter in issue which a common man cannot possess. Example, whether a document or signature is forged or genuine is determined by the opinion of the expert. Similarly, causes of death may be ascertained by post-mortem report issued by an expert. Section 45 defines an expert witness as one who has acquired special knowledge, skill or experience in any science, art, trade or profession. Such knowledge may have been acquired by practice, observation or careful studies. Section 45 runs as follows. When the court has to inform an opinion upon a point, when the court has to form an opinion upon a point of foreign law or of science or art or as to identify identity of handwriting or finger impressions, the opinion upon that point of person specially skilled in such foreign law, science or art, or in the question as to identity of handwriting or finger impressions are relevant facts. Such persons are called experts. Illustrations. The question is whether the death of A was caused by poison. The opinion of the experts as to the symptoms produced by the poison by which A is supposed to have died are relevant. Another illustration, the question is whether A at the time of doing certain act was, by reason of unsoundness of mind, incapable of knowing the nature of the act, or that he was doing what was either wrong or contrary to the law. The opinion of the experts upon the question whether the symptoms exhibited by A commonly show unsoundness of mind, and whether such unsoundness of mind usually renders person incapable of knowing the nature of the acts which they do, or of knowing that what they do is either wrong or contrary to law, are relevant. Now another illustration, the question is whether a certain document was written by A. Another document is produced which is proved or admitted to have been written by A. The opinion of the experts on the question whether two documents are written by the same person or by different persons are relevant. Now, experts' opinion when relevant. According to Section 45 of the Evidence Act, the court refers to the opinion of experts, the person specialized in the person with special skill in foreign law, science, art, or as to the identity of handwriting or finger impression, and the opinions are relevant and admissible. Thus, the opinion of expert witness plays an important role in the matter of evidence and enables the court to arrive at proper conclusions. The expert's opinion is only a piece of evidence and cannot be taken as a substantive piece of evidence, since it is to be judged along with the other evidence. So, this is not a substantive piece of evidence. In other words, expert opinion must corroborate with the other evidence. For instance, report of the handwriting expert is not admissible in evidence in the absence of the formal proof. In Mubarak Ali versus State of Bombay, 1957, Mubarak Ali versus State of Bombay, 1957, the Supreme Court laid down that a witness must confine himself to the fact and not to the state of his opinion. In Raj Kishore versus State, 1969, it was enunciated that expert testimony must be satisfactorily established. It is the court to determine the competence of an expert witness, basing on his qualification, experience, and training, etc. Now, evidentiary value. An expert opinion is only the opinion evidence. It does not have the court in interpretation. This was held in Forest Range Officer versus P. Muhammad Ali. In Forest Range Officer versus P. Muhammad Ali, 1999 case, it was held that an expert opinion is only the opinion evidence. It does not have the court in interpretation. It is relevant under Section 45 of the Evidence Act. Now, it is an accepted principle of law that the science of handwriting was not an accurate one and there was likelihood of error creeping in. When a handwriting expert gives his evidence, such evidence should be received with caution. Now, prerequisites of expert evidence. An expert evidence to be relevant and admissible, the following two conditions are to be fulfilled. The first one, the subject is such that expert testimony is necessary, and the second one, the witness in question is really an expert. Now, facts bearing upon opinions on experts, that is discussed in Section 46. Facts bearing upon opinions of experts. Where an expert opinion is relevant under Section 45, Section 46 makes relevant two types of facts, namely, the first one, facts which support expert opinion, and the second one, facts which are inconsistent with expert opinion. Thus, Section 6 confirms that the opinion of an expert is not conclusive. So, under 46, the facts which support expert opinion and the facts which are inconsistent with expert opinion is both considered. Thus, Section 46 confirms that the opinion of an expert is not conclusive. Section 46 runs as follows. Facts not otherwise relevant are relevant if they support or are inconsistent with the opinion of the experts when such opinions are relevant. Illustration. The question is whether A was poisoned by a certain poison. The fact that the other person who were poisoned by that poison exhibited certain symptom which experts affirm or deny to be symptoms of that poison is relevant. Another illustration, the question is whether an obstruction to a harbor is caused by a certain seawall. The fact that other harbors similarly situated in other respects but where there were no such seawall began to be obstructed at about the same time is relevant. Now, opinions as to handwriting, that is discussed in section 47. Opinions as to handwriting in section 47. Section 47 of the Evidence Act deals with opinions as to handwriting. It runs as follows. When the court has to form an opinion as to the person by whom any document was written or signed, the opinion of any person acquainted with the handwriting of the person by whom it is supposed to be written or signed that it was or was not written or signed by the person is a relevant fact. Explanation. A person is said to be acquainted with the handwriting of another person when he has seen that person write or when he has received documents purporting to be written by that person in answer to documents written by himself or under his authority and addressed to that person, or when in the ordinary course of business document purporting to be written by that person have been habitually submitted to him. Now, illustration. The question is whether a given letter is the handwriting of A merchant in London. B is a merchant in Calcutta who has written letters addressed to A and received letters purporting to be written by him. C is B's clerk whose duty is to examine and file B's correspondence. D is B's broker to whom B habitually submitted the letters purporting to be written by A for the purpose of advising him thereon. The opinions of B, C and D on the question whether the letter is the handwriting of A are relevant, though neither B, C nor D ever saw A write. Now, opinion as to digital signature when relevant. That is discussed under section 47A. Opinion as to digital signature when relevant. When the court has to form an opinion as to the digital signature of any purpose, the opinion of the certifying authority which has issued the digital signature certificate is a relevant fact. The next is opinion as to the existence of right or custom when relevant. That is discussed under section 48. Opinion as to the existence of right or custom when relevant. When the court has to form an opinion as to the existence of any general custom or right, the opinions as to the existence of such custom or right of persons who would be likely to know of its existence if it existed are relevant. Explanation. The expression general custom or right includes customs or rights common to any considerable class of persons. Illustration. The right of the villagers of a particular village to use the water of a particular well is a general right within the meaning of this section. Now, opinion as to usage, tenets, etc. when relevant. When the court, that is discussed in section 49. When the court has to form an opinion as to the following, that is the first one, the usage and tenets of any body of men or family. The second one, the constitution and government of any religion or charitable foundation. Or the third one, the meaning of words or terms used in particular districts or by particular class of people. And the fourth one, the opinions of persons having special means of knowledge thereon are relevant facts. So we discussed four type of facts here, opinions here. That is one, the usage and tenets of any body of men or family. The second one, the constitution and government of any religion or charitable foundation. Or the third one, the meaning of words or terms used in a particular districts or by particular class of people. And the final one, fourth one, the opinions of person having special means of knowledge thereon are relevant facts. Now, opinion on relationship when relevant. That is discussed in section 50. When the court has to form an opinion as to the relationship of one person to another, the opinion expressed by conduct as to the existence of such relationship of any person who as a member of the family or otherwise has special means of knowledge on that subject is relevant fact, provided that such opinion shall not be sufficient to prove a marriage in proceedings under the Indian Divorce Act 1869 or in the prosecution under the sections 494, 495, 497 or 498 of the Indian Penal Code. Illustrations. The question is whether A and B were married. The fact that they were usually received and treated by their friends as husband and wife is relevant. Now the second illustration is The question is whether A was legitimate son of B. The fact that A was always treated as such by members of the family is relevant. Now, the grounds of opinion when relevant, that is section 51, grounds of opinion when relevant. According to section 51, whenever the opinion of any living person is relevant, the grounds on which such opinion is based also are relevant. In other words, mere opinion unaccompanied by its grounds is not admissible. So, mere opinion unaccompanied by its grounds is not admissible. Example, medical expert opinion. Whether the cause of death is by administering a particular poison is not relevant unless it is supported or accompanied by the relevant grounds which enabled him to form such opinion. So that is with opinion of experts or strangers, that is discussed from section 45 to section 51. Section 45 discuss about people, the kind of opinions. Section 45 deals with the opinion of experts. Then section 46 deals with facts bearing upon opinions of experts. Then section 47 deals with the opinion as to handwriting. And section 47A, which is inserted by Information Technology Act 2000, deals with the opinion as to digital signature. Now, section 48 speaks about opinion as to existence of right or custom. Section 49 deals with the opinion as to usage, tenants, etc. And section 50 deals with the opinion on relationship. And section 51 provides for grounds of opinion. That is with lecture 7, opinion of experts. Lecture 8, character when relevant. The provisions for evidence on character given in the Indian Evidence Act 1872 may be divided into two parts. That is, evidence about the character of witness, and the second one, evidence about the character of the parties to the proceeding. Now, sections 140, 146, 148, 153 and 155 of the Act deals with the character of witness, and section 52 to 55 provide for character of parties to the proceeding. So, sections 140, 146, 148, 153 and 155. Once again, 140, 146, 148, 153 and 155 deals with the character of a witness, and section 50 to 55 deals with character of parties to the proceeding. Section 50 to 55 of the Act lay down the provisions relating relevancy of character. So, the character of parties to a proceeding may be relevant under the sections 52 to 55. The evidence of character may be tendered against or in favor of any person in his capacity as a witness or as a party to the proceeding. The word character denotes the collective qualities or characteristics, especially mental and moral, that distinguish person or thing. The word character has been defined in section 55 of the Evidence Act. It includes both reputation and disposition, but except as provided in section 54, evidence may be given only of general reputation and general disposition, and not of particular acts by which reputation or disposition were shown. Now, so once again, character is defined in section 55, and it includes general reputation and disposition, general disposition. In civil cases, character to prove conduct imputed irrelevant. That is section 52. Section 52 of the Evidence Act says that character evidence is irrelevant unless such character evidence is itself in issue. In civil proceedings, the evidence of a good character or bad character is not going to help the court in deciding the matters in issue. Section 52 runs as follows. In civil cases, the fact that the character of any person concerned is such as to render probable or improbable any conduct imputed to him is irrelevant, except in so far as such character appears from facts otherwise relevant. Relevancy of character in criminal cases, that is discussed in section 53. So in 52 we saw that character is irrelevant in civil cases unless the character itself is in question. That is with respect to civil cases in section 52, and now relevancy of character in criminal cases is discussed in section 53. According to section 53, the evidence 3 of the Evidence Act, in criminal proceedings, the fact that the person accused is of good character is relevant. The innocence or criminality of an accused can easily be judged by basing on his character. Now, evidence of character or previous sexual experience not relevant in certain cases. Evidence of character or previous sexual experience not relevant in certain cases, that is discussed in section 53A. In a prosecution for an offence under section 354, section 354A, section 354B, section 354C, section 354D, section 376, section 376A, 376B, 376C, 376D or 376 of IPC, that is with respect to outreaching the modesty of a woman, voyeurism, stalking, etc., along with the different kinds of rape, different categories of rape. For prosecution under these offences, for attempt to for the commission or attempt of any of such offences where the question of consent is an issue, evidence of character of the victim or of such person's previous sexual experience with any person shall not be relevant on the issue. It shall not be relevant on the issue of such consent or quality of consent. Now, previous bad character irrelevant, that is also said in section 54. So, section 54 says that previous bad character not relevant except in reply. It reads as follows: in criminal proceedings, the fact that the accused person has a bad character is irrelevant unless evidence has been given that he has a good character, in which case it becomes relevant. So, if it is shown that the person has a good character, it is relevant. So, to prove that the person has a bad character is irrelevant unless it is shown to disprove and claim that the person accused have a good character. Now, explanation 1 to section 54. This section does not apply to cases in which the bad character of any person is itself a fact and issue. Explanation 2. A previous conviction is relevant. The previous conviction is relevant as evidence of bad character. Now, character as affecting damages, section 55. In civil cases, the fact that the character of any person is such as to affect the amount of damages which he ought to receive is relevant. Especially in case of defamation or libel, this can be considered. So, in explanation, in section 52, 53, 54 and 55, the word character includes both reputation and disposition, but except as provided in section 54. Evidence may not be given only of general reputation and general disposition, and not of the particular acts by which reputation or disposition were shown. So, that is with lecture 8, character when relevant. It is discussed in two category, that is the character of the parties to the suit and character of the witness. In section 52 to 55, we are discussing about character of parties to the suit. Character of witness is discussed in 140, 146, 148, 153 and 155. So, relevancy of facts is discussed from section 5 to 55. And character under relevancy of character, which is with respect to parties of the suit, is discussed from section 52 to 55, and that is with relevancy of facts. So, the Indian Evidence Act is divided into three parts. The first part dealt with the relevancy of facts. The second part deals with the proof, and the third part deals with the effect of the evidence and the proof. So, by discussing till section 55, we have covered the part 1 relating to the relevancy of fact. Now we are moving on with the part 2, that is on proof. The part 2 of the Indian Evidence Act contains sections 56 to section 100 under chapter 3 to 6 and lays down the provisions relating to the proof of facts. Now, chapter 3 contains sections 56 to 58 and it deals with facts which need not be proved. Chapter 4 containing sections 59 to 60 provides for proof of facts by oral evidence. Now, chapter 5 comprising of section 61 to 90A deals with the documentary evidence. Chapter 6 containing sections 91 to 100 provides for of the exclusion of oral by documentary evidence. So, Here chapter 3, 4, 5 and 6 is discussed under part 2, that is proof, that is sections 56 to section 100. So in lecture 9 we are going to discuss about facts which need not be proved. The general principle or rule of law of evidence is the party to the suit must prove his case producing oral or documentary evidence. Part 2 of the Evidence Act deals with the manner in which facts received in evidence under Part 1 may be given in evidence, or how it can be proved. The party who wishes the court to believe in the existence of a fact must prove it. However, exceptions to this general rule are provided under Chapter 3 of the Evidence Act, that is, facts that need not be proved. Now, Chapter 3, containing sections 56 to 58 of the Indian Evidence Act 1872, lays down provisions relating to facts which need not be proved. Section 56 says that facts judicially noticeable need not be proved. Now, section 57 says that the facts in respect of which court must take judicial notice need not be proved. According to section 58 of the Act, facts admitted need not be proved. So, facts that are judicially noticeable need not be proved. Facts in respect of which court must take judicial notice need not be proved, and facts admitted need not be proved. So, these are the three situations where the it shall not be need not be proved. The fact need not be proved. That is discussed in 56, 57 and 58. Now, fact judicially noticeable need not be proved under section 56. According to section 56 of the Evidence Act, facts which court will take judicial notice need not be proved by the parties to any proceeding. The expression judicial notice means notice or recognition of the truth of the facts taken by a judge which do not require proof by any evidence. Section 56 runs as follows. No fact of which the court will take judicial notice need be proved. Section 56 declares that no fact of which court will take judicial notice need be proved. In other words, the court is bound to take notice of particular fact. The parties are spared of the burden of proving that fact. It is the part of the judicial function, and the court is bound to know the law of the land. Example, the court can take judicial cognizance of the fact that a particular area is a terrorist-stricken area. So that was held in Abdul Malik versus State of UP. Abdul Malik versus State of UP 1994. The court can take judicial cognizance of the fact that a particular area is a terrorist-stricken area. Now, another example is when the law and order situation has deteriorated in the country and was fast worsening, judicial notice can be taken of that while considering abolition of capital punishment. The capital punishment is to be awarded in the rarest of the rarest case. So this was discussed in Srimati Shashi Nair versus Union of India. That is Srimati Shashi Nair versus Union of India 1992. It was held that when the law and order of a situation has deteriorated in the country and was fast worsening, judicial notice can be taken of that while considering abolition of capital punishment. The capital punishment is to be awarded in the rarest of the rarest cases. Now, facts of which the court must take judicial notice. So, in 56, we discussed about facts which are judicially noticeable, and in 57, we are discussing the facts of which court must take judicial notice. So, section 56 of the Evidence Act contains the list of facts of which the court is bound to take judicial notice and is stated as below. There are 5 situations mentioned here. 1. All laws in the force in the territory of India. 2. All acts of the British Parliament and all local and personal acts directed by the British Parliament to be judicially noticed. Now, 3. Articles of war for the Indian Army, Navy or Air Force. Now, the 4th, the course of proceedings of British Parliament, of the Constituent Assembly of India, and of Parliament and legislatures established under any law in force in India. Now, the 5th one is the accession and sign manual of the sovereign of the United Kingdom and Ireland. The accession and the sign manual of the sovereign of the United Kingdom and Ireland. Now, the 6th one, all seals of which English courts take judicial notice. The seals of all the courts in India and of all the courts outside India established by the authority of the central government or the crown representative, the seals of the courts of the Admiralty and Maritime Jurisdiction, and of notaries public, and all seals which any person is authorized to use by the Constitution or an Act of the Parliament of the United Kingdom or an Act of the regulation having force of law in India. Now, the seventh one, the accession of or to office, names, titles, functions, and signatures of gazetted offices. Now, the national flag of every country recognized by the Government of India. 9. The division of time, the geographical division of the world, and the public festivals, facts, and holidays notified in the official gazette. Now, 10. The territories under the dominion of the Government of India. The 11th, the commencement, continuance, and termination of war between Government of India and any other country. 12. The names of the countries of the names of the court officials and of all advocates, etc., authorized by law to appear or act before the court. 13. The rule of the road on land or at sea. Now, effect of judicial notice. Judicial notice is not conclusive proof of fact judicially noticed. So, judicial notice is not conclusive proof of facts judicially noticed. Matters may be disproved even after they are taken judicial notice of. So, next one, facts admitted need not be proved. That is in section 58. So, section 58 of the Evidence Act lays down the facts admitted need not be proved. Evidence is to be given to prove the facts which are disputed. So, in all this case, the evidence is to be given only if they are disputed, else it need not be proved. If the facts are admitted by the other or opposite party, such facts are no longer in issue and hence need not be proved. Section 58 runs as follows. No fact need be proved in any proceeding which the parties thereto or their agents agree to admit at the hearing, or which before the hearing they agree to admit by any writing under their hands, or which by any rule of pleading in force at the time they are deemed to have admitted by their pleadings, provided that the court may in its discretion require the facts admitted to be proved otherwise than by such admissions. So, the court still has a discretion here. The court may require the facts be proved. Now, section 58 classifies the judicial admissions which require no proof into the following. That is a 3 scenario. Facts which parties or their agents agree to admit at the hearing. Now, facts which before the hearing they agree to admit in writing, and facts which they are deemed to have admitted by rules of the pleading. So, that is with facts that need not be proved under part 2 and chapter 3, 56, 58, 56, 57 and 58, chapter 3 of part 2. That is facts which need not be proved. Now, the next one we have is lecture 10, that is of oral evidence. Now, chapter 4 containing sections 59 and 60 of the Indian Evidence Act lays down the provisions relating to oral evidence. Section 59 provides for proof of facts by oral evidence. Section 60 says that oral evidence must be direct. So, under chapter 4, we have only 2 sections, that is 59 and 60. And it is related to oral evidence. Now, section 59 provides for proof of facts by oral evidence. Section 60 says that oral evidence must be direct. Evidence may be classified into oral evidence and documentary evidence. Oral evidence. The term oral signifies by word of mouth. Oral evidence literally means the evidence which is confined to words spoken by mouth. It is a fact brought to the knowledge of the court by the verbal statement of a witness qualified to speak on that point. However, a witness who is unable to speak is permitted and considered as competent to give evidence in any manner in which he can make it intelligible. Verbal statement includes signs and gestures, and this was held in R versus Abdullah. This case has already been discussed, where Abdullah, the accused, slit the throat of Dulari, the prostitute, with a prostitute with a razor blade, and she was brought to the hospital, where she was the statements were taken by the police officer in the presence of magistrate and the victim's mother. So she couldn't talk, so she used gestures and signs to reply to the questions of the police officer and the magistrate. So that is the case where R versus Abdullah, and that is a 1885 case. So here it was held that verbal statements include signs and gestures. Now, section 3 of the Evidence Act defines oral evidence as oral evidence means and includes all statements which the court permits or requires to be made before it by witnesses in relation to matter of a fact under inquiry. So, Section 3 of the Evidence Act defines oral evidence, and oral evidence means and includes all statements which the court permits or requires to be made before it by witnesses in relation to matters of fact under inquiry. Now, proof of facts by oral evidence, that is discussed under Section 59. Section 59 says that all facts except the contents of the documents or electronic records may be proved by oral evidence. The words electronic records was inserted by Information Technology Act 2000 with effect from 17th October 2000. Now, importance of oral evidence. This section lays down that where a written document exists, they shall be produced as being the best evidence of their own contents, and no oral evidence can be adduced to prove as to what is wrong in the document. While receiving oral evidence, great care must be exercised. The court must sift the evidence, separate grain from chaff, and accept what it finds to be true and reject the rest. So, while receiving oral evidence, great care must be exercised. The court must sift the evidence, separate the grain from chaff, and accept what it finds to be true and reject the rest. The real test for accepting or rejecting the evidence is A. How consistent the story is with itself. B. How it stands the test of cross-examination. C. How far it fits in with the rest of the evidence and circumstances of the case. So, 3 tests is used for the accepting or rejecting of the evidence. The first one is how consistent the story is with itself, and B. How it stands the test of cross-examination, and C. How far it fits with the rest of the evidence and circumstances of the case. Now, falses in uno, falses in omnibus. That's a maxim. Falses in uno, falses in omnibus. So, this maxim means that evidence that is false in one particular is false in all. So, that is a presumption of the court that an evidence that is false in one particular is false in all. The maxim is not a mandatory rule and is dangerous to apply. Wigmore criticized it as worthless. There is always a fringe of embroidery of story, however true in the main. The whole of the evidence should not be rejected merely for the want of veracity on some minor point. So, the whole of the evidence should not be rejected merely for want of veracity on some minor point, for it would only lead to miscarriage of justice. The Indian courts therefore treated it as merely a rule of caution affecting the weight of evidence only. So, it is only taken as a caution. This maxim is taken only as a caution and not blindly applied by Indian courts. That is falses in uno, falses in omnibus, which means that if it is false in one particular, it is false as a whole. Now, admissibility of tape recorded statement as oral evidence. So, the majority of the Supreme Court in Pratap Singh versus State of Punjab 1964. Pratap Singh versus State of Punjab 1964 held that tape recordings are not inadmissible merely on the ground of possibility of them being tampered with. Raghubar Dawal and Mudholkar JJ held that tape recorded conversation can only be corroborative evidence but cannot be direct or primary evidence that the third person stated what the other speaker had told. They observed, however, that weight to be given to such evidence will be depend on their factors which may be established in particular case. In case of blackmail, bribery, threats, inducements to commit a crime, a sedition, there cannot be better evidence than the spoken words transcribed on tape. So, in case of blackmail, bribery, threats, inducements to commit a crime, a sedition, etc., there cannot be a better evidence than the spoken words transcribed on the tape. It is something like photograph of the offender caught red-handed while committing the act of murder or housebreaking. Now, a tape recorded conversation is admissible in evidence provided the court is satisfied that there was no tampering, dubbing and imperfect recording. So, that is with chapter 4 oral evidence, which is dealt in section 59 and 60. 59 provides for the proof of the facts by oral evidence, and section 60 says the oral evidence must be direct. Hearsay evidence is brought under section 60. That we discussed that oral evidence must be direct, that is held in section 60, and hearsay evidence thus comes under section 60. Oral evidence must be direct. Evidence may be given by witness. Evidence given by the witness may be oral or documentary. Section 60 of the Evidence Act says that oral evidence to be admissible, it must be direct. In other words, hearsay evidence is no evidence. A statement, oral or written, by a person not called as witness comes under the general rule of hearsay. Section 60 reads as follows: oral evidence must, in all cases whatever, be direct. That is to say, if it refers to a fact which could be seen, it must be the evidence of a witness who says he saw it. If it refers to a fact which could be heard, it must be the evidence of a witness who says he heard it. If it refers to a fact which could be perceived by any other sense or in any other manner, it must be the evidence of a witness who says he perceived it by that sense or in that manner. If it refers to an opinion or to the grounds on which that opinion is held, it must be the evidence of the person who holds that opinion on those grounds, provided that the opinions of experts expressed in any treatise commonly offered for sale and the grounds on which such opinions are held may be proved by the production of such treatise if the author is dead or cannot be found or has become incapable of giving evidence or cannot be called as witness without an amount of delay or expense which the court regard as unreasonable. Provided also that if the oral evidence refers to the existence or condition of any material thing other than a document, the court may, if it thinks fit, require the production of such material thing for its inspection. As stated above, the fundamental principle of the of law of evidence is hearsay evidence must not be admitted. Hearsay evidence is also known as derivative or second-hand or unoriginal evidence. So, hearsay evidence is also known as derivative or second-hand or unoriginal evidence. It is the evidence of facts which the witness has not learnt through his own bodily senses but learnt through the medium of others. It is regarded as ambiguous and misleading and hence inadmissible. Example: A is being tried for stealing B's cycle. C, as witness, says that C heard D saying that D saw A with B's cycle. In this example, the testimony of C is hearsay evidence. Definition: Taylor: all the evidence which does not derive its value solely from the credit given to the witness himself, but which rests also in part on the veracity and competence of some other person. Now, the definition of Bentham: the supposed oral testimony transmitted through oral, supposed orally delivered evidence of a supposed extrajudicial narrating witness, judicially delivered viva voce by the judicially deposing witness. Now, hearsay evidence means whatever a person has heard to say. It includes 1. A statement made by a person not called as witness, and 2nd, a statement contained or recorded in a book, document or record which is not admissible. So, direct evidence conditions. Section 60 defines direct evidence. Evidence is said to be direct in the following conditions, if the following conditions are satisfied. So, the first one, if it refers to a fact which could be seen, the evidence must be of a witness who saw it. The person who witnessed it himself must give the evidence. Suppose A is stabbed in the presence of B, who tells this fact to C. If B is called as witness to prove the fact of stabbing, his evidence would be direct. But if C is called, his evidence would be indirect or hearsay. Now, the second condition, if it refers to a fact which could be heard, it must be the evidence of a witness who heard it. Suppose A, who was being murdered in the house at night, cried that B was killing him. C, a neighbor, heard cries and told D in the morning. Evidence of C will be direct, but that of D will be hearsay. Now, the third condition, If it refers to a fact which could be perceived by any other sense or in any other manner, it must be evidence of the witness who himself perceived it by that sense or in that manner. Many facts may be perceived by other senses than other senses than eyes and ears. Whether a gun was fired can be known by touching and smelling it soon after it is fired. The fact that it was hot and smelt gunpowder can be proved by him who touched or smelled it, but not by any other person whom he told this fact. Now, the fourth condition, if it refers to an opinion or to the grounds on which that opinion is held, it must be the evidence of the person who holds that opinion on those grounds. Where in case of a murder, the doctor on the basis of certain symptoms opines that is of the opinion that the death was caused by strangulation or by poison, etc. The evidence of such opinion and symptoms would be direct if given by the doctor who examined the dead body. The hearsay witness may not be able to say correctly and completely the truth of his statement. Now, reasons for exclusion of hearsay evidence. No single reason can be assigned for its exclusion. The reasons for its exclusion generally given are the following. That is, the evidence is not given on oath or under personal responsibility by the original declarant. Second one, it cannot be tested by cross-examination. Third, it supposes some better evidence and encourages substitution of weaker for stronger evidence. The fourth one, it has a tendency to protract or prolong legal investigation. The fifth one, it is intrinsically weak. The sixth one, as truth depreciates in the process of repetition, it is not reliable. Seventh one, its reception will increase opportunities of fabrication. Now, the exceptions. So, general rule is that hearsay evidence is no evidence. Now, we are going to the exceptions. The Indian Evidence Act provides for certain exceptions to this general rule. Hearsay evidence is no evidence. In other words, hearsay evidence is admissible in the following cases. 1. Res gestae, that is discussed in section 6, statements forming part of the same transaction. And the second one is admissions and confessions, that is discussed in section 17 to 23, that is admissions, and 24 to 30, that is confession. Now, third one is statement by a person who cannot be called as witness. So that includes dying declaration. Now, evidence given in formal proceeding, that is discussed in section 33. Now, entries in the book of accounts kept in the ordinary course of business, that is discussed in section 34. And statements in public documents, that is discussed in section 35. Now, opinion of the experts, that is discussed in sections 45 to 51. Now, statement contained in public document, that is discussed in section 77. And learned treatise, that is proviso of section 60. So, these are the exceptions for hearsay evidence, where hearsay evidence is admissible is the following these sections, that is section 6, res gestae, section 17 to 30, that includes admission and confession. Now, section 32, that is dying declaration. Section 33, evidence given in formal proceedings. Section 34, entries of the book of accounts kept in ordinary course of business. If it is some statements contained in a public document, it's section 77. Now, section 35, statements in public documents. So, for ordinary entries in the books of accounts kept in ordinary course of business is section 34. Statements in public documents is section 35. And statements contained in public documents is section 77. Now, opinion of the experts is discussed in section 45 to 51. And learned treatises, that is proviso of section 60. So, part 2 of the Indian Evidence Act 1872 deals with the kinds of proof, and that is discussed in chapter 3, 4, 5 and 6. Now, we already discussed chapter 3 and 4. Now, we are going to discuss about chapter 5, that is of documentary evidence. And this is one of the largest chapter in part 2, extending from section 61 to 90A, that is of documentary evidence. So, lecture 11, documentary evidence. Now, section 61 to 90A of Indian Evidence Act 1872 lays down the provisions relating to of documentary evidence. Section 61 deals with proof of contents of documents. Section 62, with primary evidence. Section 63 deals with secondary evidence. Section 64 deals with proof of documents by primary evidence. Then section 65 deals with cases in which secondary evidence relating to documents may be given. Section 65 deals with special provisions as to evidence relating to electronic record. Section 65 deals with cases in which secondary evidence relating to documents may be given. Under section 65, we have 65 capital A and 65 capital B. 65 capital A deals with special provisions as to evidence relating to electronic record. Section 65B deals with admissibility of electronic records. Section 66 deals with rules as to notice to produce. Now section 67 deals with proof of signature and handwriting of persons alleged to have signed or written document produced. Now we have 67 capital A, which deals with the proof as to digital signature. Then section 68, which deals with the proof of execution of documents required by law to be attested. Now section 69 deals with proof where no attesting witness found. Section 70 deals with admission of execution by party to attested document. Now section 71 deals with proof when attesting witness denies the execution. Section 72 deals with proof of documents not required by law to be attested. Now section 73 deals with comparison of signature, writing or seal with other admitted or proved. Section 73A capital A deals with proof as to verification of digital signature. So now section 74 to 78 lays down the provisions relating to public documents. So section 61 to 90A in general deals with documentary evidence. We already looked into read about the general rules, that is from section 61 to 73A. Now section 74 to section 78 lay down provisions relating to public documents. So these sections are in specific to public documents. So section 74 deals with public documents. Section 75 deals with private documents. Section 76 deals with certified copies of public documents. And section 77 deals with proof of documents by production of certified copies. Now section 78 deals with proof of other official documents. And then sections 79 to 90A lays down the provisions relating to presumptions as to our documents. Section 79 deals with presumptions as to genuineness or of certified copies. Section 80 deals with presumption as to documents produced as record of evidence. Section 81 deals with presumption as to gazette, newspapers, private acts of parliament, and other documents. Section 81 capital A deals with presumption as to gazettes in electronic form. Section 82 deals with the presumption as to documents admissible in England without proof of seal or signature. Section 83 deals with presumption as to maps or plans made by authority of government. Section 84 deals with presumption as to collection of law and reports and decisions. Section 85 deals with the presumption as to the powers of attorney. Section 85 capital A deals with the presumption as to electronic agreements. Section 85B deals with presumption as to electronic records and digital signatures. Section 85 capital C deals with the presumption as to digital signature certificates. Section 86 deals with presumption as to certified copies of foreign judicial records. Section 87 deals with the presumption as to books, maps and charts. Section 88 deals with the presumption as to the telegraphic messages. Section 88 capital A deals with presumption as to electronic messages. Section 89 deals with presumption as to the due execution etc. of documents not produced. Section 90 deals with presumption as to documents 30 years old. Section 90 capital A deals with presumption as to the electronic records 5 years old. So that is what these sections deals with. And now let's look into detail, that is what is primary and secondary evidence. Section 61 of the Evidence Act deals with the proof of contents of documents. it provides that the contents of documents may be proved either by primary or secondary evidence. Section 62 and 64 deals with primary evidence, while section 63 and 65 deals with section 63, 65 and 66 deals with secondary evidence. So 62 and 64 deals with primary evidence, 63, 65 and 66 deals with secondary evidence. So primary evidence. According to section 62 of the Evidence Act, primary evidence means the document itself produced for the inspection of the court. Primary evidence is that which the law requires to be given first, and the secondary evidence is that such can be given in the absence of the primary evidence. For example, A sold his house to B for 50,000 and executes registered sale deed. In a dispute as to the title, if B produces before the court the sale deed, it is primary evidence. Primary evidence is considered as the best evidence since it provides proof with certainty. That is why law insists or requires first the primary evidence. The document may be in counterparts, then each counterpart is regarded as primary evidence. If the documents are made by uniform process like printing or lithography, each is the primary evidence. Now section 62 runs as follows. Primary evidence means the document itself produced for the inspection of the court. Explanation 1. Where a document is executed in several parts, each part is primary evidence of the document. Where a document is executed in counterparts, each counterpart being executed by one or some of the parties only, and each counterpart is primary evidence as against the parties executing it. Now explanation 2. Where a number of documents are all made by one uniform process, as in case of printing, lithography or photography, each is primary evidence of the contents of the rest. But where they are all copies of a common original, they are not primary evidence of the contents of the original. Illustration. A person is shown to have been in possession of a number of placards, all printed at one time from one original. Any one of the placards is primary evidence of the contents of any other, but no one of them is primary evidence of the contents of the original. Now, proof of documents by primary evidence, that is discussed in section 64. Section 64 embodies one of the underlying principles of the law of evidence, that the best evidence must be given in all cases. The other two underlying principles are evidence must be confined to the matter in issue and hearsay evidence must not be admitted. Hearsay evidence is no evidence. Section 60 and 91 are also based on the rule underlying this principle. Based on this rule or underlying principle that the best evidence must be given in all cases, that is section 60 and 91. Now section 64 runs as follows. Documents must be proved by primary evidence except in the case hereinafter mentioned. Now, secondary evidence. Sections 63, 65 and 66 deals with secondary evidence. It is also known as inferior or substituted evidence. It indicates the existence of more original sources of information. It may be given in the absence of a better or primary evidence if proper explanation is given for such absence. According to section 63, copies made and compared with the originals or photostat copies may be treated as secondary evidence. Section 63 runs as follows. Secondary evidence means and includes 1. Certified copies given under the provisions hereinafter contained. 2. Copies made from the original by mechanical processes which in themselves ensure the accuracy of the copy, and copies compared with the subject. 3. Copies made from or compared with the original. 4. Counterparts of the documents as against the parties who did not execute them. Now the fifth one, oral accounts of the contents of a document given by some person who has himself seen it. So these 5 can secondary evidence means and include either of these 5. Now we have few illustrations. The first one, a photograph of an original is secondary evidence of its contents. though the two have not been compared, if it is proved that the thing photographed was the original. Another illustration. A copy compared with a copy of a letter made by a copying machine is secondary evidence of the contents of the letter if it is shown that the copy made by the copying machine was made from the original. Another illustration. A copy transcribed from a copy but afterwards compared with the original is secondary evidence, but the copy not so compared is not secondary evidence of the original, although the copy from which it was transcribed was compared with the original. Another illustration. Neither an oral account of a copy compared with the original nor an oral account of a photograph or machine copy of the original is secondary evidence of the original. So, cases in which secondary evidence relating to documents may be given, that is discussed in section 65. Section 65 provides for the circumstances in which the secondary evidence is admissible as detailed below. 7 circumstances are discussed here. 1. The person in possession of the original is not within the reach of the court. 2. If the original is in the possession of the opposite party. 3. If the original is lost. 4. When the original deed had already been admitted in the court. 5. If the original is a public document. 6. When the original is not easily movable. And 7. When the original consists of many accounts. Now, special provisions as to evidence relating to electronic records, that is laid down in section 65 capital A. Now, the contents of the electronic records may be proved in accordance with the provisions in 65B. So, with respect to electronic records, we have to consider 65A and 65B. Now, admissibility of electronic records, that is discussed in section 65B. Notwithstanding anything contained in this act, any information contained in an electronic record which is printed on a paper, stored, recorded or copied in optical or magnetic media produced by a computer, hereinafter referred to as computer output, shall be deemed to be also a document if the conditions mentioned in the computer in question, and shall be admissible in any proceeding without further proof or production of the original as evidence of any contents of the original or of any fact stated therein of which direct evidence would be admissible. That is the para 1 of section 65B. And then in para 2, we have the conditions referred to in subsection 1 in respect of a computer output shall be the following, namely A. The computer output containing the information was produced by the computer during the period over which the computer was used regularly to store or process information for the purpose of any activities regularly carried on over the period by the person having lawful control over the use of computer. B. During the said period, information of the kind contained in the electronic record or of the kind from which the information so contained is derived was regularly fed into the computer in the ordinary course of the said activities. C. Throughout the material part of the said period, the computer was operating properly, or if not, then in respect of any period in which it was not operating properly or was out of operation during that part of the period, was not as such as to affect the electronic record or the accuracy of its contents. And the last one, the information contained in the electronic record reproduces or is derived from such information fed in the computer in the ordinary course of the said activities. So that is said in the second para. Now, wherever any period, the function of storing or processing information for the purpose of any activities regularly carried on over that period is mentioned in clause A of subsection 2, was regularly performed by computers whether A. by combination of computers operating over that period, or by different computers operating in succession over that period, or by different combinations of computers operating in succession over that period, or in any other manner involving the successive operation over that period in whatever order of one or more computers and one or more combination of computers. All the computers used for that purpose during that period shall be treated for the purpose of this section as constituting a single computer, and reference in this section to a computer shall be construed accordingly. Now, the fourth para, in any proceeding where it is decided to give a statement in evidence by virtue of this section, a certificate doing any of the following things, that is to say, A. Identifying the electronic record containing the statement and describing the manner in which it was produced. B. Giving such particulars of any device involved in the production of that electronic record as may be appropriate for the purpose of showing that the electronic record was produced by computer. Or C. Dealing with any of the matter to which the conditions mentioned in subsection 2 relate, and purporting to be signed by a person occupying a responsible official position in relation to the operation of the relevant device or management of the relevant activities, whichever is appropriate, shall be evidence of any matter stated in the certificate, and for the purpose of this section, it shall be sufficient for a matter to be stated to the best of the knowledge and belief of the person stating it. Now, fifth para. For the purpose of this section, A. Information shall be taken to be supplied to a computer if it is supplied thereto in any appropriate form, and whether it is supplied directly or without human intervention by means of any appropriate equipment. B. Whether in the course of activities carried on by any official, information is supplied with a view to its being stored or processed for the purposes of those activities by a computer operated otherwise than in the course of those activities. That information, if duly supplied to that computer, shall be taken to the supply to it in the course of those activities. And C. A computer output shall be taken to have been produced by a computer, whether it was produced by it directly or without human intervention by means of any appropriate equipment. Now, the explanation to this section is that for the purpose of this section, any reference to information being derived from other information shall be a reference to its being derived therefrom by calculation, comparison, or any other process. So, this is with respect to section 65B. So, 65A and 65B deals with the electronic record, and 65B discuss about the admissibility of electronic record with 5 paragraphs and 1 explanation, which has kept in detail about how the electronic record shall be, in which manner it should be, what is the appropriate form in which it is fed to the computer, and what is the kind of computer, and the official, and about the certificates to prove the veracity of this document. This is all discussed in section 65B, that is with admissibility of electronic record. Electronic records is discussed with respect to 65A and 65B. Now, rules as to notice to produce, that is section 66. Rules as to notice to produce. Section 66 lays down the procedure to be followed in admitting secondary evidence as allowed by section 65. Before resorting to secondary evidence under section 65, subclause A notice to produce the original, section 65A, a notice to produce the original must be served on the person in whose power and possession the original is. Section 65, which insists notice, runs as follows. Now, we are going to read about section 65, which insists notice, runs as follows. Secondary evidence of the contents of the document referred to in section 65 clause A shall not be given unless the party proposing to give such secondary evidence has previously given to the party in whose possession or power the document is, or to his attorney or pleader, such notice to produce it as prescribed by law. And if no notice is prescribed by law, then such notice as the court considers reasonable under the circumstances of the case, provided that such notice shall not be required in order to render secondary evidence admissible in any of the following cases, or in other cases in which the court thinks it fit to dispense with it. Now, the case scenarios discussed here is six situations. The first one, when document to be proved is itself a notice. When, from the nature of the case, the adverse party must know that he will be required to produce it. 3. when it appears or is proved that the adverse party has obtained possession of the original by fraud or force. 4. When the adverse party or his agent has the original in court. 5. When the adverse party or his agent has admitted the loss of the document. 6. When the person in possession of the document is out of reach or not subject to the process of the court. Now, exceptions. Following are the exceptions. Following are the circumstances in which notice under section 66 is not necessary. The 6 exceptions are discussed here. The first one, when the document to be proved is itself a notice. When from nature of the case the adverse party must know that he will be required to produce it. 3. When it appears or is proved that the adverse party has obtained possession of the original by force or fraud. 4. When the adverse party or his agent has the original in court. 5. When the adverse party or his agent has admitted the loss of the document. 6. When the person in possession of the document is out of reach or not subject to the process of the court. That is the 6th situation discussed as exception. Now, other than these exceptions, the court may also dispose of with the necessity of serving a notice if it deems fit or reasonable. Now, distinction between primary evidence and secondary evidence. Following are the notable points of distinction between primary and secondary evidence. So, primary evidence is the main source of evidence, whereas secondary evidence is an alternative source of evidence. Section 62 of the Evidence Act defines primary evidence, and Section 63 of the Evidence Act defines secondary evidence. Now, primary evidence means the document itself produced for the inspection of the parts of the documents, etc. Now, secondary evidence means and includes the documents or testimonials other than the original document, that is, certified copies, photostat copies, counterparts of the documents, etc. Now, primary evidence itself is admissible. Secondary evidence is admissible in the absence of primary evidence. Now, proof of signature and handwriting of a person alleged to have signed or written document produced, that is discussed in section 67. If a document is alleged to be signed or to have been written wholly or in part by any person, the signature or the handwriting of so much of the document as is alleged to be in the person's handwriting must be proved to be in his handwriting. Now, the next is proof as to the digital signature, that is discussed in section 67 capital A. Except in the case of secure digital signature, if the digital signature of any subscriber is alleged to have been affixed to an electronic record, the fact that such digital signature is the digital signature of the subscriber must be proved. Now, the next one we have is proof of execution of document required by law to be attested, that is section 68. If a document is required by law to be attested, it shall not be used as evidence until one attesting witness, at least one attesting witness has been called for the purpose of proving its execution, if there be an attesting witness alive and subject to process of court and capable of giving evidence, provided that it shall not be necessary to call an attesting witness in proof of the execution of any document, not being a will which has been registered in accordance with the previous provisions of the Indian Registration Act 1908, unless its execution by the person by whom it purports to have been executed is specifically denied. Now, so what it says is that we have to call at least one attesting officer to the court for the proving of the execution. Now, in the proviso, it is said that unless it is a will, so provide that it shall not be necessary. So it is not necessary to call a attesting witness except in the case of will to call a attesting witness if the instrument is registered under Indian Registration Act 1908. And yet there is another exception here. If the instrument is registered under Registration Act 1908, still we will need to call an attesting witness if the person who claims to have purported the instrument has denied it. Only in that case we have to call it is necessary to call an attesting witness, and please note it is not with respect to will. It is respect to other documents registered in accordance with the Indian Registration Act 1908. And if the purporter of the maker or the maker has denied it, then a witness is called upon. Now, proof where no attesting witness found. Section 69. If no such attesting witness can be found, or if the document purports to have been excluded in the United Kingdom, it must be proved that the attestation of one attesting witness at least is in his handwriting, and the signature of a person executing the document is in the handwriting of that person. Now, admission of execution by party to attested document. Admission of execution by party to attested document. Section 70. The admission of a party to an attested document of its execution by himself shall be sufficient proof of its execution as against him, though it be a document required by law to be attested. Now, proof when attesting witness denies the execution. That is discussed in section 71. Proof when attesting witness denies the execution. If the attesting witness denies or does not recollect the execution of documents, its execution may be proved by other evidences. Now, proof of document not required by law to be attested. That is in section 72. Proof of document not required by law to be attested. An attested document not required by law to be attested may be proved as if it was unattested. Now, comparison of signature, writing or seal with other admitted or proved. That is in section 73. The comparison of signature, writing or seal with others admitted or proved. In order to ascertain whether a signature, writing or seal is that of the person by whom it purports to have been written or made, any signature, writing or seal admitted or proved to the satisfaction of court to have been written or made by that person may be compared with the one which is to be proved, although that signature, writing or seal has not been produced or proved for any other purpose. The court may direct any person present in the court to write any words or figures for the purpose of enabling the court to compare the words or figures so written with any words or figures alleged to have been written by such person. This section applies also with any necessary modifications to finger impressions. Now, proof as to the verification of digital signature, that is discussed in section 73A. Proof as to the verification of digital signature. In order to ascertain whether a digital signature is that of the person by whom it purports to have been affixed, the court may direct A. the person or the controller of certifying authority to produce the digital signature certificate, and B. any other person to apply the public key listed in the digital signature certificate and verify the digital signature purported to have been affixed by that person. Now, explanation to 73A. For the purpose of this section, controller means the controller appointed under subsection 1 of section 17 of Information Technology Act. That is, controller appointed under section 17 subclause 1 of Information Technology Act 2000. Now, public and private documents. According to section 3 of the Indian Evidence Act 1872, documentary evidence means and includes all documents produced before the court for its inspection. Such documents may be divided into public documents and private documents. Section 74 to 90A of the Evidence Act lay down provisions relating to public documents, which include public and private documents. Now, public documents. Section 74. The following documents are public documents. 1. Documents forming the act or records of the acts. 1. Of the sovereign authority. 2. Of official bodies and tribunals. And 3. Of public officers, legislative, judicial and executive of any part of India or of the Commonwealth or of a foreign country. And now, second, public records kept in any state of private documents. Now, private documents is defined in section 75. According to section 75 of the Evidence Act, all other documents other than those enlisted in section 74 of the Evidence Act are private documents. The list of public documents given in section 74 is exhaustive. Any document which does not fall within the provisions of section 74 is a private document. Sale deeds, mortgage, bond, lease, contracts, receipts, etc. are instances of private documents. So far as proof of public documents is concerned, There is only one significant difference between public and private documents in regard to the form of secondary evidence which is admissible. In case of public documents, permissible secondary evidence is certified copy, and such document and certified copies shall be presumed to be genuine by virtue of Section 79 of the Evidence Act. Now, distinction between public document and private document. Following are the notable points of distinction between public document and private document. Now, Section 74 of the Evidence Act defines public document, whereas Section 75 of the Evidence Act defines private document. Public documents are kept in the custody of some special authority, whereas private documents are kept in the custody of some private persons. Certified copies of the public document may be issued to a person requiring them, whereas certified copies of private documents can be issued. It is public documents is prepared by a public servant, whereas private document is prepared or created out of an agreement between the parties concerned. In a public document, certified copies of public document can be received in evidence without proof, whereas certified copies of private document cannot be taken in evidence without proof of the original document. Now we have presumptions as to document. Section 79 to 90A of the Evidence Act lay down the provisions relating to presumptions as to documents. Now, presumptions is an inference which takes place in the absence of absolute certainty as to the truth or falsehood of a fact. In other words, presumption is an inference drawn by the court as to the truth of a particular fact from other known or proved facts. Now, classification of presumptions. Presumptions can be classified as follows. 1. Presumption of fact or natural presumption or may presume, and this is discussed in section 86 to 88, section 90, section 113a and section 114. And the second type is presumption of law or artificial presumption. That is of two types. That artificial presumption or presumption of law is of two types: rebuttable presumption and irrebuttable presumption. So, rebuttable presumption or shall presume is discussed in section 79 to 85, section 89 and section 105. Now, irrebuttable presumption of law or conclusive proof, that is discussed in section 41, section 112 and section 113. And the third category of presumption is presumption of mixed law and fact. So, presumption of fact or natural presumption or may presume, that is also discussed in sections 86 to 88, 90, 111b and 114. So, sections 86 to 89, 90, 113a and 114 lay down the provisions relating to presumption of fact or natural presumption or may presume. Now, section 86 deals with presumption as to certified copies of foreign judicial records. Now, section 87 deals with presumption as to books, maps and charts. Section 88 deals with presumption as to telegraphic message. Section 90 deals with presumption as to documents 30 years old. Now, section 113a deals with presumption as to abetment of suicide by a married woman. Now, section 114 deals with court may presume existence of certain facts. The expression may presume refers to discretion of the court as to the existence or non-existence of a fact in issue. For instance, when a person is found in possession of a stolen property, the court may presume him as thief or has received such goods with the knowledge that they are stolen. So, this is discussed in section 114 of Evidence Act. According to section 4 of the Evidence Act, may presume a fact means A. Regard it as proved unless and until it is disproved, or B. Call for proof of it. In above example, the court has discretion power either to presume the possessor of stolen property as thief, or may presume that he had received such goods with the knowledge that they are stolen, or may refuse to presume the guilt of the accused and may ask or direct the prosecution to prove the guilt of the accused. These presumptions are generally rebuttable. Now, the second category of presumption, that is presumption of law or artificial presumption. This is further classified into two, that is rebuttable presumptions of law or shall presume, and irrebuttable presumptions of law or conclusive proof. Now, rebuttable presumptions of law or shall presume. Section 79 to 85, Section 89, Section 105, Section 111A, Section 113B, and Section 114A lay down the provisions relating to rebuttable presumptions or shall presume. Now, Section 79 deals with presumption as to genuineness of a certified copies. Section 80 deals with presumption as to documents produced as records of evidence. Section 81 deals with presumption as to gazette, newspaper, private acts of parliament and other document. Section 82 deals with presumption as to documents admissible in England without proof of seal or signature. Now, Section 83 deals with presumption as to maps or plans made by authority of government. Section 84 deals with presumption as to the collection of laws and reports and decisions. Section 85 deals with presumption as to power of attorney. Now, Section 89 deals with presumption as to due execution, etc. of documents not produced. Section 105 deals with burden of proving that case of accused comes within exceptions. Now, Section 111A deals with presumption as to certain offences. Section 113B deals with presumption as to dowry death. Section 114A deals with presumption as to the absence of consent in certain prosecutions of rape. According to Section 4 of the Evidence Act, the court has no opinion or discretionary power in drawing a presumption as to the existence or non-existence of a fact in issue. The court is bound to regard a fact as proved unless evidence is produced to disprove it. However, rebuttable presumption of law shall presume is not conclusive but only rebuttable. Section 79 directs that when a certified copy of public document is produced, the court shall presume that the certifying officer held the official character when the copy was certified. The court cannot call for evidence to disprove this fact, but the opposite party has the privilege to disprove that he held that official character. Example, the court shall presume the genuineness of every document purporting to be the official gazette. That is under Section 8 of the Evidence Act. Similarly, the court shall presume the accuracy or genuineness of the maps and plans made by the government authority as under Section 83 of the Evidence Act. Now, irrebuttable presumptions of law or conclusive proof. So, here it is discussed under Sections 41, Section 112 and Section 113. Sections 41, 112 and 113 of the Evidence Act 1872 lay down the provisions relating to the conclusive proof or irrebuttable presumptions of law as stated below. Now, Section 41 deals with the relevancy of certain judgments in probate, etc. jurisdiction. Now, Section 112 deals with the birth during marriage, conclusive proof of legitimacy. Now, Section 113 deals with the proof of cessation of territory. According to Section 4 of the Evidence Act, when one fact is declared by the Evidence Act to be conclusive proof of another, the court on proof of that fact must regard the other having been proved, and the court shall not permit any kind of evidence for the purpose of rebutting or disproving that fact. In other words, when a fact is proved to be conclusive under Evidence Act, the court must confirm it as conclusive and shall not permit or entertain any evidence for the purpose of disproving that fact. In such words, neither the court has the discretion to call for evidence nor the party has the privilege to disprove it. Even if the party seeks to disprove it, the court has a duty not to allow evidence for that purpose. Example, A and B are married but divorced. When the question arises whether A and B are husband and wife, if the decree of divorce is submitted to the court shall conclusively presume that they are no longer husband and wife from the date of such decree for divorce. In this example, the divorce decree is regarded as conclusive proof. Now, the third category of presumption is presumption of fact and law or mixed presumption. Besides presumption of fact and of law, a third category of presumption is also recognized, which is referred to as mixed presumption of law and fact. They lie on the boundary line between the other two, that is, the presumption of fact and presumption of law. They consist chiefly of certain inferences which form their strength, importance of frequent occurrence, and constant recommendation by judge become in course of time a familiar to the courts as presumption of law. Now, summary to presumptions as to documents, that is in section 79 to 90. Section 79 to 90 deal with presumption as to documents. Out of them, section 79 to 85 and 89 deals with what are called presumptions of law, and section 86 to 88 and 90 are relating to presumption of fact. So section 79 to 90 deals with the presumptions as to documents, 79 to 90. Out of them, 79 to 85 and 89 deals with presumption of law, and sections 86 to 88 and 90 relates to presumption of fact. Section 79 to 90A reads as follows. Now, presumption as to genuineness of certified copies, that is in section 79. It reads as, the court shall presume to be genuine every document purporting to be a certificate, certified copy, or other documents which is by law declared to be admissible as evidence of any particular fact, and which purports to be duly certified by any officer of the central government or of a state government, or by any officer in the state of Jammu and Kashmir who is duly authorized thereto by central government, provided that such document is substantially in the form and purports to be executed in the manner directed by law in that behalf. So that is section 79, presumption as to genuineness of certified copies. Now, presumption as to documents produced as records of evidence, that is discussed in section 80, presumption as to documents produced as records of evidence. Whenever any document is produced before any court purporting to be a record or memorandum of evidence, or of any part of the evidence given by a witness in a judicial proceeding, or before any officer authorized by law to take such evidence, or to be a statement of or confession by any prisoner or accused person taken in accordance with law and purporting to be signed by any judge or magistrate, or by any such officer as aforesaid, the court shall presume that the document is genuine, that any statement as to the circumstances under which it was taken, purporting to be made by the person signing it, are true, and that such evidence, statement, or confession was duly taken. So that is discussed in section 80, presumption as to documents produced as record of evidence. Presumption as to gazettes, newspaper, private acts of parliament, and other documents, that is discussed in section 81. The court shall presume the genuineness of every document purporting to be the London Gazette, or any official gazette, or the government gazette of any colony, dependency, or possession of British Crown, or to be a newspaper of a journal, or to be a copy of a private act or parliament of the United Kingdom printed by the Queen's printer, and of every document purporting to be a document directed by any law to be kept by any person, if such document is kept substantially in the form required by law and is produced by proper custody. Now, presumption as to gazette in electronic forms, that is discussed in section 81A. The court shall presume the genuineness of every electronic record purporting to be the official gazette, or purporting to be electronic record directed by any law and law to be kept by any person, if such electronic record is kept substantially in the form required by law and is produced from proper custody. That is 81A with respect to gazettes in electronic forms. Now, presumption as to documents admissible in England without proof of seal or signature, that is discussed in section 82. when any document is produced before any court purporting to be a document which by law in the force for the time being in England or Ireland would be admissible in proof of any particular in any court of justice in England or Ireland without proof of the seal or stamp or signature authenticating it, or of the judicial or official character claimed by the person by whom it purports to be signed, the court shall presume that such seal, stamp, or signature is genuine, and the person signing it held, at the time when he signed it, the judicial or official character which he claims, and the documents shall be admissible for the same purpose for which it would be admissible in England or Ireland. Now, the next one is presumption as to the maps or plans made by authority of government, that is discussed in section 83. Presumption as to maps or plans made by authority of government. The court shall presume that maps or plans purporting to be made by the authority of the central government or any state government were so made and are accurate, but maps or plans made for the purposes of any cause must be proved to be accurate. Now, presumption as to the collection of laws and reports and decisions, that is in section 84. Presumption as to the collection of laws and reports and decisions. The court shall presume the genuineness of every book purporting to be printed or published under the authority of the government of any country and to contain any of the laws of that country, and of every book purporting to contain reports of the decision of the courts of such country. Now, presumption as to the power of attorney, that is in section 85. The courts shall presume that every document purporting to be a power of attorney and to have been executed before and authenticated by a notary public or any court, judge, magistrate, Indian counsel or vice counsel or representative of the central government was so executed and authenticated. Presumption as to electronic agreements, that is discussed in section 85 capital A. Presumption as to electronic agreements. The court shall presume that every electronic record purporting to be an agreement containing the digital signatures of the parties was so concluded by affixing the digital signature of the parties. Now, presumption as to electronic records and digital signatures, that is in section 85B. Presumption as to electronic records and digital signature, section 85B. 1. In any proceeding involving a secure electronic record, the court shall presume, unless contrary is proved, that the secure electronic record has not been altered since the specific point of time to which the secure status relates. Second, in any proceedings involving secure digital signature, the court shall presume, unless the contrary is proved, that a. the secure digital signature is affixed by subscriber with the intention of signing or approving the electronic record. B. Except in the case of a secure electronic record or a secure digital signature, nothing in this section shall create any presumption relating to authenticity and integrity of the electronic record or any digital signature. Now, presumption as to digital signature certificate, that is discussed in section 85C. Presumption as to digital signature certificate. The court shall presume, unless contrary is proved, that the information listed in the digital signature certificate is correct, except for the information specified as subscriber information which has not been verified, if the certificate was accepted by the subscriber. Now, presumption as to certified copies of foreign judicial records, that is discussed in section 86. Presumption as to the certified copies of foreign judicial records, section 86. The court may presume that any document purporting to be a certified copy of any judicial record of any country not forming part of India or of Her Majesty's Dominion is genuine and accurate, if the document purports to be certified in any manner which is certified by any representative of the central government in or for such country to be manner commonly in the use in that country for the certification of copies of judicial records. An officer who, with respect to any territory or place not forming part of India or Her Majesty's dominions, is a political agent, therefore, as defined in Section 3, Clause 43 of Section 3, Clause 43 of the General Clauses Act 1897, shall, for the purpose of this section, be deemed to be a representative of central government in and for the country comprising that territory or place. So, any or an officer who, with respect to any territory or place not forming part of India or Her Majesty's dominion, is a political agent, therefore, as defined in Section 3, Subclause 43 in the General Clauses Act 1897, shall, for the purpose of this section, be deemed to be a representative of the central government in and for the country comprising that territory or place. Presumption as to books, maps, and charts, that is discussed in Section 87. Presumption as to books, maps, and charts. The court may presume that any book to which it may refer for information on matters of public or general interest, and that any published map or chart, the statements of which are relevant facts and which is produced for its inspection, was written and published by the person and at the time and place by whom or at which it purports to have been written or published. The next one, presumption as to telegraphic message, discussed under Section 88. Presumption as to telegraphic messages. The court may presume that a message forwarded from a telegraph office to the person to whom such message purports to be addressed corresponds with a message delivered for transmission at the office from which the message purports to be sent, but the court shall not make any presumption as to the person by whom such message was delivered for transmission. Now, presumption as to electronic message, that is discussed in Section 88A, 88 capital A, presumption as to electronic messages. The court may presume that an electronic message forwarded by the originator through an electronic mail server to the addressee to whom the message purports to be addressed corresponds with the message as fed into his computer for transmission, but the court shall not make any presumption as to the person by whom such message was sent. Explanation to Section 88 capital A. For the purposes of this section, the expression addressee and originator shall have the same meanings respectively assigned to them in Clause B and Clause Z of subsection 1 of Section 2 of Information Technology Act 2000. That is, Section 2 subclause B and Section 2 subclause 1 Clause B and Section 2 subclause 1 Clause Z of Information Technology Act 2000. Now, presumption as to the due execution etc. of documents not produced, that is discussed in Section 89. Presumption as to due execution etc. of documents not produced, Section 89. The court shall presume that every document called for and not produced after notice to produce was attested, stamped, and executed in the manner required by law. Now, presumption as to the documents 30 years old, Section 90. Presumption as to documents 30 years old. Section 90. Where any document purporting or proved to be 30 years old is produced before any custody which the court in particular case considers proper, the court may presume that the signature and every other part of such document which purports to be in the handwriting of any particular person is in that person's handwriting, and in case of a document executed or attested, that it was duly executed and attested by the persons by whom it purports to be executed and attested. Explanation to Section 90. Documents are said to be in proper custody if they are in the place in which and under the care of the person with whom they would naturally be, but no custody is improper if it is proved to have had a legitimate origin, or if the circumstances of the particular case are such as to render such an origin probable. Now, this explanation applies to Section 81. Illustration. A. The first illustration. A has been in possession of landed property for a long time. He produces from his custody deeds relating to the land showing his title to it. The custody is proper. Now, the second illustration. A produces deeds relating to a landed property of which he is the mortgagee. The mortgager is in possession. The custody is proper. Now, the third illustration. A connection of B produces deeds relating to the lands in B's possession which were deposited with him by B for safe custody. Here the custody is proper. Now, presumption as to electronic records 5 years old, that is section 90A. Presumption as to electronic records 5 years old, section 90 capital A. Where any electronic record purporting or proved to be 5 years old is produced from any custody which the court in the particular case considers proper, the court may presume that the digital signature which purports to be the digital signature of any particular person was so affixed by him or any person authorized by him in this behalf. Now, explanation to section 90A capital A. Explanation. Electronic records are said to be in proper custody if they are in the place in which and under the care of the person with whom they naturally be, but no custody is improper if it is proved to have had a legitimate origin or the circumstances of the particular case are such as to render such an origin probable. This explanation also applies to section 81 capital A, that is with documentary records from section 61 to 90 capital A. It also discusses about primary evidence and secondary evidence and also the evidence by in electronic form, that is electronic gazettes and electronic documents, etc. Lecture 12 of the exclusion of oral by documentary evidence. Of the exclusion of oral by documentary evidence. Chapter 6 contains sections 91 to 100 of the Indian Evidence Act 1872, which lays down the provisions relating of the exclusion of oral by documentary evidence. This chapter deals with the exclusion of oral by documentary evidence and restricts the admissibility of extrinsic evidence to prove the contents of or to vary, contradict, or add to the effect of documents. This chapter also provides for certain exceptions. Sections 91 and 92 define the cases in which documents are exclusive evidence of transactions which they embody and oral evidence cannot be used to supersede, control, contradict, vary, add to or subtract from the terms of the documents. Section 93 to 100. Section 93 to section 100 deal with the interpretation of documents by oral evidence, and oral evidence is admissible under these sections to explain the documents. Evidence of terms of contract, grants, and of other disposition of property reduced to form of document, that is discussed in section 91. So section 91 is based on the underlying principle that best evidence available should be given. It runs as follows. When the terms of a contract or of a grant or of any other disposition of property have been reduced to the form of a document, and in all cases in which any matter is required by law to be reduced to the form of a document, no evidence shall be given in proof of the term of such contract, grant, or disposition of property or of such matter except the documents itself or secondary evidence of its contents in cases in which secondary evidence is admissible under the provisions herein before contained. Exception 1. When a public officer is required by law to be appointed in writing, and when it is shown that any particular person has acted as such officer, the writing by which he is appointed need not be proved. Exception 2. Wills admitted to probate in India may be proved by the probate. Now, explanation 1. This section applies equally to cases in which the contracts, grants, or disposition of property referred to are contained in one document and to cases in which they are contained in more documents than one. Explanation 2. Where there are more originals than one original only need be proved. Explanation 3. The statement in any document whatever of a fact other than facts referred to in this section shall not preclude the admission of oral evidence as to the same fact. Now we have few illustrations. A. If a contract be contained in several letters, all the letters in which it is contained must be proved. Now B.
If a contract is contained in a bill of exchange, the bill of exchange must be proved. Illustration C. If a bill of exchange is drawn in a set of three, one only need be proved. Now illustration D. A contract in writing with B for the delivery of indigo upon certain terms. The contract mentions that the fact that B had paid A the price of other indigo contracted for verbally on another occasion. Oral, oral evidence is offered that no payment was made for the other indigo. The evidence is admissible. So, illustration D. A contract in writing with B for the delivery of indigo upon certain terms. The contract mentions the fact that B had paid A the price of other indigo contracted for verbally on another occasion. Oral evidence is offered that no payment was made for the other indigo. The evidence is admissible. Now, illustration E. A gives B a receipt for money paid by B. Oral evidence is offered of the payment. The evidence is admissible. Now, exclusion of evidence of oral agreement. That is discussed in section 92. Exclusion of evidence of oral agreement. Section 92 applies only to oral agreements. The prohibition contained in section 92 is against admission of oral agreements for purposes of varying the terms of written document. It does not apply to written agreements or statements. Where an agreement in writing is executed along with a promissory note postponing the time of payment, it is not inadmissible. Section 92 runs as follows. When the term of any such contract, grant, or other disposition of property or any property required by law to be reduced to the form of a document have been proved according to the last section, no evidence of any oral agreement or statement shall be admitted as between the parties to any such instrument or the representatives in interest for the purpose of contradicting, varying, adding to, or subtracting from its terms. Proviso 1. Any fact may be proved which would invalidate any document or which would entitle any person to any decree or order relating thereto, such as fraud, intimidation, illegality, want of due execution, want of capacity in any contracting party, want or failure of consideration or mistaken in fact or law. Now, Proviso 2. The existence of any separate oral agreement as to any matter on which a document is silent and which is not inconsistent with its terms may be proved. In considering whether or not this proviso applies, the court shall have regard to the degree of formality of the document. Proviso 3. The existence of any separate oral agreement constituting a condition precedent to the attaching of any obligation under any such contract, grant, or disposition of property may be proved. Now, Proviso 4. The existence of any distinct subsequent oral agreement to rescind or modify any such contract, grant, or disposition of property may be proved except in cases in which such contract, grant, or disposition of property is by law required to be in writing or has been registered according to the law in force for the time being as to the registration of documents. Now, Proviso 5. Any usage or custom which incidents not expressly mentioned in any contract are usually annexed to the contracts of that description may be proved, provided that annexing of such incident would not be repugnant to or inconsistent with the express terms of the contract. Now, Proviso 6. Any fact may be proved which shows in what manner the language of a document is related to existing facts. Now we have few illustrations. Illustration A. A policy of insurance is effected on goods in ship from Calcutta to London. The goods are shipped in a particular ship which is lost. The fact that the particular ship was orally accepted from the policy cannot be proved. Illustration B. A agrees absolutely in writing to pay B 1000 rupees on 1st March of 1873. The fact that at the same time an oral agreement was made that the money should not be paid till the 31st March cannot be proved. Illustration C. An estate called the Rampur Tea Estate is sold by a deed which contains a map of the property sold. The fact that land not included in the map had always been regarded as a part of the estate and was meant to pass by the deed cannot be proved. Now, illustration D. A enters into written contract with B to work certain mines, the property of B upon certain terms. A was induced to do so by misrepresentation of B's as to their value. This fact may be proved. Now, illustration E. A institutes a suit against B for the specific performance of a contract and also prays that the contract may be reformed as to one of its provisions, as that provisions was inserted in it by mistake. A may prove that such a mistake was made as would by law entitle him to have the contract reformed. Illustration F. A orders goods of B by a letter in which nothing is said as to the time of payment and accepts the goods on delivery. B sues A for the price. A may show that the goods were supplied on credit for a term still unexpired. Illustration G. A sells B a horse and verbally warrants him sound. A gives B a paper in these words: bought of A horse for rupees 500. Now B may prove the verbal warranty. Illustration H. A hires lodgings of B and gives B a card on which it is written rooms are rupees 200 per month. A may prove a verbal agreement that these terms were to include partial board. A hires lodging of B for a year and a regularly stamped agreement drawn up by an attorney is made between them. It is silent on the subject of board. A may not prove that board was included in the terms verbally. Illustration I. A applies to B for a debt due to A by sending a receipt for money. B keeps the receipt and does not send the money. In a suit for the amount, A may prove this. Illustration J. A and B make a contract in writing to take effect upon the happening of a certain contingency. The writing is left with B, who sues A upon it. A may show the circumstances under which it was delivered. Now, interpretation of documents. Section 93 to 100 lay down rules for interpretation of documents as enumerated hereunder. Now, exclusion of evidence to explain or amend ambiguous documents. That is, exclusion of evidence to explain or amend ambiguous document. This is discussed under section 93. When the language used in a document is on its face ambiguous or defective, evidence may not be given of facts which would show its meaning or supply its defects. Illustration A. A agrees in writing to sell a horse to B for rupees 1000 or 1500. Evidence cannot be given to show which price was to be given. Now, illustration B. A deed contains blanks. Evidence cannot be given of facts which would show how they were meant to be filled. Now, exclusion of evidence against application of documents to existing facts. That's in section 94. Exclusion of evidence against application of documents to existing facts. When language used in a document is plain in itself and when it applies accurately to existing facts, evidence may not be given to show that it was not meant to apply to such facts. Illustration A. Now, A sells to B by deed my estate at Rampur containing 100 bighas. A has an estate at Rampur containing 100 bighas. Evidence may not be given of the fact that the estate meant to be sold was one situated in a different place and of a different size. Now, evidence as to document unmeaning reference to existing facts. that is in section 95. Evidence as to document, unmeaning reference to existing facts. When language used in a document is plain in itself but is unmeaning in reference to existing facts, evidence may be given to show that it was used in a peculiar sense. Illustration A. A sells to B by deed my house in Calcutta. A had no house in Calcutta, but it appears that he had a house at Howrah, of which B had been in possession since the execution of the deed. These facts may be proved to show that the deed related to the house at Howrah. Now, evidence as to application of language which can apply to one only of several persons. That is in section 96. Evidence as to application of language which can apply to one only of several persons. Section 96. When the facts are such that language used might have been meant to apply to anyone and could not have been meant to apply to more than one of several persons or things, evidence may be given of the fact which shows which of those persons or things it was intended to apply to. So we have an illustration. Illustration A. A agrees to sell to B for ₹1,000 my white horse. A has 2 white horses. Evidence may be given of facts to show which of them was meant here. Illustration B. A agrees to accompany B to Hyderabad. Evidence may be given of facts showing whether Hyderabad in Deccan or Hyderabad in Sindh was meant. Evidence as to the application of language to one of 2 sets of facts to neither of which the whole correctly applies, and this is discussed in section 97. Evidence as to application of language to one of 2 sets of facts to neither of which the whole correctly applies, that is section 97. When the language used applies partly to one set of existing facts and partly to another set of existing facts, but the whole of it does not apply correctly to either, evidence may be given to show to which of the 2 it was meant to apply. Illustration A. A agrees to sell to B my land at X in the occupation of Y. A has land at X, but not in the occupation of Y. And he has a land in the occupation of Y, but it is not at X. Evidence may be given of facts showing which he meant to sell. Now, evidence as to meaning of illegible characters. That is in section 98. Evidence as to the meaning of illegible characters. Evidence may be given to show the meaning of illegible or not commonly intelligible characters of foreign, obsolete, technical, local, and provincial expressions, of abbreviations, and of words used in a peculiar sense. Illustration A. A sculptor, agrees to sell to B all my modes. A has both models and modeling tools. Evidence may be given to show which he meant to sell. Now, who may give evidence of agreement varying terms of document? That is discussed in section 99. Who may give evidence of agreement varying terms of documents? That is in section 99. Persons who are not parties to a document or their representatives in interest may give an evidence of any fact tending to show a contemporaneous agreement varying the terms of the document. Now, illustration. A and B make a contract in writing that B shall sell A certain cotton to be paid for on delivery. At the same time, they make an oral agreement that 3 months' credit shall be given to A. This could not be shown between A and B, but it might be shown by C if it affected his interest. Now, saving provisions of Indian Succession Act relating to wills, that is discussed in section 100. Saving provisions of Indian Succession Act related to wills, section 100. Nothing in this chapter contains shall be taken effect any of the provisions of Indian Succession Act as to the construction of wills. So, these provisions discussed in Indian Evidence Act shall not affect the construction of wills under Indian Succession Act. So, that is with lecture 12, the exclusion of oral evidence by documentary evidence, discussed in chapter 6 containing sections 91 to 100. With that, we are done with part 2 of Indian Evidence Act and we are moving to part 3 of Indian Evidence Act, that is production and effect of evidence. Part 3 of Indian Evidence Act 1872 comprises of 5 chapters, that is chapter 7 to chapter 11. It contains sections 101 to 167, including sections 111A, 113A, 113B and 114A. Chapter 7 contains sections 101 to 114A, including 111A, 113A and 113B, and deals with the burden of proof. Now, Chapter 8 contains sections 115 to 117 and deals with estoppel. Chapter 9 contains sections 118 to 134, that is 134, deals with witnesses. Chapter 10 contains section 135 to 166 and deals with examination of witnesses. Chapter 11 has only section 167 and deals with improper admission and rejection of evidence. Once again, in part 3 we have 5 chapters, chapter 7 to chapter 11 and sections 101 to 167. Now chapter 7 has sections 101 to 114A, that is inclusive of 111A, 113A, 113B, and this is regarding burden of proof. Now chapter 8, chapter 7 is with burden of proof. Chapter 8 deals with estoppel and this is discussed under sections 115, 116, 117. Now chapter 9 deals with witnesses, that is dealt under section 118 to section 134. Chapter 10 contains section 135 to 166 and deals with the examination of witnesses, and chapter 11 has only one section and that is section 167 and deals with improper admission and rejection of evidence. Lecture 13, Burden of Proof. Part 3, Chapter 7 of Indian Evidence Act 1872 containing sections 101 to section 114A including sections 111A, 113A and 113B lays down the provisions relating to burden of proof. Section 101 deals with burden of proof. 102, section 102 deals with on whom burden of proof lies. Section 103 deals with burden of proof as to particular fact. Section 104 deals with burden of proving fact to be proved to make evidence admissible. Now, section 105 deals with burden of proving that the case of accused comes within exceptions. Section 106 deals with the burden of proving fact, especially within knowledge. Now, section 107 deals with burden of proving death of a person known to have been alive within 30 years. Now, section 108 deals with burden of proving that person is alive who has not been heard for 7 years. So, in section 107, it deals with burden of proving death of a person known to have been alive within 30 years, and section 108 deals with burden of proving that person is alive who has not been heard for 7 years. Now, section 109 deals with burden of proof as to relationship in case of partners, landlord and tenant, principal and agent. Section 110 deals with burden of proof as to ownership. Section 111 deals with proof of good faith in transactions where one party is in relation of active confidence. Now, section 111A deals with presumption as to certain offences. Now, section 112 deals with birth during marriage, a conclusive proof of legitimacy. Now, section 113 deals with proof of cessation of territory. Now, Section 113A deals with presumption as to abetment of suicide by a married woman. Now, Section 113B deals with presumption as to dowry death. Section 114 deals with court may presume existence of certain facts. And Section 114A deals with presumption as to the absence of consent in certain prosecutions for rape. Now, burden of proof. When a fact is to be given in evidence, the first question which arises is who has a duty to prove the fact? In other words, on whom the burden of proof lies. Meaning, the expression burden of proof means obligation to prove a fact. Every party has to establish facts which go in his favor or against his opponent. In other words, the general rule with regard to burden of proof is he who asserts must prove. The reason is one who drags another into the court must bear the burden of proving the facts which he asserts. The word proof signifies a state of mental certainty as to existence or non-existence of some fact, and the phrase burden of proof in its correct sense means the responsibility of creating the state of mind. When a person is bound to prove the existence of any fact, it is said that the burden of proof lies on that person. Definition. Section 101 of the Evidence Act defines burden of proof in the following words. It follows, whoever decides any court to give judgment as to any legal right or liability dependent on the existence of facts which he asserts must prove that these facts exist. When a person is bound to prove the existence of any fact, it is said that the burden of proof lies on that person. Now, illustration. The first one, suppose A decides a court to punish B for commission of crime. The burden of proof lies on A. Now, the second illustration, A decides a court to give judgment that A is entitled to certain land which is in B's possession, but B denies it to be true. A must prove the existence of those facts that he is entitled to that property. In other words, burden of proof is the obligation which a party is to discharge by producing evidence to satisfy the court as to any legal right or liability dependent on the existence of facts which he asserts and contends therefore. The burden of proof lies on the person who alleges it, not on the person who denies it. The issue must be proved by the party who states an affirmative and not by the party who states a negative. The expression burden of proof has two distinct meanings. One, the legal burden, that is the burden of establishing the guilt. And two, the evidential burden, that is the burden of leading evidence. So, burden of proof has two distinct meanings. One is the legal burden and second one is the evidential burden. Now, in a criminal trial, the burden of proving everything essential to establish the charge against the accused lies upon the prosecution, and the burden never shifts. Notwithstanding the general rule that the burden of proof lies exclusively upon the prosecution, in the case of certain offences, the burden of proving a particular fact in issue may be laid by law on the accused. The burden resting on the accused in such cases is, however, not so onerous as that which lies on the prosecution and is discharged by a proof of balance of probabilities. So, the burden resting on the accused in such cases is, however, not so onerous as that which lies on the prosecution and is discharged by proof of balance of probabilities. Under the scheme of Prevention of Corruption Act, burden lies upon the accused to account for his possessions. Burden of proof in civil and criminal cases. In criminal cases, there is a presumption in favor of innocence of the accused, and the burden rests on the prosecution to establish his guilt beyond reasonable doubt. He is not required to rebut the case made out against him until the evidence is sufficient to establish his guilt beyond reasonable doubt, and even in such a case, it would be enough for him to introduce only such evidence as will again create a reasonable doubt as to his guilt. It is only where the accused relies upon some independent matters of defense or general exceptions that he has to offer evidence in support of such defense or exception. In civil cases, the plaintiff is required to prove his case by preponderance of evidence. The reasons for this relaxed rule in civil cases are the following. 1. In criminal cases, there is a presumption of innocence in favor of the accused, but there is no such presumption in civil cases. 2. In civil cases, proof may result in a judgment for pecuniary damage or establishing a right, but in criminal cases, reputation, freedom, future livelihood, career, and even life are involved. Now, presumptions and burden of proof. Presumptions may affect burden of proof, and whenever the law places a burden of proof upon a party, a presumption operates against it. They have close connection with each other and must be considered together. When there is an ample evidence from both sides, the fate of the case is no longer determined by presumptions or burden of proof, but by a careful selection of the correct version based on preponderance of probabilities, which has to be so compulsive or overwhelming in the case of a choice in favor of a conviction as to remove all reasonable doubt. Burden of proof and presumption may become decisive only where evidence from both sides is equally balanced or there is a paucity of evidence on either side. So, burden of proof and presumption may become decisive only where evidence from both sides is equally balanced or there is a paucity of evidence on either side. Now, on whom burden of proof lies? That is discussed in section 102, on whom burden of proof lies. Section 102 of Evidence Act lays down that the burden of proof in a suit or proceeding lies on that person who would fail if no evidence at all were given on either side. Section 102 runs as follows. The burden of proof in a suit or proceeding lies on that person who would fail if no evidence at all were given on either side. Illustrations. Illustration A. A sues B for land of which B is in possession and which, as A asserts, was left to A by the will of C, who is B's father. If no evidence were given on either side, B would be entitled to retain his possession. Therefore, the burden of proof is on A. Illustration B. A sues B for money due on a bond. The execution of the bond is admitted, but B says that it was obtained by fraud, which A denies. If no evidence were given on either side, A would succeed as the bond is not disputed and the fraud is not proved. Therefore, the burden of proof is on B. The next one, burden of proof as to particular fact, and this is discussed in section 103, burden of proof as to particular fact, section 103. It lies on the person who wants the court to believe such facts. It means he who wishes to prove a particular fact must prove. Section 103 runs as follows. The burden of proof as to particular fact lies on that person who wishes the court to believe in its existence, unless it is proved by any law that the burden of proof of the fact shall lie on any particular person. Illustrations. Illustration A. A prosecutes B for theft and wishes the court to believe that B admitted the theft to C. A must prove the admission. Illustration B. B wishes the court to believe that at the time in question he was elsewhere. He must prove it. Now, agreement between parties on burden of proof. Parties to the suit can enter into an agreement to the effect that the burden of proof as to proof of existence or non-existence of a particular fact shall lie on either side. Standard of proof in civil and criminal cases. In criminal cases, the burden of proof as to guilt of the accused is to be proved beyond reasonable doubt lies on the prosecution. But in civil cases, proof beyond reasonable doubt is not necessary, and the matter is decided by the court by taking into consideration the evidence produced by the parties. Burden of proving fact to be proved to make evidence admissible, that is discussed in section 104. So, burden of proving fact to be proved to make evidence admissible, section 104. Section 104 provides that burden of proving a fact, the proof of which enables a party to give evidence of some other fact, is on the person who wished to give such evidence. To give evidence of a dying declaration, it is necessary that the party must prove that the person whose dying declaration is tendered in evidence is dead. The burden of proving death is under section 104 on the person who wishes to give evidence of dying declaration. Section 104 runs as follows. The burden of proving any fact necessary to be proved in order to enable any person to give evidence of any other fact is on the person who wishes to give such evidence. Illustrations. Illustration A. A wishes to prove a dying declaration by B. A must prove B's death. Illustration B. A wishes to prove by secondary evidence the contents of a lost document. A must prove that the document has been lost. Now, burden of proving that case of accused comes within exceptions, that is discussed in section 105. Burden of proving that case of the accused comes within exceptions is discussed in section 105. Section 105 is an important qualification of the general rule that in criminal trials the burden of proving a very thing essential to the establishment of charge against the accused lies upon the prosecution. Now, if the accused claims exemption from criminal liability under chapter 14, that is general exemptions, section 76 to 106 of the IPC, the burden of proof rests on the accused. Example, A is accused of murder. If he claims exemption on the ground of insanity under section 84 of IPC, the burden of proofs lies on him. Section 105 runs as follows. When a person is accused of any offence, the burden of proving the existence of circumstances bringing the case within any of the general exception in the Indian Penal Code chapter 14 or within any special exemption or proviso contained in any part of the same code or in any law defining the offence is upon the accused, and the court shall presume the absence of such circumstances. So, the presumption of the court is that such a circumstance for exception does not exist. So, the accused who claims the exception shall prove it. Now, illustrations. Illustration A. A, accused of murder, alleges that by reason of unsoundness of mind, he did not know the nature of the act. The burden of proof is on A. Now, illustration B. A, accused of murder, alleges that by grave and sudden provocation, he was deprived of the power of self-control. The burden of proof is on A. Illustration C. Section 325 of Indian Penal Code provides that whoever, except in the case provided for by section 335, voluntarily cause grievous hurt shall be subjected to certain punishment. A is charged with voluntarily causing grievous hurt under section 325. The burden of proving the circumstance bringing the case under section 335 lies on A. So we have a case law here, that is Bhikari in Bhikari versus State of UP, AIR 1966. In Bhikari versus State of UP, AIR 1966. The appellant was charged with murder and pleaded the defense of insanity under section 84 IPC. The burden of proof was held to be on the appellant. Now, burden of proving fact, especially within knowledge. that is section 106. Burden of proving fact, especially within knowledge. When any fact is especially within the knowledge of any person, the burden of proving that fact is upon him. Illustrations. Illustration A. When a person does an act with some intention other than that which the character and circumstances of the act suggest, the burden of proving that intention is upon him. Illustration B. A is charged with travelling on a railway without a ticket. The burden of proving that he had a ticket is on him. Now, burden of proving death of a person known to have been alive within 30 years. That is discussed in section 107. Burden of proving death of a person known to have been alive within 30 years. When the question arises whether a person is alive or dead, section 107 of the Evidence Act lays down that if a person is proved to have been living within 30 years, it shall be presumed that he is alive, and the burden of proving that he is dead lies on the person who affirms that he is dead. In simple words, a person is alive within 30 years. If anyone says that he is dead, then the burden of proof that he is dead lies on the person who claims that person to be dead. We have a case law here, that is Surjit Kaur versus Jhujhar Singh, AIR 1980. Surjit Kaur versus Jhujhar Singh, AIR 1980. In this case, a person was shown to be alive in the year 1960 and was presumed by the court to be alive up to 30 years from that date. In the evidence, his wife said that he had gone to Indonesia and his whereabouts were unknown for a period of more than 7 years. It was held not sufficient to rebut the presumption under section 107. Burden of proving that person is alive who has not been heard of for 7 years. That is discussed in section 108, the presumption of death. Burden of proving that the person is alive who has not been heard of for 7 years. Section 108. Section 108 has its origin in English law, which was stated thus in Re Finis Trust 1870, that if a person has not been heard for 7 years, there is a presumption of law that he is dead. So this had the origin in English law, which was stated in Re Finis Trust 1870, that if a person has not been heard of for 7 years, there is a presumptive of law that he is dead. The above principle is embodied or enshrined in section 108 of the Evidence Act. According to section 108, when a person is not heard of for 7 years, he is presumed to be dead by law. If anybody says that he is alive, the burden of proof lies on that person who claims the other person to be alive. Now, in a case law, that is N. Jayalakshmi Ammal versus R. Gopala Pattar, AIR 1995. N. Jayalakshmi Ammal versus R. Gopala Pattar. In this case, it was held that one not heard for 7 years is presumed to be dead. Generally, the person is presumed to be dead on the expiry of 7 years, but no hard and fast rule of universal rule can be laid down in this respect, and this was held in Subhash Ramachandra Vadegar versus Union of India in AIR 1993. In Subhash Ramachandra Vadegar versus Union of India in AIR 1993. Burden of proof as to relationship in the case of partners, landlord and tenant, principal and agent, that is discussed in section 109. So, burden of proof as to relationship in the case of partners, landlord and tenant, principal and agent, section 109. When the question is whether the persons are partners, landlord and tenant, or principal and agent, and it has been shown that they have been acting as such, the burden of proof that they do not stand or have ceased to stand to each other in those relationships respectively is on the person who affirms it. Now, burden of proof as to ownership, that is discussed in section 110. Burden of proof as to ownership. When the question is whether any person is owner of anything of which he is shown to be in possession, the burden of proving that he is not the owner is on the person who affirms that he is not the owner. So, when the question is whether any person is the owner of anything of which he is shown to be in possession, the burden of proving that he is not the owner is on the person who affirms that he is not the owner. According to section 110, a person in possession of a property is presumed to be the owner. If anybody denies that the possessor is not the owner, the burden of proof lies on him. Now, section 110 runs as follows. When the question is whether any person is owner of anything of which he is shown to be in possession, the burden of proving that he is not the owner is on the person who affirms that he is not the owner. Now, we have proof of good faith in transaction where one party is in relation of active confidence, that is section 111. Proof of good faith in transactions where one party is in relation of active confidence. Where there is a question as to the good faith of a transaction between parties, one of whom stands to the other in a position of active confidence, the burden of proving the good faith of the transaction is on the party who is in position of active confidence. Illustrations. Illustration A. The good faith of a sale by a client to an attorney is in question in a suit brought by the client. The burden of proving the good faith of the transaction is on the attorney. Illustration B. The good faith of a sale by a son just come of age to a father is in question in a suit brought by the son. The burden of proving the good faith of the transaction is on the father. Now, presumptions as to certain offences, that is discussed in section 111A. Presumptions as to certain offences. Now, 1. Where a person is accused of having committed any offence specified in subsection 2, that is A. Any area declared to be distributed area under any enactment for the time being in force, making provision for the suppression of disorder and restoration and maintenance of public order, or B. Any area in which there has been over a period of more than 1 month extensive disturbance of public peace, and it is shown that such person had been at place in such area at a time when firearms or explosives were used at or from the place to attack or resist the members of any armed force or the forces charged with maintenance of public order acting in discharge of their duties, it shall be presumed, unless the contrary is shown, that such person had committed such offence. And subclause 2, the offence referred to in subsection 1 are the following, namely A. An offence under section 121, section 121A, section 122 or section 123 of Indian Penal Code, and B. Criminal conspiracy or attempt to commit or abetment of an offence under section 122 or 123 of Indian Penal Code. Now, the next one, we have birth during marriage, conclusive proof of legitimacy. That is discussed in section 112. Birth during marriage, conclusive proof of legitimacy. A child born during the continuance of a valid marriage is conclusively presumed to be the legitimate child. If the child is born within 280 days after the dissolution of marriage, it is a conclusive proof of legitimacy. It is said that maternity is a fact and paternity is a surmise, that is a matter of inference. Maternity can easily be obtained by positive proof, but it is very difficult to establish the paternity because the child's connection with the father are secret, and in spite of the development of medical science, it is not possible to prove paternity positively. Therefore, conclusive presumption as to legitimacy of a child has been provided for under section 112 of the Evidence Act. Pater ist quem nupite demonstrant. Pater ist quem nupite demonstrant. This maxim means father is he whom nuptials indicate. Now, essential conditions. To establish legitimacy under section 112, the following conditions must be satisfied. 1. The child must have born during the subsistence of a valid marriage. 2. The child must have born within 280 days of the dissolution of marriage. 3. When child is born within 280 days of the dissolution of the marriage, the mother must have remained unmarried. And 4. It should be shown that the husband and wife had no access to each other. So we have a case law, that is Timmakku versus Rengappa, AIR 1977. Timmakku versus Rengappa, AIR 1977. A child born after 280 days after the dissolution of the marriage was held to be legitimate. Now, another case law, Chirudakkutti versus Subramanian, AIR 1987. Chirudakkutti versus Subramanian, AIR 1987. The respondent married the appellant in 1969. 3 children were born to them out of this wedlock. On 8/1/1976, respondent underwent vasectomy operation. Therefore, both lived together. On 30/8/1978, the appellant gave birth to 4th child. The question was whether the appellant was guilty of adultery. The 4th child was conceived in or about November 1977. According to medical evidence, there is chance of 1% failure in vasectomy operations. The husband and wife lived together till 7 months pregnancy. There was no evidence that operation was successful. The test was conducted on 25/1978 and the result processed in 1979. It was not proved that the delay did not affect the result, and the technician admitted that semen was not taken in his presence. Under these circumstances, it was held that the respondent could not establish that in or about November 1977 he was unable to procreate. The burden lies on father to prove illegitimacy, which he failed to discharge. Now the next one is presumption as to abetment of suicide by a married woman. That is in section 113A. Presumption as to abetment of suicide by a married woman. Section 113A has been inserted by the Criminal Law Amendment, Second Amendment Act of 1983. So Section 113A has been inserted by the Criminal Law Second Amendment Act of 1983. Section 7, Amendment Act Section 7, and it came into effect from 25/12/1983. Came to effect from 25/12/1983. When a married woman committed suicide within 7 years of marriage, law presumes that her husband or his relatives subjected her to cruelty. Section 113A runs as follows. When the question is whether the commission of suicide by a woman had been abetted by her husband or any relative of her husband, and it is shown that she had committed suicide within a period of 7 years from the date of her marriage, and that her husband or such relative of her husband had subjected her to cruelty, the court may presume, having regard to all the other circumstances of the case, that such suicide had been abetted by her husband or by such relative of her husband. Now, explanation to this section. For the purpose of this section, cruelty shall have the same meaning as in section 498A of Indian Penal Code. The objects of section 113A is to eradicate atrocities and dowry death committed against married women sent to father-in-law's house. The Dowry Prohibition Act, which was passed in 1961, did not serve the purpose. Essential conditions. For application of section 113A, the following conditions are necessary. First one, the case must be of suicide, not murder. 2. The question in issue must be whether suicide was abetted by husband or his relative. 3. Suicide must have occurred within 7 years from the date of the marriage. 4. It must be shown that she was subjected to cruelty by the husband or any relative of the husband. And the fifth one, the court should consider other circumstances of the case. If all the above conditions are satisfied, the court then may presume that suicide was abetted by husband or his relative who subjected her to cruelty. Now, section 113A has retrospective effect. Section 113A has retrospective effect. The general rule is that all statutes other than those which are merely declaratory or which relate only to matters of procedure or evidence are prima facie prospective and not retrospective unless by express words or necessary implications it appears that this was the intention of the legislature. So, in Guru Bachan Singh versus Satpal Singh, AIR 1990, Guru Bachan Singh versus Satpal Singh, AIR 1990, it was held that Section 113A of Evidence Act has retrospective effect. In that case, Ravinder Kumar, daughter of Guru Bachan Singh, was married to Satpal Singh in November 1982. She died on 25th June 1983 of burns on her body by fire. The father-in-law and Satpal Singh were charged with abetment of suicide. All the three were convicted under Section 306 IPC by the learned Additional Sessions Judge, drawing presumption under Section 113A of Evidence Act. The High Court acquitted them, but the Supreme Court affirmed the conviction. So, in Guru Bachan Singh versus Satpal Singh, AIR 1990, the court held that Section 113A of Evidence Act has retrospective effect. Now, presumption as to dowry death, that is discussed in Section 113B. Presumption as to dowry death. Section 113B has been inserted by Dowry Prohibition Amendment Act in 1986. So, Section 113B has been inserted by the Dowry Prohibition Amendment Act in 1986. It relates to dowry death and runs as follows. When the question is whether a person has committed the dowry death of a woman and it is shown that soon before her death, such woman had been subjected by such person to cruelty or harassment for or in connection with any demand for dowry, the court shall presume that such person had caused the dowry death. Explanation. For the purpose of this section, dowry death shall have the same meaning as in Section 304B of Indian Penal Code. For the purpose of this section, dowry death shall have the same meaning as in 304B of Indian Penal Code. Now, essential conditions. For the application of Section 113B of the Evidence Act, the following conditions must be satisfied. 1. The woman must have died on account of burns, bodily injury, or otherwise in abnormal circumstances. 2. She must have died within 7 years of marriage. 3. It must be shown that soon before her death, she was subjected to cruelty or harassment for or in connection with a demand of dowry by any person. When the above points are established, then the court shall presume that the person who shown to have subjected her to cruelty or harassment caused dowry death. Presumption as to dowry death. When the question arises whether a person has caused the dowry death of the woman, if it is shown that prior to the death of such woman, she had been subjected by such person to cruelty or harassment for or in connection with dowry demand, the court shall raise a presumption that such person has caused the dowry death. Now, nature of presumption and burden of proof. When the court is satisfied that the circumstances exist to show that the victim of the dowry death has before her death been subjected by the accused to cruelty or harassment in connection with the demand for dowry that is sufficient to raise an adverse presumption against the accused that he had caused the dowry death in question. The expression shall presume, as used in section 113b, imposes a mandatory obligation on the court to raise the presumption that the accused has caused the dowry death. When an adverse presumption is raised against the accused that he caused the dowry death in question, it is very much implied that the burden of proof lies on the accused to rebut the presumption referred to under this section and to prove that circumstances do not exist to show that the alleged victim of dowry death has been subjected by him to cruelty or harassment in connection with the demand for dowry. Where an accused was tried under section 304b of IPC for dowry death of his wife, in view of abundant evidence to prove harassment in connection with dowry demand, it was held that the burden of proof is shifted on the accused to show that it was not a dowry death, and this was held in GM Natarajan vs. State 1995. GM Natarajan vs. State 1995. In this, it was held that where an accused was tried under section 304b of IPC for dowry death of his wife, in view of abundant evidence to prove harassment in connection with dowry demand, it was held that the burden of proof is shifted on accused to show that it was not a dowry death. Now, in Bhura Singh vs. State, 1992, the deceased wife was alleged to have been set on fire by her in-laws or accused at her matrimonial house. Prior to her death, she wrote letter to father narrating about the ill treatment, harassment and threat of dire consequence from her in-laws' side in connection with the demand of dowry. The Allahabad High Court held that section 113b can be invoked only in cases where there is a question whether a person has caused dowry death of a woman. Further, in order to raise a presumption under section 113b, 1. Firstly, it must be shown that soon before the death of woman, she had been subjected by the accused to cruelty or harassment. And 2. Secondly, the cruelty or harassment must have been for or in connection with any demand for dowry. So, this was held in Bhura Singh vs. State 1992. In Shamlal vs. State of Haryana 1997, Shamlal vs. State of Haryana 1997, the accused along with his father and grandmother were tried for causing dowry death of his wife. It was shown that as a result of dispute regarding the dowry, the deceased was sent back to her parental home. The deceased, after staying for 1.5 years at her parental home, rejoined her husband after the dispute was patched up by a panchayat, and shortly afterwards she died of burn injuries. The Supreme Court held that in the absence of anything on the record to show that she was either treated with cruelty or harassment with the demand for dowry during the period between her having been taken to the parental home and her tragic end, no recourse can be taken to the legal presumption envisaged in Section 113b of Evidence Act. The Supreme Court set aside the conviction of the accused under Section 304b of IPC, but however found him guilty under Section 498 of IPC. Now, court may presume existence of certain facts. That is discussed in Section 114. Court may presume existence of certain facts. That is discussed in 114. The court may presume the existence of any fact which it thinks likely to have happened, regard being had to the common cause of natural events, human conduct, and public and private business in their relation to the facts of particular case. Illustrations. The court may presume in case illustration A, that a man who is in possession of stolen goods soon after the theft is either the thief or has received the goods knowing them to be stolen unless he can account for his possession. Illustration B, that an accomplice is unworthy of credit unless he is corroborated in material particulars. Illustration C, that a bill of exchange accepted or endorsed was accepted or endorsed for good consideration. Illustration D, that a thing or state of things which has been shown to be in existence within a period shorter than that within which such things or state of things usually cease to exist is still in existence. Illustration E, that judicial and official acts have been regularly performed. Illustration F, that the common course of business has been followed in particular cases. Now, illustration G, that evidence which could be and is not produced would, if produced, be unfavorable to the person who withholds it. Now, illustration H, that if a man refuses to answer a question which he is not compelled to answer by law, the answer, if given, would be unfavorable to him. Illustration I, that when a document creating an obligation is in the hands of the obliger, the obligation has been discharged, but the court shall also have regard to such facts as the following, is considering whether such maxims do the following, is considering whether such not apply to particular cases before it. So, while we discuss these illustrations, we discuss what the court shall presume, but there are also some facts the court shall have regard to in addition to this presumption. So, as to illustration A shopkeeper has in his till a marked rupee soon after it was stolen and cannot account for its possession specifically, but is continually receiving rupees in the course of his business. As to illustration B, a person of the highest character is tried for causing a man's death by an act of negligence in arranging certain machinery. B, a person of equally good character who also took part in the arrangements, describes precisely what was done and admits and explains the common carelessness of A and himself. As to illustration B, a crime is committed by several persons, A, B, and C. Three of the criminals are captured on the spot and kept apart from each other. Each gives an account of the crime implicating D, and the accounts corroborate with each other in such a manner as to render previous consent highly importable. Now, the next one is presumption as to absence of consent in certain offences such as prosecutions for rape. Presumptions as to absence of consent in certain prosecutions for rape, that is discussed under section 114A. Section 114A has been inserted by Criminal Law Amendment Act of 1983. The amendment became necessary partly because of the growing incidence of rape and partly because of the sensational acquittal of Mathura rape case. In this section has been again substituted by Amendment Act number 13 of 2013 with effect from 3/2/2013, which reads as follows. In a prosecution for rape under clause A, clause B, clause C, clause D, clause E, clause F, clause G, clause H, clause I, clause J, clause K, clause L, clause M, or clause N of subsection 2 of section 376 of IPC, where sexual intercourse by the accused is proved, and the question is whether it was without the consent of the woman alleged to have been raped, and such woman states in her evidence before the court that she did not consent, the court shall presume that she did not consent. Explanation. In this section, sexual intercourse shall mean any of the acts mentioned in clauses A to D of section 375 of IPC. So what is discussed is here is that if a person is said to have committed any offense that comes under 376 subsection 2 from clause A to clause N. If a person has committed any of such offenses, and if the question is regarding whether the victim has given the consent, and if the woman says that she has not given consent, then the court shall presume that the consent was not given. And for this, where sexual intercourse is defined, the explanation says that the sexual intercourse shall mean any of the act mentioned in 375 clauses A to D. So it is to be noted that earlier only physical touch and skin touch were included, right? And now presently even the touch by inserting mouth or keeping mouth or any such acts are also included in the definition of sexual intercourse under section 375. In the case of rape, direct evidence is not possible since the offense takes place at a secluded place. So, in case of rape, direct evidence is not possible since the offense takes place at a secluded place. The statement made by the victim, as she had been raped by the accused, can be offered as material evidence. In most cases of rape, the accused pleads consent as defense and gets acquittal. But this amended section 114A provides that where rape is alleged, the court presumes that no consent was given by the victim. Prior to this amendment, the prosecution was to prove the absence of consent of the victim. This amended section shifted the burden of proving consent from victim to the accused. To raise an adverse presumption against the accused, the following conditions are to be satisfied. And 3 conditions are mentioned. The first one, the fact of sexual intercourse between the accused and the victim must be proved. The second one, the question before the court was whether such intercourse was with or without the consent of the victim. And the statement of the third one, the statement of the victim before the court that she had not consented. So these 3 conditions should be satisfied. Now the relevant leading and sensational case which is instrumental for inserting section 114A is as follows. One is Tukaram versus State of Maharashtra, that is popularly known as Mathura rape case. So it was based on this decision that the amendment 114A the amendment was brought and 114A was inserted. In this case, Madhura, a working girl, was alleged to have been raped by 2 policemen. Madhura lost her parents in the childhood. She was brought up by her brother. Both of them were working hard as laborers. At the place of work, Madhura came in contact with her employer's sister's son, that is employer's nephew, and decided to marry him. Madhura's brother launched a complaint or report at the police station that his sister Madhura had been kidnapped by her lover's sister and her husband. All of them were rounded up and brought to the police station. The statement of the girl Madhura and her lover were recorded. The head constable asked the party, that is Madhura's brother, to leave the police station to bring a copy of Madhura's date of birth. Later, the head constable left the police station for evening meal. At that time, only 2 accused policemen, that is Tukaram and Ganpat, remained at the police station. When the party, Madhura's brother, was about to cross the gate of the police station, the 2 accused policemen appeared before Madhura. They told Madhura to stay and asked the others to move out. Madhura was taken inside. From this point onwards, all that could be known was from Madhura's mouth. She stated that one of the policemen, Ganpat, dragged her to the back veranda and raped her against her stiff resistance. He left and the other accused policeman, Tukaram, appeared, who was still then sitting nearby. He fondled her private parts. He could not do anything more because he was too drunk. When Madhura did not come out, her brother, her lover, and her employer, Nushi, became suspicious. When Nushi shouted for Madhura, the noise attracted crowd. Tukaram came out and said that the girl had gone and he went out. Later on, Madhura came out and narrated the incident. The sessions judge found that there was no evidence that she was below 16 years and she was a shocking liar whose testimony was riddled with falsehood and improbabilities. The learned judge said that she had sexual intercourse with Ganpat and not rape. He opined that she was habituated to sexual intercourse, and because of fear of the crowd, her lover and others, she might have not admitted that she had sexual intercourse willingly. He, the sessions judge, acquitted the accused on the ground that rape was not proved and it might probably with her consent. The High Court on appeal held that the deposition of Madhura that Ganpat had sexual intercourse with her was reliable and supported by circumstantial evidence. The court convicted the accused on the ground that passive submission at a police station cannot be deemed as consent. On appeal, the Supreme Court acquitting the accused held that when the accused Ganpat took her inside, she must have resisted and cried for help. Secondly, the onus is always on the prosecution to prove affirmatively each ingredient of the offence. Section 114A was inserted to the Evidence Act by Criminal Laws Amendment Act in 1983. After the inception or insertion of this section, Section 114A, the decision of Supreme Court in Madhura rape case would be otherwise. So when the decision of Madhura rape case was there, Section 114A was not there, and thus the onus of proving onus is always on the prosecution to prove affirmatively each ingredient of the offence. That was held by the judge because 114A was not there. Now, essential conditions. For the application of Section 114A of the Indian Evidence Act 1872, the following conditions must be satisfied. 1. The accused must be prosecuted for rape under Clause A to Clause G of subsection 2 of 376. That is either of these clause. Clause F has been excluded because sexual intercourse with a girl under 16 years is rape even if she has consented to it. So, rape of all other kind where the consent is irrelevant comes under this section. Now, it must be proved that accused had sexual intercourse with the woman. The third one, the only question in issue must be whether sexual intercourse was with her consent. Now, the fourth one, the woman should depose before the court that she did not give her consent. If these conditions are satisfied, the court shall presume the absence of consent and the burden of proving consent will be on the accused. If he cannot prove consent, he cannot be acquitted. The presumption under this section is presumption of law. So the next one is lecture 14, that is estoppel. So part 3, chapter 8 contains section 115 to 117 of the Indian Evidence Act 1872 that lays down the provisions relating to the doctrine of estoppel. Section 115 embodies the principle of estoppel. Section 116 deals with estoppel of tenant and of license of persons in possession, and section 117 deals with estoppel of acceptor of bill of exchange, bailee or licensee. So under chapter 8, with regards to estoppel, we have 3 sections, that is section 115, 116, 117. 115 deals with the doctrine of estoppel or embodies the principle of estoppel. Section 116 deals with estoppel of tenant and of license of persons in possession. Now section 117 deals with estoppel of acceptor of bill of exchange, bailee or licensee. Now meaning and definition. The expression estoppel is derived from the French word estoppe, which means shut the mouth. The expression estoppel is derived from the French word estoppe, which means shut the mouth. Now, when a person tells something, we generally hear him. If he says something different or contradicting, we would not hear anymore and contradict such statement. Otherwise, we shall comply with it. Example: A intentionally and falsely says B. Intentionally and falsely says B that he is the owner of certain land and induces B to purchase and pay for it. Later, A happens to become the owner of the said land. Then A cannot set aside the sale on the ground that he did not have title at the time of the contract for sale. In other words, A cannot stop B for execution of the contract of sale. Now, when a person by declaration, that is by act or omission, makes or induces another to believe a thing, cannot deny its truth subsequently. That is laid down by doctrine of estoppel. That is, when a person by declaration, that is an act or omission, makes or induces another to believe a thing that cannot deny, then that person cannot deny its truth subsequently. The other person cannot be estopped from proceeding upon such declaration. Estoppel is a rule of evidence by which a person is not allowed to plead the contrary of a fact or state of things which he has formally asserted as existing. Section 115 of Evidence Act embodies the principle of estoppel. It runs as follows. When one person has, by his declaration, act or omission, intentionally caused or permitted another person to believe a thing to be true and to act upon such belief, neither he nor his representative shall be allowed in any suit or proceeding between himself and such person or his representative to deny the truth of that thing. Illustration: A intentionally and falsely leads B to believe that certain land belongs to A and thereby induces B to buy and pay for it. The land afterwards becomes the property of A, and A seeks to set aside the sale on the ground that at the time of the sale he had no title. He must not be allowed to prove this for the want of title. Now, basis, object and underlying principle. The principle of estoppel is based on the principle of equity and good conscience. The object of the principle of estoppel is to prevent fraud and to manifest good faith amongst the parties. This principle is enshrined in the maxim Allegans contraria non est audientes. Allegans contraria non est audientes. It means a man alleging contradictory facts ought not to be heard. So, a man alleging contradictory facts ought not to be heard. Allegans contraria non est audientes. The principle of estoppel was laid in the case of Picard versus Sears, 1832. Picard versus Sears, 1832. In the instant case, A was the owner of machinery. A allowed his friend B to be in possession of the machinery. C obtained a decree against B and seized the machinery, for which A did not raise any objection immediately. Later, C sold the machinery to other person. Then A raised an objection and sued C for setting up his title. The suit was dismissed on the ground that C cannot be estopped from sale. The object of the doctrine of estoppel is to protect the interest of a person who acted in good faith, believing the statement of another. It is based on three moral principles. 1. No one can blow hot and cold in the same breath. 2. No one can take advantage of one's wrong. And third one, no one can approbate or accept and reprobate, that is reject, at the same time. So, the three moral principles: 1. No one can blow hot and cold in the same breath. 2. No one can take advantage of one's wrong. And the third one, no one can approbate or accept and reprobate, that is reject, at the same time. Now, essential elements. To constitute estoppel, the following conditions are to be satisfied, and three conditions are laid here. The first one, there must be a declaration, that is an act or omission on the part of one person intentionally causing or permitting another person to believe a thing to be true. Now, the second one, the other person to whom the declaration is made must believe that thing to be true. So, the first condition is that there must be a declaration, act or omission on the part of one person, intentionally causing or permitting another person to believe a thing to be true. Second one, the other person to whom the declaration is made must believe that thing to be true. And the third one, there must be some act in pursuance of that belief. Estoppel is a rule of civil actions. It has no application in criminal proceeding. So, estoppel is a rule in civil actions. It has no application in criminal proceedings. Now, the kinds of estoppel. The principle of estoppel is of three kinds. 1. Estoppel by record. 2. Estoppel by deed. And the third one, estoppel by conduct or estoppel in pais. So, the first one, estoppel by record. It refers to judgments or public records which are believed to be true. A person who acts in pursuance of judgment or records cannot be estopped. The second one, estoppel by deed. It means estoppel by an agreement. When a person enters into an agreement and his statement is furnished therein, he shall not be permitted to deny his statement. And the third one, estoppel by conduct. Now, it is also called estoppel in pais. When a person, by acts or words or deeds, induces another person to believe the existence of a thing and make him to act upon it, he is estopped from denying the existence of such fact. Now, some of the relevant case laws here, that is Srimati Geeta Mishra versus Utkal University, AIR 1971. Srimati Geeta Mishra versus Utkal University, AIR 1971. In the instant case, Geeta Mishra was declared to have been passed first BSc. On the basis of documents, she joined in second BSc. Subsequently, her admission was cancelled on the ground that she was declared to have been passed by mistake. The Orissa High Court held that the government was stopped from denying earlier declaration. The petitioner was directed to continue the second BSc. That was in Srimati Geeta Mishra versus Utkal University, AIR 1971. Another relevant case law is Pratima Das versus State of Orissa, AIR 1975. Pratima Das versus State of Orissa, AIR 1975. In this case, the petitioner was declared qualified through entrance examination for admission into MBBS. She left BSc and joined MBBS. Later, her seat in medicine was cancelled on the ground that there were other candidates who secured more marks than the petitioner. The Orissa High Court held that the government is stopped from the truth of its earlier declaration. The petitioner was directed to continue her study in medicine. Another case law is Santanam Gowda versus Behrampur University, AIR 1990. Santanam Gowda versus Behrampur University, AIR 1990. In this case, the appellant, a student, was admitted to law course at Ganjam Law College. There was no dispute that at the time of admission he had submitted his mark sheet. He studied for 2 years and was admitted to final year course. His result of pre-law and intermediate law examination was withheld on the ground that he was ineligible for admission as he secured 39.5 marks in MA examination. Overruling the High Court decision, the Supreme Court held that the estoppel would apply. The court also pointed out that there was requirement of minimum marks 40% for the graduates only. There was no requirement of any percentage of marks for postgraduates. There was no fraud or misrepresentation on the part of the candidate. Now, in another case, that is Vandana versus MLN Medical College, Allahabad, AIR 1987. Vandana versus MLN Medical College, Allahabad, AIR 1987. The petitioner in the instant case, who appeared at pre-medical test as general candidate, was selected by mistake, treating her member of the scheduled caste. She was asked to appear for medical test on 3/9/1985. On 11/9/1985, her admission was cancelled. It was held that the principle of estoppel will not apply. One of the grounds for this decision was that she knew and could be presumed to have known that she could not be admitted as a general candidate because her marks were much less and those of the last candidate of the general category. So here the doctrine of estoppel was not made applicable. Now, Ashutosh Biswas versus State of Orissa. Ashutosh Biswas versus State of Orissa, AIR 1989. In this case, the petitioner, after being selected provisionally for admission in Government Medical College for a reserved seat of scheduled caste, resigned from state service believing bona fide that on producing original certificate he would be admitted. It was nowhere in the prospectus or application form requiring him to be scheduled caste belonging to the state of Orissa. He was denied admission on the ground that he was scheduled caste from West Bengal. The court held that the government was stopped from denying the admission since his seat had already been filled up. The authorities were directed to create one seat. Now, specific instances of application of estoppel. Section 116 and 117 of the Evidence Act 1872 deals with certain specific instances of the application of estoppel as stated below. Estoppel of tenant and of licensee of person in possession, that is in section 116. Estoppel of tenant and of licensee of person in possession. Section 116 deals with estoppel between 1. A tenant of immovable property and his landlord, and 2. Licensee and licensor. It runs as follows. No tenant of immovable property or person claiming through such tenant shall, during the continuance of tenancy, be permitted to deny that the landlord of such tenant had, at the beginning of tenancy, a title to such immovable property, and no person who came upon any immovable property by the license of the person in possession thereof shall be permitted to deny that such person had a title to such possession at the time when such license was given. A tenant of an immovable property during the continuance of tenancy shall not be permitted to deny the title which his landlord had at the beginning of tenancy. Similarly, any person who came upon any immovable property by the license of the person in possession thereof shall not be permitted to deny that such person had a title at the time of giving the license. License makes an unlawful act lawful. Example, entering another's land with license is no trespass. Now, estoppel of acceptor of bill of exchange, bailee or licensee, that is in section 117. Estoppel of acceptor of bill of exchange, bailee or licensee. Section 117 deals with estoppel between three categories, that is acceptor of a bill of exchange and drawer. The second one, bailee and bailer, and the third one, licensee and licensor. The section facilitates smooth conduct of commercial transaction. So, section 117 facilitates smooth conduct of commercial transactions. It runs as follows. No acceptor of a bill of exchange shall be permitted to deny that the drawer had authority to draw such bill or to endorse it. Nor shall any bailee or licensee be permitted to deny that his bailer or licensor had, at the time when the bailment or license commenced, authority to make such bailment or grant such license. Explanation 1. The acceptor of a bill of exchange may deny the bill was really drawn by the person by whom it purports to have been drawn. Now, explanation 2. If a bailee delivers the goods bailed to a person other than the bailer, he may prove that such person had a right to them as against bailer. Now, promissory estoppel. The rule of promissory estoppel is recognized by courts of equity in England. It is known as requisite estoppel or new estoppel. So, promissory estoppel is also known as requisite estoppel or new estoppel. It does not come within the meaning of Section 115 of Evidence Act. It relates to future promises. Section 115 relates to existing facts, where a person makes a promise to another, thereby induces him to do an act to alter his position. The person promised is estopped from denying the truth of that promise. The concept of promissory estoppel was involved for the first time in India in the case of MP Sugar Mills versus State of UP, AIR 1979. MP Sugar Mills versus State of UP, AIR 1979. In the instant case, the government, through the Chief Secretary, announced categorical assurance for total exemption from sales tax. Basing on this promise, the defendant set up a hydro generation plant by raising huge loan. Later, the government changed its policy and announced the exemption of sales tax at 3%, 2.5%, and 2% for the first, second, and third years respectively. The tax exemption was completely withdrawn later. When the defendant's factory started its production, the Supreme Court held that government is bound by its promise and directed to give exemption to the defendant's company. In another case, Ashok Kumar Maheshwari versus State of UP, AIR 1998. Ashok Kumar Maheshwari versus State of UP, AIR 1998. There was provision for only direct appointment to the post of lecturer in medical college. There was no avenue for promotion from the post of demonstrator to the post of lecturer. Appellants pleaded that the state government had assured that they would be promoted to the post of lecturer. The contention was rejected on the ground that there could be no promissory estoppel against provision of law. Now, burden of proof. The burden of proving estoppel lies upon the party who claims estoppel. He has to prove the ingredients of Section 115 of the Evidence Act for this purpose. So that is with estoppel, and it is discussed under sections 115, 116 and 117 and comes under the chapter 8 of part 3, sections 115, 116 and 117. Lecture 15, Competency and Compellability of Witnesses. Lecture 15, Competency and Compellability of Witnesses. The expression competence of witnesses refers to capacity or ability or qualification to give evidence in the court of law. The expression compellability refers to whether a person may be compelled to give evidence. Some persons may be competent to give evidence, but they cannot be compelled to give evidence. Example, judges, magistrates, etc. Part 3, Chapter 9, containing sections 118 to 134 of the Indian Evidence Act 1872, lay down the provisions relating to competency and compellability of witnesses. Section 118 to 120 defines competency of witnesses, and Section 118 lays down the general rule as to competency of witnesses. So, sections 118 to 120 define competency of witnesses. Section 118 lays down the general rule as to competency of witnesses. It says that all persons shall be competent to testify or give evidence unless they are prevented by the court. Section 119 provides for dumb witnesses. Section 120 deals with parties to civil suit and either wives or husbands, husband or wife of persons under criminal trial. Section 121 lays down that judges or magistrates shall not be compelled to answer any questions or disclose any communication about his or her conduct or character. Section 122 to 132 provide for privileged communications. Section 122 deals with communications. Section 123 deals with evidence as to the affair of the state. Section 124 deals with official communications. Section 125 deals with information as to the commission of offences, that is FIR. Now, Section 126 deals with professional communications. Section 127 extends the provisions of Section 126 to interpreters, clerks or servants of barristers, pleaders, attorneys and vakils not to disclose confidential documents belonging to the clients. Section 128 provides for privilege not waived by volunteering evidence. Section 129 deals with confidential communications with legal advisors. Section 130 speaks about production of title deeds of witnesses, not a party. Section 131 deals with production of documents or electronic records, which another person having possession could refuse to produce. Section 132 relates to witness not excused from answering on the ground that answer will criminate. Finally, Section 133 deals with accomplice witness and Section 134 provides for number of witnesses. Now, witnesses and documents are the main sources of evidence. Evidence given by witnesses is called oral evidence, while the evidence produced through documents is called documentary evidence. So, while the evidence produced through documents is called documentary evidence and evidence given by witness is called oral evidence. Generally, every person is competent to testify or give evidence unless the court considers him not competent. In certain cases, the witnesses are privileged. In some cases, the witness has a right to refuse to give evidence. Some officials, like judges and magistrates, by virtue of the position held by them, cannot be compelled to give evidence. Now, competency and compellability of witness. They can be considered in three cases or three scenarios. Now, who may testify? Section 118. Tender years or child witness. Now, dumb witness, judges and magistrate. Now, privileged communications discussed under Section 122 to Section 132. That includes communication during marriage under Section 122, evidence as to affair of state, Section 123, official communications, Section 124, information as to commission of offences, Section 125, and professional communication, Section 126. Now, we discussed about competency and compellability of witnesses, privileged communication. Then the third category, accomplice witness, that is discussed in Section 133, and number of witnesses in Section 134. So, first we will look into competency of witnesses. So, competency of witnesses means capacity or ability or qualification to give evidence in a court of law. Section 118 to 120 define competency of witnesses. Who may testify? That is given in Section 118. Section 118 provides for the general rule that who may testify. Section 118 says that all persons shall be competent to testify or give evidence unless the court considers them not competent. It runs as follows. All persons shall be competent to testify unless the court considers that they are prevented from understanding the questions put to them or from giving rational answers to the questions by tender years, extreme old age, disease, whether of body or mind, or any other cause of same kind. Now, explanation. A lunatic is not competent to testify unless he is prevented by his lunacy from understanding. A lunatic is not incompetent to testify unless he is prevented by his lunacy from understanding the questions put to him and giving a rational answer to them. However, certain persons are regarded not competent to testify or give evidence. Example, child witness, insane, etc. Now, with respect to child witness or tender years, the question is whether the evidence given by a child witness is admissible. A child of tender age may be allowed to testify or give evidence if the court is satisfied that he has capacity to understand the question put to him and gives rational answers to those questions. In Evidence Act 1872 prescribes no age limit as to the competence of giving evidence. Even a child of 3 or 4 years old is competent to give evidence provided he is competent to give rational answers to the question put to him. A child witness below the age of 12 years need not administer oath before giving evidence, since he is ignorant of the moral significance of the oath. The court entertains the evidence given by the child witness. Conduct a test known as voir-dire test. Voir-dire test by putting certain questions unconnected with the case, like what is your name, your father's name, where are you residing, etc. If the child gives rational answers to such questions, the court satisfies that the child is competent witness and allow to put questions to the child pertaining to the case. Thus, the evidence given by a child witness is admissible in evidence. Now, value of child evidence. Child witnesses are the most dangerous witnesses. Due to tender age, they often mistake dreams for reality. Children are capable of cramming things easily and reproducing them. Hence, it is unsafe to rely on uncorroborated testimony of a child. Evidence given by child should be scrutinized with care and caution. The next, witness unable to communicate verbally. That is discussed in section 119. Witness unable to communicate verbally. A deaf and dumb witness cannot speak and understand the question put to him. Earlier, it was thought that deaf and dumb persons are regarded as idiots and were not competent to give evidence. However, modern science reveals that deaf and dumb persons are much more intelligent than any other normal person and are competent to give evidence. Thus, a person by reasons of dumbness or otherwise is unable to speak may give evidence by any means, such as by writing or by signs. Section 119 of the Indian Evidence Act 1872 deals with the witness unable to communicate verbally. It runs as follows. A witness who is unable to speak may give his evidence in any other manner in which he can make it intelligible, as by writing or by signs. But such writing must be written, and the signs made in open court, evidence so given shall be deemed to be oral evidence, provided that if the witness is unable to communicate verbally, the court shall take the assistance of an interpreter or a special educator in recording the statement, and such statement shall be videographed. According to section 119 of the Evidence Act, evidence given by deaf and dumb persons by means of gestures or signs or in writing are admissible. Such gestures or signs or writing must be made in the open court before the judge in the manner which he can make it intelligible. Evidence so given by the deaf and dumb person is deemed to be oral evidence and is admissible. Evidence so given by the deaf and dumb person is deemed to be oral evidence and is admissible. Section 119 also applies to those who can speak but do not speak. Evidence given by such persons by means of writing or signs is admissible. Now, we have judges and magistrates. They are discussed under section 121. Section 121 of the Indian Evidence Act 1872 confers privilege on judges or magistrates that they cannot be compelled except upon special order of a higher court to give evidence about his conduct in relation to a case tried by him nor can be made to depose anything which he came to know as a court in course of trial. Section 121 runs as follows. No judge or magistrate shall, except upon the special order of some court to which he is subordinate, be compelled to answer any question as to his own conduct in court as such judge or magistrate, or as to anything which came to his knowledge in court as such judge or magistrate, but he may be examined as to other matters which occurred in his presence while he was so acting. Illustrations. Illustration A. A, on his trial before the Court of Sessions, says that a deposition was improperly taken by B, the magistrate. B cannot be compelled to answer question as to this, except upon the special order of superior court. Now, illustration B. A is accused before the Court of Sessions of having given false evidence before B, a magistrate. B cannot be asked what A said except upon the special order of the superior court. Illustration C. A is accused before the Court of Sessions of attempting to murder a police officer while on his trial before B, a sessions judge. B may be examined as to what occurred. It must be borne in mind that privilege given by Section 121 is meant only for witnesses. In simple words, a judge or magistrate cannot be compelled to answer any question about his conduct or character. Statements made by them in the course of judicial proceedings enjoy absolute privilege. Now, the second category is privileged communications, that is dealt in sections 122 to 132. Privileged communication, that is dealt under section 122 to section 132. Section 122 to section 132 of Indian Evidence Act 1872 provide for privileged communications. The expression privilege means a peculiar advantage or some special benefit conferred by virtue of sex or one's position. There are certain circumstances or occasions in which a person is free to express his views or publish any statement without any fear of being subjected to civil or criminal liability. In other words, such persons are immune from liability or privilege. In simple words, privilege means a qualified advantage. There are certain circumstances in which certain persons are not compelled to testify or give evidence. Any statement made by such person is said to be a privileged communication. Following are the instances of such privileged communication. 1. Communication during marriage, that is section 122. The second one, evidence as to affairs of state, that is section 123. Third one, official communications, that is section 124. The fourth one, information as to commission of offences, that is section 125. And the fifth one, professional communications, that is section 126. So the first category under privileged communications, that is communication during marriage, section 122. According to section 122 of Evidence Act, whatever is communicated between husband and wife cannot be admitted as evidence. Therefore, a wife or husband cannot be compelled to answer any question or disclose any communication made to him or her during marriage, except in suits between them and proceedings in which one spouse is prosecuted for committing a crime against the other. Section 122 lays down that communication between husband and wife is absolutely privileged. It runs as follows. No person who is or has been married shall be compelled to disclose any communication made to him during marriage by any person to whom he is or has been married, nor shall he be permitted to disclose any such communication unless the person who made it or his representative in interest consents, except in suits between married persons or proceedings in which one married person is prosecuted for any crime committed against the other. The objects of section 122 is to ensure peaceful matrimonial life and mutual confidence between the married couple. Suppose the husband makes confession to his wife that he has committed a murder of a person or he has committed a dacoity. The wife to whom the confession is made cannot be called to the court and compelled to give evidence against her husband. It is to be noted that privilege under section 122 is applicable to communications, not to acts or conduct. Now, the relevant case law, that is T.J. Ponnan versus Mac Verghese, AIR 1970. T.J. Ponnan versus Mac Verghese, AIR 1970. The defendant, that is the husband of the plaintiff's daughter, addressed a letter containing defamatory matter to his wife about her father. Plaintiff noted the defamatory contents through his daughter in an action by the plaintiff against his son-in-law, the defendant. The Kerala High Court held that the suit was not actionable. But the Supreme Court reversed the above decision on the ground that if the communication between husband and wife have fallen into the hands of a third person, they can be proved in any other way. Now another case, that is Thiekar versus Richardson. Thiekar versus Richardson, 1962. The defendant addressed a letter to the plaintiff alleging that she was a prostitute and a brothel keeper. The letter was sent in all probabilities that plaintiff's husband would read the same. The defendant was held liable. Now, the second category under privileged communication is evidence as to affairs of state, that is discussed under section 123. According to section 123, no one shall be permitted to give evidence from unpublished official records relating to state affairs. Such disclosure affects the public interest. Section 123 reads as follows. No one shall be permitted to give any evidence derived from the unpublished official records relating to any affairs of the state, except with the permission of the officer at the head of the department concerned, who shall give or withhold such permission as he thinks fit. The expression affairs of state has not been defined in Evidence Act. Every communication which proceeds from one officer of the state to another is not necessarily relating to affairs of state. The expression covers only matters of public nature in which state is concerned. It is not limited to matters of political or administrative character, but also sometimes include matters relating to trading, commercial or contractual activities of the state. Now, the third category under privileged communication is official communication, that is discussed under section 124. According to section 124, no public officer shall be compelled to disclose any communication made to him in official confidence. According to section 124, no public officer shall be compelled to disclose any communication made to him in official confidence. It runs as follows. No public officer shall be compelled to disclose communications made to him in official confidence when he considers that the public interest would suffer by the disclosure. Now, the fourth category under privileged communication is information as to commission of offences, that is section 125. According to section 125, no magistrate or police officer is compelled to say when he got any information as to commission of an offence. Such privilege extends to revenue officer also in case of an offence against public revenue. Section 125 runs as follows. No magistrate or police officer shall be compelled to say when he got any information as to the commission of any offence, and no revenue officer shall be compelled to say when he got any information as to the commission of any offence against public revenue. Explanation. Revenue officer in this section means any officer employed in or about the business of any branch of the public revenue. Now, the fifth category under privileged communication is professional communication, that is dealt under section 126. According to section 126, no barrister or attorney or pleader or wakil shall be permitted to disclose any communication or secrets of the clients. This privilege continues to exist even after the relationship ends. Section 126 runs as follows. No barrister, attorney, pleader, or vakil shall at any time be permitted, unless with his client's express consent, to disclose any communication made to him in the course and for the purpose of his employment as such barrister, pleader, attorney, or vakil by or on behalf of his client, or to the state the contents or to the state the contents or conditions of any document with which he has become acquainted in the course and for the purpose of his professional employment, or to disclose any advice given by him to his client in the course and for the purpose of such employment, provided that nothing in this section shall protect from disclosure of 1. Any such communication made in furtherance of any illegal purpose. 2. Any fact observed by any barrister, pleader, attorney, or vakil in the course of his employment as such, showing that any crime or fraud has been committed since the commencement of his employment. It is immaterial whether the attention of such barrister, pleader, attorney, or vakil was or was not directed to such fact by or on behalf of his client. Now, explanation to this section. The obligation stated in this section continues after the employment has ceased. Now, illustrations. Illustration A. A client says to B, an attorney, I have committed forgery and I wish you to defend me. As the defense of a man known to be guilty is not a criminal purpose, this communication is protected from disclosure. Illustrations B. A client says to B, an attorney, I wish to obtain possession of property by the use of a forged deed on which I request you to sue. This communication being made in furtherance of a criminal purpose is not protected from disclosure. Illustration C. A, being charged with embezzlement, retains B, an attorney, to defend him. In the course of the proceedings, B observes that an entry has been made in A's account book charging A with the sum said to have been embezzled, which entry was not in the book of the commencement of his employment. This being a fact observed by B in the course of his employment, showing that a fraud has been committed since the commencement of the proceeding, it is not protected from disclosure. Now, the third category under here is accomplice witness. Now, accomplice witness is discussed under section 133. So, section 133 of Indian Evidence Act 1872 deals with accomplice witness. It reads as follows. An accomplice shall be competent witness against an accused person, and a conviction is not illegal merely because it proceeds upon the uncorroborated testimony of an accomplice. When a crime takes place at a secluded place, it is not possible for the police to get sufficient evidence. The police resorts to arrest the suspect, to divulge information by making them to give evidence against his own colleague. Such person who is picked up by the police for extracting information is called accomplice or approver. The word accomplice has not been defined in the Evidence Act. According to judicial decisions, it means guilty associate or partner in commission of a crime, or who in some way or other is connected with the commission of crime. Example, a person giving bribe to a public servant is an accomplice. Now, competence of an accomplice as a witness, that is discussed in section 133. Now, according to section 133, an accomplice is a competent witness against the accused. An accused person can be convicted in the sole testimony of an accomplice. However, it is not to rely on the uncorroborated evidence of an accomplice. Under English law, the evidence of an accomplice against the accused is no evidence at all. That is under English law. Now, kinds or categories of accomplice. An accomplice may come under any one of the following categories. That is, principal offender of first degree or second degree. The second one is accessories before the fact, and the third one accessories after the crime or fact. So the three categories are principal offender of first degree or second degree. The second one is accessories before the fact, and the third one accessories after the crime or fact. Now, principal offender of first degree or second degree. Principal offender of first degree is a person who actually commits a crime, while principal offender of second degree is a person who abets or aids the commission of a crime. Example: A Hindu having wife living attempts to marry another woman. If a Hindu having wife living marries again, it amounts to the offense of bigamy under section 494 IPC. Now B, being aware of the fact that A has a wife living, accepts to marry A. In this example, A is the principal offender in the first degree and B is the principal offender in the second degree. Similarly, A administers poison through B to kill C. A is the principal offender in first degree and B is the principal offender in second degree. Now, the second category of accomplice is accessories before the fact. Those persons who abet or incite the commission of a crime are called accessories before the fact. They do not participate in the commission of crime but make necessary arrangements. A gives financial aid or provide necessary facilities to B to commit murder of C. Here, A is accessory before the fact. Now, the third category of accomplice is accessories after the crime or fact. Accessories after the fact are those who receive or protect or comfort the person who committed the crime. In other words, they help the accused in escaping from punishment. Example: A commits murder of B. If C, knowing that A committed the murder and gives shelter to A, C is called accessory after the crime or fact. In Jagannathan vs. State of Orissa, a driver of a lorry was held guilty of offence as accomplice for transporting food grains contrary to Food Control Act. Now, the last category we discuss here is number of witnesses. That is discussed under section 134. Section 134 of the Indian Evidence Act 1872 declares that no particular number of witnesses shall in any case be required for the proof of any fact. How many witnesses are necessary for the proof of a fact is wholly left to the judgment of the court. The Supreme Court has, in a number of cases, sustained convictions on the basis of the testimony of a sole witness. Section 134 says that it is not the number of witnesses that is important, but the quality and credibility of witnesses that counts. So that is with the competency and compellability of witnesses, and that is discussed under part 3 and chapter 9 from sections 118 to 134, and 118 to 120 discuss about the competency of the witnesses, and 119 to 134 about the approver, the privileged communication, etc. Lecture 16 of the examination of witnesses. So, part 3, chapter 10, containing sections 135 to 166 of the Indian Evidence Act 1872, lays down the provision relating to examination of witnesses. Section 135 provides for the order in which witnesses ought to be produced and examined. Section 136 confers on judge power to decide as to the admissibility of evidence. Section 137 deals with examination in chief and provides for 3 stages of examination. Section 139 deals with cross-examination of a person called to produce a document. Section 140 provides for cross-examination and re-examinations of a witness to character. Section 141 to 143 lay down the provisions relating to leading questions. Section 144 deals with the evidence as to matters in writing. Section 145 relates to cross-examination as to previous statement in writing. Section 146 speaks about the questions lawful in cross-examination. When the witness to be compelled to answer is provided under Section 147. So when witness to be compelled to answer is provided for under Section 147. Section 148 confers on court power to decide when question shall be asked and when witness compelled to answer. Section 149 prescribes question not to be asked without reasonable grounds. Section 150 provides for procedure of court in case of questions being asked without reasonable grounds. Section 151 confers on the court power to forbid indecent and scandalous questions. Section 152 empowers the court to forbid questions intended to insult or annoy. Section 153 deals with the exclusion of evidence to contradict answers to questions testing veracity. Section 154 deals with question by party to his own witness or hostile witness. Section 155 deals with impeaching credit of witnesses. Section 156 deals with questions tending to corroborate evidence of relevant fact admissible. Section 157 deals with former statements of witness may be proved to corroborate later testimony as to same effect. Section 158 deals with what matters may be proved in connection with proved statement relevant under Section 32 or 33. Section 159 to 161 lays down the rules relating to refreshing memory. Section 162 deals with the production of documents. Section 163 deals with giving as evidence of documents called for and produced on notice. Section 164 deals with using as evidence of documents production of which were refused on notice. Section 165 refers on judge powers to put questions or order production, and finally Section 166 speaks about power of jury or assessors to put questions. Once again, a summary is that order of production and examination of witness, Section 135, and examination of witnesses, stages in examination of witnesses is given under Section 137, that is examination in chief, cross-examination and re-examination. Leading questions is discussed from Section 141 to Section 143. Exclusion of evidence is discussed under Section 153. Hostile witness is discussed under Section 154. Impeaching credit of witness is discussed in Section 155. And refreshing memory is discussed from Section 159 to 161. Now, order of production and examination of witnesses. Section 135. Section 135 of Evidence Act provides for the order in which witnesses are to be produced and examined before the court. The order shall be regulated by 1. The law and practice relating to civil and criminal procedure, and 2. In the absence of such law, by discretion of court, the relevant legal provisions are enshrined in Order 18, Order 41 of the CPC, and chapters 18, 19, 20, 21 and 29 of CRPC. Once again, Order 18 and 41 of CPC and chapters 18, 19, 20, 21 and 29 of CRPC. In the absence of such provision, the order is regulated by discretion of the court. Section 135 runs as follows. The order in which witnesses are produced and examined shall be regulated by the law and practice for the time being relating to civil and criminal procedure respectively, and in the absence of any such law, by discretion of the court. Now, examination of witnesses, that is stages in examination of witnesses, that is discussed under Section 137. Stages in the examination of witnesses is of 3, that is examination in chief or chief examination, cross-examination and re-examination. Examination in chief. It means examination of a witness called by the party. If the advocate for the plaintiff introduces witness in support of his case and examines them, it is called examination in chief. Similarly, in case of defendant's side, examination in chief is the first stage. It is a viva voce examination where questions are put to the witness in a chronological order. It is an art which is acquired by experience. In chief examination, no leading question can be put except in certain special cases. Leading question is one which suggests the answer. Only relevant questions should be asked. And the second stage is cross-examination. The examination of a witness by adverse or opposite party is called cross-examination. It must relate to relevant fact. Leading questions may be asked. A witness may be cross-examined as to the previous statement made by him in writing or reduced into writing. Cross-examination is considered as the most powerful weapon. According to Philip Wendell, it is double-edged weapon. If you know how to wield, it helps to cut enemy's neck. Otherwise, it cuts one's own hand. So that are the words of Philip Wendell. It is a double-edged weapon. If you know how to wield, it helps to cut enemy's neck. Otherwise, it cuts one's own hands. When a witness is cross-examined, he may be asked any questions which tends 1. To testify his veracity or correctness, 2. To discover who he is and what is his position, and 3. To shake his character. These questions cannot be asked in examination in chief. Now, re-examination. After cross-examination is over, the party who called the witness feels necessary may once again examine the witness. Re-examination cannot be claimed as a matter of right except with the permission of the court. The purpose of re-examination is to explain any new matters raised in cross-examination, but not to prove any other fact. It refers to matters in cross-examination and new matter with permission of the court only. Leading questions should not be asked in re-examination except in the following cases. 1. If it is not objected by the adverse party, or 2. With the permission of the court, or 3. Already sufficiently proved matter, that is undisputed matter. The other party, the adverse party, may further re-examine the witness. Now, leading questions that is discussed in section 141 to 143. So, leading questions are discussed in sections 141 to 143. Sections 141 to 143 of Chapter 10, Part 3 of Indian Evidence Act 1872 deals with leading questions. Section 141 defines leading questions. Section 142 and 143 prescribes the circumstances under which the leading question may or may not be asked. So, meaning and definition. The expression leading question literally means a question which by itself suggests the answer as expected by the person asked or put the same. Section 141 of the Evidence Act defines the leading question as any question which suggests answer which the person putting the question wishes or expects to receive is called leading question. Bentham defines leading question as a question is a leading one when it indicates to the witness the real or supposed fact which the examiner expects and decides to have confirmed by the answer. For example, is not your name so and so? Do you reside in such a place? Are you not in service of such and such person? Have you not lived with him for so many years? Do you see A enter B's shop and take a watch? So such questions are leading questions. The answer itself is in the question. So this gives an indication to the witness of what the answer should be, or the answer will be in accordance with what is expected by the person who asked it. Now, when leading question must not be asked is discussed in section 142. So, section 141 defines leading question, and when leading question must not be asked is given in section 142. According to section 142, leading questions may not be asked in examination in chief or in re-examination except with the permission of the court. Section 142 reads as follows. Leading question must not, if objected to by the adverse party, be asked in an examination in chief or in a re-examination except with the permission of the court. The court shall permit leading questions as to matters which are introductory or undisputed, or which have, in its opinion, been already sufficiently proved. Objection to leading questions. Objection to leading questions is not that they are illegal, but only that they are unfair. The rule excluding leading questions is intended to prevent unfairness in the conduct of the inquiry. The Act gives absolute discretion to the court to allow or disallow leading questions. Now, when leading questions must be asked, that is section 143. According to section 143 of the Evidence Act, leading questions may be asked in cross-examination. Cross-examination as to previous statement in writing, that is section 145. A witness may be cross-examined as to previous statements made by him in writing or reduced into writing and relevant to matters in question without such writing being shown to him or being proved, but if it is intended to contradict him by the writing, his attention must, before the writing can be proved, be called to those part of it which are to be used for the purpose of contradicting him. Questions lawful in cross-examination, that is section 146. When a witness is cross-examined, he may, in addition to the questions herein before referred to, be asked any question which tend 1. to test his veracity, 2. to discover who he is and what is his position in life, 3. to shake his credit by injuring his character. Although the answer to such questions might tend directly or indirectly to criminate him, or might expose or tend directly or indirectly to expose him to a penalty or forfeiture. So, questions lawful in cross-examination. When a witness is cross-examined, he may, in addition to the questions herein before referred to, be asked any question which tend to 1. test his veracity, 2. to discover who he is and what is his position in life, 3. to shake his credit or by injuring or for injuring his character. Now, provided that in a prosecution for an offence under section 376, section 376A, 376B, 376D, 376C or 376E of IPC, that is different forms of rape, or for attempt to commit any such offence, where the question of consent is an issue, it shall not be permissible to adduce evidence or to put questions in the cross-examination of the victim as to the general immoral character or previous sexual experience of such victim with any person for proving such consent or the quality of the consent. When witness to be compelled to answer, that is discussed in section 147. When witness to be compelled to answer. If any such question relates to a matter relevant to the suit or proceeding, the provisions of section 132 shall apply thereto. Now, exclusion of evidence, that is discussed in section 153. Exclusion of evidence is discussed in section 153. Section 153 deals with exclusion of evidence to contradict answers to questions testing veracity. So, exclusion of evidence to contradict answers to question testing veracity. It runs as follows. When a witness has been asked and has answered any questions which is relevant to the inquiry only insofar as it needs to shake his credit by injuring his character, no evidence shall be given to contradict him. But if he answers falsely, he may afterwards be charged with giving false evidence. Exception 1. If a witness is asked whether he has been previously convicted of any crime and denies it, evidence may be given of his previous conviction. And exception 2. If a witness is asked any question tending to impeach his impartiality and answers it by denying the facts suggested, he may be contradicted. Illustrations. Illustration A. A claims against an underwriter irresisted on the ground of fraud. The claimant is asked whether in a former transaction he had not made a fraudulent claim. He denies it. Evidence is offered to show that he did make such a claim. The evidence is inadmissible. Now, illustration B. A witness is asked whether he was not dismissed from a situation for dishonesty. He denies it. Evidence is offered to show that he was dismissed for dishonesty. This evidence is not admissible. Illustration C. A affirms that on a certain day he saw B at Lahore. A is asked whether he himself was not on that day at Calcutta. He denies it. Evidence is offered to show that A was on that day at Calcutta. The evidence is admissible not as contradicting A on a fact which affects his credit, but as contradicting the alleged fact that B was seen on the day in question in Lahore. In each of these cases, the witness might, if his denial was false, be charged with giving false evidence. Now, illustration D. A is asked whether his family has not had a blood feud with the family of B against whom he gives evidence. He denies it. He may be contradicted on the ground that the question tends to impeach his impartiality. Now, the general rule both under English law and Indian law under section 153 of Evidence Act is that the matters which only go to the credit and which are deemed relevant solely because they go to the credibility of a witness cannot be contradicted by further evidence. Section 153 provides two exceptions to this general rule. A. The section must be constructed strictly, and B. Unless a case comes within the exceptions mentioned in the section, the answers of a witness to question shaking his credit cannot be contradicted. The object of section 153 is to impose some restrictions so as to enable the court to confine to specific and material issues. This was laid down in Chandran vs. State of Kerala 1992. Chandran vs. State of Kerala 1992. It was said that now section 153 provides two exceptions to the general rule. First one, the section must be constructed strictly, and B, unless a case comes within the exceptions mentioned in the section, the answers of a witness to question shaking his credit cannot be contradicted. The object of section 153 is to impose some restrictions so as to enable the court to confine to specific and material issues. The object of section 153 is to impose some restrictions so as to enable the court to confine to specific and material issues that was laid down in Chandran vs. State of Kerala 1992. Another important protection against character assassination is contained in section 153. If a witness has answered a question as to his credit, whatever be his answer, no evidence is allowed to be given to contradict his answer. The court has to find the facts of the case, not the character of a witness, and therefore the inquiry about character need not be prolonged. The matter should end with whatever answer the witness has given. Now, prosecution for giving false evidence. Section 153 says that the answer given by a witness in response to a question intended to shake his credit cannot be contradicted. However, if the answer or evidence given by him is found to be false, he shall be charged and punished under section 193 of Indian Penal Code. Now, hostile witness, that is discussed under section 154. Section 154 of Indian Evidence Act 1872 speaks about hostile witness. Section 154 deals with questions by party to his own witness. Section 154 deals with questions by party to his own witness. It runs as follows. The court may, in its discretion, permit the person who calls a witness to put any questions to him which might be put in cross-examination by adverse party. The word hostile literally means unfriendly. A witness is ordinarily or generally expected to give evidence in favor of the party by whom he is called. But in certain cases, such witnesses may unexpectedly turn hostile and gives evidence or make statement against the interest of the party who has called him. Such witnesses is called hostile witness. He is also known as adverse witness or unfavorable witness. A hostile witness is one who from the manner in which he gives evidence shows that he is not desirous of telling the truth to the court. Where the witness is adverse to the party called him, such party is not entitled as of right to cross-examine the witness. The matter is entirely in the discretion of the court whether to permit the person calling the witness to put any question to him which might be put by the adverse party in cross-examination. Before putting such question, the party must take permission of the court. The concept of hostile witness has been explained by the Supreme Court in Sat Paul versus Delhi Administration, AIR 1976. Sat Paul versus Delhi Administration, AIR 1976. In this case, an officer was charged or tried for taking bribe. A trap was laid by the Anti-Corruption Department. The office of the accused was raided after the bribe money was supposed to have been passed on to him. The evidence of the witness and of the inspector who participated in the trap was rejected on the ground that they were interested in the success of their trap. Two other witnesses, who were supposed to be independent, made contradictory statements, and the prosecution, with the permission of the court, cross-examined them. Then the question of the value of their evidence arose. The court said that a hostile witness is described as one who is not desirous of telling the truth at the instance of the party calling him, and an unfavorable witness is one called by a party to prove a particular fact who fails to prove such fact or proves an opposite fact. The court also remarked that in view of certain nature of expression, the draftsman of Indian Evidence Act has not felt it making necessary that the court shall grant permission to a party to cross-examine his own witnesses. The court laid down that even when a witness is cross-examined by the party who called him, his evidence cannot be treated as washed off from the record altogether. The court can still rely upon the part of the testimony of the witness which inspires confidence and credit. On the facts of the case, however, the court found that credit of the witness was substantially shaken and therefore it was not safe to rely on them. And the next we have impeaching credit of witness, that is under section 155. The court relies upon the evidence given by the witness to arrive at the truth or falsity of the claim or charge in the litigation. Sometimes the witness called by the party turns hostile and it is not safe to rely upon such evidence. Then the parties may be provided with an opportunity to give independent testimony by impeaching the credit of the witness. Section 155 of Indian Evidence Act 1872 deals with impeaching credit of witness. It runs as follows. The credit of a witness may be impeached in the following ways by adverse party or with the consent of the court by the party who calls him. 1. By the evidence of persons who testify that they from their knowledge of the witness believe him to be unworthy of credit. 2. By proof that witness has been bribed or has accepted offer of a bribe or has received any other corrupt inducement to give his evidence. 3. By proof former statements inconsistent with any part of his evidence which is liable to be contradicted. Now, explanation. A witness declaring another witness to be unworthy of credit may not, upon his examination in chief, give reasons for his belief, but he may be asked his reasons in cross examination, and the answers which he give cannot be contradicted, though if they are false, he may afterwards be charged with giving false evidence. Illustrations. Illustration A. A sues B for the price of goods sold and delivered to B. C says that he delivered the goods to B. Evidence is offered to show that on a previous occasion he said that he had not delivered the goods to B. The evidence is admissible. Illustration B. A is indicated for the murder of B. C says that B, when dying, declared that A had given B the wound of which he died. Evidence is offered to show that on a previous occasion C said that the wound was not given by A or in his presence. The evidence is admissible. Now, refreshing memory, that is discussed in section 159 to 161. Refreshing memory, section 159 to 161. Sections 159 to 161 of Indian Evidence Act 1872 lays down the provisions relating to refreshing memory. Section 159 provides for use of material by a witness to refresh his memory. Section 160 provides for testimony of facts stated in a document as mentioned in section 159. Section 161 deals with right of adverse party as to writing used to refresh memory. When a witness is examined by putting certain questions connected to the case, he may not be able to answer or reply promptly as he would not recollect the points. Then the witness is given an opportunity to refresh his memory by referring any writing or document. The refreshing of memory is intended to enable the witness to recollect the exact facts pertaining to the case in the interest of justice. Generally, there is a long gap between the date of incident and commencement of legal proceeding. During this gap, the memory of the witness is likely to fade and it becomes necessary to refresh their memory. Generally, the doctors, police officers, and other professional experts who deal with a number of cases regularly find it difficult to remember the facts unless certain time is given for the purpose. Now, rule of refreshing memory, section 159 to 161. Section 159 to 161 provides for certain rules to enable witnesses to refresh their memory as follows. 1. The witness is permitted to refer his own writing at the time of the transaction. The court does not prescribe any precise time. It may allow even few weeks for the purpose. That is in section 159. 2. The witness is also permitted to refer the writings made by others. He must read such other writing within a prescribed time. That is in section 159. Now, the court permits the witness to refer to a copy of the documents to refresh his memory. The witness must prove it as a true copy of the original. That is also in section 159. Now, the fourth one, an expert may refresh his memory by reference to professional treatise. Now, the fifth one, the witness need to have specific recollection of the facts. That is discussed in section 160. The sixth one, the adverse party has a right to inspect the writing and to cross-examine the witness. That is in section 161. Now, other provisions, that is in section 156. Questions tending to corroborate evidence of relevant fact admissible. Questions tending to corroborate evidence of relevant fact is admissible. That is in section 156. When a witness whom it is intended to corroborate gives evidence of any relevant fact, he may be questioned as to any other circumstances which he observed at or near to the time or place at which such relevant fact occurred, if the court is of the opinion that such circumstances, if proved, would corroborate the testimony of the witness as to relevant fact which he testifies. Illustration. A, an accomplice, gives an account of a robbery in which he took part. He describes various incidents unconnected with the robbery which occurred on his way to and from the place where it is committed. Independent evidence of these facts may be given in order to corroborate his evidence as to the robbery itself. Now, former statement of witness may be proved to corroborate later testimony as to the same fact. That is in section 157. In order to corroborate the testimony of a witness, any former statement made by such witness relating to the same fact at or about the time when the fact took place or before any authority legally competent to investigate the fact may be proved. What matters may be proved in connection with proved statement relevant under section 32 or 33, that is discussed in section 158. What matters may be proved in connection with proved statement relevant under section 32 or 33, that is discussed in section 158. Whenever any statement relevant under section 32 or 33 is proved, all matters may be proved either in order to contradict or to corroborate it, or in order to impeach or confirm the credit of the person by whom it was made, which might have been proved if that person had been called as a witness and had denied upon cross-examination the truth of matter suggested. Now, production of documents, that is discussed in section 162. A witness summoned to produce a document shall, if it is in his possession or power, bring it to the court, notwithstanding any objection which there may be to its production or its admissibility. The validity of any such objection shall be decided on by the court. The court, if it sees fit, may inspect the document unless it refers to matters of state or take other evidence to enable it to determine on its admissibility. Now, translation of documents. If for such purpose it is necessary to cause any document to be translated, the court may, if it thinks fit, direct the translator to keep the contents secret unless the document is to be given in evidence. And if the interpreter disobeys such direction, he shall be held to have committed an offence under section 166 of Indian Penal Code. Now, giving as evidence of documents called for and produced on notice, that is in section 163. Giving as evidence of documents called for and produced on notice, section 163. When a party calls for a document which he has given the other party notice to produce, and such document is produced and inspected by the party calling for its production, he is bound to give it as evidence if the party producing it requires him to do so. Now, using as evidence of document production of which was refused on notice, that is in section 164. Using as evidence of document production of which was refused on notice, section 164. When a party refuses to produce a document which he has had notice to produce, he cannot afterwards use the document as evidence without the consent of other party or the order of the court. Illustration: A sues B on agreement and gives B notice to produce it. At the trial, A calls for the document and B refuses to produce it. A gives secondary evidence of its contents. B seeks to produce the document itself to contradict the secondary evidence given by A, or in order to show that the agreement is not stamped, he cannot do so. Now, judge's power to put questions or order production, that is in section 165. Judge's power to put questions or order production. The judge may, in order to discover or to obtain proper proof of relevant facts, ask any question he pleases in any form at any time of any witness or of the parties about any fact relevant or irrelevant, and may order the production of any document or thing, and neither the parties nor the agents shall be entitled to make any objection to any such question or order, nor without the leave of the court to cross-examine any witness upon any answer given in reply to any such question. So, and provided that the judgment must be based upon facts declared by this act to be relevant and duly proved. Provided also that this section shall not authorize any judge to compel any witness to answer any question or to produce any document which such witness would be entitled to refuse to answer or produce under section 121 to 131, both inclusive, if the question were asked or the documents were called for by the adverse party, nor shall the judge ask any question which it would be improper for any other person to ask under section 148 or 149, nor shall he dispense the primary evidence of any document except in the cases hereinbefore expected. So that is with judges' power to put questions of order production under section 165. And under section 166 we have power of jury or assessors to put questions. In cases tried by jury or with assessors, the jury or assessors may put any question to the witnesses through or by leave of the judge, which the judge himself might put and which he considers proper. So that is with the examination of witnesses, which ranges from, which is the which also includes the stages of examination, and this is discussed in chapter 10 section 135 to 166. Lecture 17 of improper admission and rejection of evidence. Chapter 11 containing section 167 of Indian Evidence Act 1872 deals with improper admission and rejection of evidence. It says, no new trial for improper admission or rejection of evidence, and runs as follows. The improper admission or rejection of evidence shall not be a ground of itself for a new trial or reversal of any decision in any case, if it shall appear to the court before which such objection is raised that, independently of the evidence objected to and admitted, there was sufficient evidence to justify the decision, or that if the rejected evidence had been received, it ought not to have varied the decision. Sometimes improper evidence may happen to be admitted. It means that evidence of irrelevant facts has been admitted. It can also happen that evidence which is relevant and should have been admitted may be rejected. Section 167 of the Evidence Act says that an improper admission or rejection of evidence by itself is not a ground for a new trial or reversal of decision. Reversal or a new trial can be ordered only if it appears that the improperly admitted evidence had been rejected or the improperly rejected evidence had been admitted, then the decision would have been different. Section 167 makes the provision against new trial merely on the technical objection as to improper rejection or admission of evidence. According to section 167, an improper admission or rejection of evidence can be a ground for new trial only in the following cases. 1. In the case of improper admission, if it appears to the court hearing the objection that the decision could not be justified independently of the evidence objected to as improperly admitted. And the second scenario is in case of improper rejection, if the court is of the view that admission of the rejected evidence would have varied the decision. Now, there are some provisions for evidence in other acts too, that is Air Force Act, Army Act, Bankers Book Act, Banking Regulation Act, Bonded Labor System Abolition Act, then Citizenship Act, Customs Act, Drugs and Cosmetics Act. Thus, there are evidence provisions for evidence in other respective statutes too.